एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यति कश्चन एतद्वैता 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 एतद्वैता.
So before we let our speaker speak, let us speak about him for few minutes. So Mr. CANS Shivakumar is a qualified chartered accountant as well as a cost accountant. He completed his chartered accountancy in the year 1996 and became an FCA in 2004. He is also a diploma holder in Information Systems Audit. So he commenced his practice in the year 2001 and he is a fellow member of the Institute of Chartered Accountancy. After graduating in 1995, he started career in the industry as an internal auditor in leather chemical company and elevated to the position of manager accounts there. Subsequent to which he also changed his portfolio and he joined in the group company of a joint venture company with Bayer AG Germany, at which he had wide exposure in all the spheres of the organization. He left in December 2000 to start his own practice and he has since then practiced very well here. And he is a partner in NSK and Associates Chartered Accountants. So he is specializing in labor law and GST compliance. I would request Honorable Member C.A. Sri Raman to come up here to hand over the memento to the Chief Guest. Thank you, sir, Shriram sir. So now we would like to request Mr. N.S. Shivakumar to give an amazing lecture on labor law. Thank you.
Very happy morning in the morning. Good morning all. For the past 25 years, I am in this practice. The first client when I started with the labor law only. Then I specialized in GST, but still I am continuing the same one. First of all, when they gave the topic to me, domestic workers, I was thinking it is coming under labor code because there is a separate chapter under the labor code. I was thinking that, but as labor code has not come, I thought, because they told another topic also called international workers. So they mean domestic workers means Indian employees. So I have proceeded with that under PF Act. So Provident Fund contribution are regulated by EPF Act and Employees Provident Fund Scheme. That Act is applicable all over India. It applies to all establishments employing 20 workers or employees in a factory or other establishment engaged in industry specified in the Schedule 1. So the Schedule 1 gives a lot of industries in which they have given, because when the Act was introduced in 1956, slowly they started adding a few one by one. So ultimately the entire industries, of course almost all the industries have been covered under Schedule 1. And not only that, it is applicable to all the business establishment also. So it makes applicable when the number of employees crosses 20. So how to count the 20 is the test. Not only you have to see the payroll. So on any day, if the number of count is more than 20, then the registration should be obtained. So say for example in payroll it is 16. You are hiring 5 people to do some office work for cleaning in the office. Then the day on which you are the 5 people coming in and you are paying salary for them, automatically that is the date of applicability of the act. So generally these things people will not look into, so they will used to go by payroll only. So employees means uncovers all sort of employees, whether permanent or casual, direct or indirect, including contract employees and even employees at extended establishment. So here one by one, permanent, those who are in payroll. Casual employees means what I told now. Suppose you are hiring for 1 or 2 days also, that count also should also be taken into account for the limit of the 20. And direct and indirect. Direct means, of course, by injecting them in the manufacturing process directly or indirectly through doing some other work also, if you include also, then that count should also be taken. Contract employees means, suppose if you engage any contractor for supply of manpower or carrying out any work in your premises, then that count also be taken into account. One fine example tell, in construction industry generally, of course major builders, they used to do like this. They engage one person and that fellow will bring 10 or 15 employees to the site and they will pay the money to the contractor. He will in turn disperse the salary to the parties. Whether these employees, that is the 10 people brought in by that contractor, should also be taken into account or not is a major question. Generally every builder faces this. In my view, those should also be taken into account because the site where it is being carried out is a place of business for the contractor. So those should also be taken into account. But how to come out of the problem is, generally the work given to that party, they used to give on a square feet basis. Suppose if you pay on per day basis, then there is no doubt straight away they can charge. But if you give in terms of a square feet, then he becomes an independent employer responsible for the work. For example, suppose 10th one wall they used to do, say 100 square feet they have to run. For per square feet, if you fix a rate of 400, you will pay 104,000 to him, then in turn he will disperse to them, means then there is a little bit scope of coming out of the PF issue. And one more thing is, if he undertakes similar work for other contractors also, then you are well safe. That can be proved by seeing the 26 As of the concerned contractors. Generally, when PF people come, they used to ask this, whether he is doing only for you or for others. So that part, whenever you engage a contractor, ensure that he is very cooperative with you in terms of giving his personal records also to you, so that you will be safe while presenting to the PF department. What is extended establishment? Generally, people used to do that to circumvent this PF liability. They create a separate entity and some other place. They used to do part of the process in the other place, whereby the number of count will be taken into separately in that establishment. So when PF people comes, they used to try to club these two organizations in one head. So extended establishment means, here refers to a unit even owned by others. If carries out any work through a contract carried out exclusively for the establishment. Exclusivity is very, very important here. Suppose he do the works only for the establishment, then they can easily club both the establishment and see the count by taking that also into account. The onus of disproving such exclusivity falls with the establishment. So that's why I said you have to get the 26 A's of the contractors. As per section 6 of the PF rate, as per 6, the PF rate is 10%. Generally, when you read the law, they used to say that it is mentioned as 10%, why it is not 12%. But under PF scheme, it is mentioned as 12% as notified by the Government of India. For coverage purpose, the limit of 20 employees shall be checked as on any day of the year. However, an organization with less than the limit can also apply voluntarily with the consent of all the employees, subject to approval of the regional provision. Suppose you want to do give the benefit to the employees voluntarily, even though the number of count is less than that also, you can do that, but it should be consented by all the employees. Why? Because you are going to deduct a part of the salary from the salary, monthly pay. So definitely the take home will come down. So at that time there may be some objection from them. there is a case that the concerned employee also applied to the PF commissioner to reject the application. So that is the reason when the making the application itself, the consent of all the employees should be obtained when the number of count has not reached the limit of 20. Once made applicable, then it continuously applies even the count comes below the limit. Suppose you are applying on the date of application, it is 21. Thereafter 4 people left. The limit has come down. Then also it is continuously applicable. It is not like ESI. Suppose if ESI, once the people left, then the next after 6 months you need not contribute. Whereas here it is not so. Once you get enrolled, then till the employee leaves, you have to continuously contribute even the number of employees comes below the limit of 20. Clubbing of establishment for coverage purpose is a crucial test undertaken by the PF department. Generally they go by the business. What is the nature of business they are doing, how many establishment they have separately, whether possibility of clubbing is there. They used to think like that. For example, a person may be having a hotel generally. So hotel name is say Muruga Bhavan. So Muruga Bhavan may be having a hotel restaurant at Mylapore, under the same name brand they may be having at Tinagar also. Suppose here the number of employees are say 12. With the 12 you cannot run, but still I am saying small hotel, let us assume. So 12. In Tinagar they are employing an employee for another 15. So if you see the independent, the PF is not applicable. Whereas if the owners are same, say proprietorship concern, owners are same, then there is a possibility of clubbing, because but for evading the PF, you have diverted into 2 separate entity. They may say, even if you have a Tina restaurant in the relative name also, close relative also, they have power to club the establishment, because if the case is taken to the court, generally courts are pro-employee only. But what I suggest is generally you go by private limited company, because even the shareholders patterns are little bit changed, then it is not very tough to club. When it is a proprietorship concern, there will be only one PAN number. Even partnership also, family members will be there. So there is a possibility of clubbing is there in these 2 types of entity, whereas in case of private limited company, being a separate legal entity, that too owned by different structure of owners, we can easily come out of the issue. If the establishments are in the same premises having different ownership, and if the intention is to avoid PF, then there is a wide chance to come under the clubbing provision. What I told you, so in the same premises, even if you do different nature of business also, but owners are same, means then there is a possibility of clubbing, because PF is on the employer only, not for the business done by them. So that is the reason when they are clubbing together, these issues will come. So EPF Act is a Social Security Act providing savings for the employees and pension for their retirement. Hence, the court and department generally considers the disputes in the pro-employee approach only. I will tell you on next slide, there is a Supreme Court judgment. PF applicability need to be seen on count basis, but PF contribution are to be made for those employees whose basic salary is less than 15,000 rupees. So in a company, when you see whether it is applicable or not, the count should be taken into account excluded employees also. Excluded employee means those who are earning more than 15,000. Suppose when the salary is less than all the employees are more than 15,000, but there is no employees with less than 15,000, means also you are bound to take a registration being the number of employees are more than 20, whereas contribution will be null, but we are bound to contribute the administration charges. Okay, but contribution for only for those employees until less than 15,000 should be only be applicable to the employer. Some case laws. When 2 units have 2 different line of business and one was not dependent on the other, could exist even if the other closed down and admittedly they had separate tax registration, income tax registration under the labor law, they should be treated as 2 separate entities. So there should be lot of tests you have to see, like separate GST registration number, labor law registration, income tax registration. So that is the reason I said you have to have different type of ownership in the industry, I mean in the entity, like separate companies with a different shareholding pattern like that. Otherwise there is a much possibility of merging it. When both the units have common partners, common nature of business with the common financial department, then Union of International Integrity, it is considered as the one establishment. So there are two partnership firms in which common partners are there. Even the management as well as finance departments are the same, means then there is a possibility of merging it. A subsidiary company generally a separate legal entity from the holding company. So a subsidiary company will not be a branch or department of a holding company, thus it is not liable to default of the subsidiary companies for the PF dues. Two schools, this is very very important school. Two schools run by the same management, catering to nursery classes and the other secondary classes constitute one single establishment. So generally it is run by that generally by the trust. I have another case law. So trust, generally they used to run education establishment. So in education establishment, in one establishment it is less than 20, in another one it is 20, means also we have to both see together to see the applicability of the PF Act. The units cannot be clubbed together based on the common ownership unless there is a financial and functional entirety. This is another case giving a different approach, but still in each and every case we have to see the nature of common integrity. So when possibilities there or not, we have to generally go after seeing the nature of case only we can decide that. But whenever you see same management, means ensure that they are promoting a separate company with a different ownership. If at all, if possible, even one person from the outsider can also be held in that, so that to prove the not in the same management. A new factory established by a company cannot be a branch as per 2A. Suppose a company has 4 factories and they are opening another factory in the another, means then they will be coming under the PF Act will be applicable on that. Commission agents appointed with management to collect milk from the different points are not workmen under the Industrial Dispute, but of course it is coming under the Industrial Dispute Act. But if they are paid salary also and commission, then they will automatically come under the employees definition. The last one is very very important, recently held in 2023 by the Supreme Court. The judgment underscores the importance of functional integrity between the establishment management the same entity for the purpose of coverage under the PEPF Act. The court observed that there is a financial integrity between the society of the appellant as well as the ideal institute, as substantial funds have been advanced by the institute by the society. So a society is running a 2 education institution. The funding, management, everything is done by the society, even though maybe of course each institution may be having a separate CEO. This societies that both the establishment are managed by this society. So that is the reason they said it is applicable for the both the education institutions. So PF contribution. Hitherto we are seeing the clubbing and all. Now it is we have to see the contribution. As per section 6, read with the PF scheme, PF at 12% of basic wages, dearness allowance and retaining allowance provisions are to be contributed to the employer. So 12%, generally we used to say the gross salary, out of which we have to carve a portion towards this basic, HRA and other allowances also. When we contribute, we have to for PF we have to contribute under the basic wages, DA and retaining allowances. Of course, there is a different definition under 2B which will come in later on. An amount equal to the amount of contribution by employer to be contributed by the employee also. So 12% should be deducted from the employee. Similar amount, equal amount should be contributed by the employer along with the administration charges. An employee can at his option can contribute more than the amount contributed by the employer. So suppose on 15,000 employee we are deducting we are contributing 1,800 rupees, so 12%. Suppose if the employee decides to contribute more, say 3,000 rupees, he can ask you to deduct, no problem. You can jolly well deduct 3,000, but you are not bound to contribute equal to 3,000 rupees on the same. But generally company used to contribute because they used to go by the C2C. When they decide the C2C, they will restructure in such a way that employer contribution also taken into account for the purpose of the contribution. So, but in no way employer is obligated to contribute more than 1,000 rupees. That's what I want to stress here. The employees are applicable to all employees whose basic salary wages is less than equal to 15,000 rupees. Earlier it was 6,500 rupees. So the PF contribution should be made only for employees earning less than 15,000 rupees. Suppose a person is having a basic salary of 12,000 rupees. Due to increment, if it crosses 15,000 rupees, say for example, person basic salary 12,000 rupees, you are giving an increment of 6,000 rupees which is added to the basic, then it will cross the 15,000 rupees, but you are restricted to contribute only to the extent of 50,000 rupees. You need not contribute to the extent of 80,000 rupees. So till he leaves the job, you have to contribute till 15,000 rupees. When the resigned employee joins a new company with a higher basic salary, whether the new employers will contribute, there is another question. So because the continuity of membership should be seen from the, not from the company, it should be seen from the membership of the PF Act. So when he joins a new company with a higher basic salary, if he contributes his membership with EPFO, then the new employer is obligated to contribute up to the maximum of 15,000 rupees. Suppose 12,000 rupees now you are paying, due to increment it is more, it has reached 15,000 rupees, on which he is paying 15,000 PF on the 15,000 rupees. When he joins a new company, even the basic salary is more than 15,000 rupees, you are obligated to contribute to the extent of 15,000 rupees, even though the basic salary is more than the limit of 15,000 rupees. Section 2B defines basic salary means all emoluments which are earned by an employee while on duty. While on duty is very, very important, and on leave or holidays, with the wages in either case in accordance with the terms of contract of employment, and which are paid or payable in cash to him, but does not include cash value of the food concession, any dearness allowance. This is a confusing point. In the definition of 2B, they are excluding dearness allowances, house rent allowances, overtime allowances, bonus, commission. Of course, these house rent allowance, overtime allowances need not be considered because it is specifically not included in the section 6. Whereas in section 6, it specifically covers the dearness allowance. In 2B, it is excluded, whereas in 6, it is included specifically. So there is a lot of confusion whether to take the dearness allowance. It has been well clarified by a Supreme Court judgment. So this is a definition of section 6. So here the contribution which shall be paid by the employer to the funds shall be 10% of the basic wages, dearness allowance and retraining allowances, if any, for the time being payable to each of the employee, whether employed by him directly or through a contractor. So for the purpose of this section, dearness allowance shall be deemed to be also in cash value of food concession allowed by the employee. Okay. Now the confusion is, in section 6 it should be included, in 2B it is need not be included. The contradiction between the 2B and 6 makes a confusion whether DA should be included or not. The test is whether it is paid to all the concerns or by all the concerns in the industry. So why in 2B it is not included is, generally DA is not paid to all the employees. So that's the reason it has been specifically included in the 2B, whereas in section it is included. In bridge roof company, this is one of the cases which decides whether it should be included or not. It seems there is therefore that the basis for the exclusion of class 2 of the exception in 2B is that all that is not earned by the all concerns or by all employees of the concern is excluded from the basic wages. To this exclusion, dearness allowance in 2B, but the exception has been corrected by including the dearness in section 6. So the court has observed that even though it is excluded in 2B, it has been cured by including the same in the section 6. So ultimately what court says is, you have to contribute on the DA also. So when you do a pay structure, ensure that you are including the dearness allowance also to see the limit of 15,000 rupees. Of course, in some concerns it will be benefits also. Say for example, in basic it is 12,000 rupees. In DA it is 6,000 rupees. Adding both together it will cross the 15,000. So PF may not be applicable to that party also. So to decide all these things, it is better you must have a pakka HR policy. Hence, as per section 6, the DA forms part of the basic salary even though it is excluded in the 2B. Some of the observations by the court I have just listed out. Thus understood, basic wage never includes the additional emoluments which some workman may earn on the basis of system of bonus related to the production. The quantum of earning in such bonuses varies from individual to individual according to their efficiency and diligence. It will vary sometimes from season to season with the variation from working condition in the factory and other places where the work is done. It will vary also with variation in the rate of supplies of the raw material and in the assistance obtainable from the machinery. This very element of variation exclude this part of workman evaluation from the connotation of basic wages. So generally in all the industries they used to give the production incentive. So production incentive they used to have depending upon the efficiency of the person. So basic wages is defined as a component which is payable to all the employees whether he performs or not. So it is a minimum guarantee amount. So minimum guaranteed amount payable to the employees should be treated as a basic salary. Whereas in case of production incentive, it depends upon the person to pay, it will vary. But how people from PF department look into this, whether this production incentive has been introduced so as to reduce the basic salary. They used to look into that. So you have to ensure and have pakka record to establish that because of the efficiency of one person he has been paid. So how will you prove that? So you must have the pakka data sheet for the calculation of the production incentive. So that is important. And one more thing is, generally production incentive should not be paid on monthly basis. You have to avoid it. At least once in a quarter, once in a half yearly, once in a year, it is better to pay because the efficiency of one person will vary from one month to 1 month. So 1 month he may not be maybe earning, in next month he will not be earning the incentive. So it is better to have a pakka policy in the HR policy that, a clause in the HR policy that production incentive will be paid on quarterly basis or half yearly basis or yearly basis with the demarking very clearly the how the efficiency will be evaluated. In RFC, Hyderabad and VS industries observed that having regard to the nature of scheme and the bonus payment of amount towards the production incentive for the same one, however, the onus of proving the production incentive falls on the employer. So that's why I said we have to, hence record maintenance and differentiating the efficiency of each worker for payment of incentive are essential to succeed in the such exclusion. Hence it is advisable to give production incentive once in a quarter or half yearly or yearly. Here generally people from the low level they used to expect to receive the money of production incentive on monthly basis. So what I have suggested to my client is, you accumulate the production incentive, release a part of the amount, say 75% on monthly basis as advance, at least their packet will also get filled. So once in a year after reconciling the what is the eligible amount and reduce the advance paid and you pay in a once in a year, because if it is paid on monthly basis I said they may treat that as a component of basic salary also. So but it should be clearly stated in the HR policy. If you achieve a production limit of so and so, 50% advance will be paid. If you receive that level, you will receive 70%. Like that, if you have a pakka policy, then department also cannot question it. Southern Engineering versus RPFC. Special allowance, special HRA, special conveyance allowance being paid only to the handful of employees who could discharge the special duties will not be a basic salary attracting the EPF contribution. So nomenclature, whatever you can give, HRA, special allowance, special duty allowance and dress allowance, like that you can give whatever nomenclature. But ultimately what court says is whether it is applicable to all, then only they will decide. So hence structuring and designing the pay scale plays a vital role in the streamlining the contribution. In another case, Manipal Academy, the Supreme Court has observed that the basic principle as laid down in the Bridge Roof case on a combined reading of section 2B and 6 are as follows. Where the wage is universally, necessarily and ordinarily paid to all across the board, such emoluments are basic wages. So it should be applicable to all the employees necessarily, and ordinarily it should be paid. Whether he performs or not, that should be paid. That is what the ordinarily word catches. So such emoluments should be treated as basic wages. Here recently there is a circular from PF department that if an allowance is paid to all the category, please include that. So at that time I have seen so many companies that they used to park the entire balance amount in the special allowance. So when they come the visit, they used to add the entire special allowance in the basic wages. So it is better to have a pakka grading as well as the pay structure for that. So what I said, generally court have a pro-employee approach only. So in this the daily Parthap, the act it was held that the act was a piece of beneficial social welfare, so must be interpreted as such in favor of employees only, generally. In Vivekananda case, it is therefore not possible to ascertain whether extra amounts are paid to the workmen were in fact paid as extra work which is exceeded the normal output. So it is also production related. So the wage structure and components of salary have been examined the fact, but the authority and appellate authority who have arrived at the factual conclusion that the allowance in question were essentially a part of the basic wages and camouflaged as part of the an allowance so as to avoid the deduction and contribution accordingly to the product fund account of the employees. So in this case they have not properly created the document to show that the production incentives are not forming part of the basic salary. So the court has gone other side of the saying that the production incentives should also be included in the basic wages. So for everything you must have a pakka documentation, very very important. So this is the example I have created I have given to some of the employees also. Generally PF people comes, they see a thumb rule whether basic salary is 70% of the gross amount. If it is less than that, they used to add the balance as a basic salary. So I have structured, applying all the, taking the points of the Supreme Court and all, I have structured this. This I have given to my clients also. So you have to create a grade and you have to bifurcate them into the nature of, the amount of salary also. So wherever the salary is less than 15,000 rupees, ensure that 70% is brought under basic. And rest you can give anything. I safely added in the HRA because in income tax they have to claim, So that's the reason now it is 1 lakh, up to 1 lakh there is no tax. But earlier it was 2.5 lakhs. So I added the balance in the HRA. So next category 15 to 30,000 I have put 60%. So 30% I have added to the HRA, balance in the convenience allowances. And fourth category 30 to 49, like that 50 I have graded like this. So 20, 30, 40, 50, 60, 70. In 70 the condition of the PF department is satisfied for me. Because whenever they come, they first see the lower level whether 70% are paid or not. So if it is 70%, okay, they will blindly accept. Because as I told earlier, when you contribute up to 15,000 rupees, they will not ask you to contribute more than that. So when it crosses 15,000 rupees, they are rest bothered about that what is the percentage you are applying. So from 15 to 60,000, even 60%, 60%, they will not look into that. But the last column, other allowances. So I have structured in such a way that we have to take the benefit of income tax point of view also, like medical expenses, knowledge, petrol. These are all we used to give as advance. Then it will be treated as perquisite for the purpose of income tax. In other allowances, in the 5th and 6th category, I have put 0. Why? Because as per the Supreme Court judgment, if it is universally and ordinarily paid to all the employees, that should be taken as a basic salary. So to avoid that, I have included 0 in the 5th and 6th category. Of course, there is a plan that they are going to increase the limit further to 21,000 rupees in line with the ESI. That is under process. So ultimately what I stress is ensure that up to 15,000 rupees, ask your employer to pay 70% at least. Of course, in labor code it is well safe. They have clearly told that the basic can be 50% enough. Now, but under the old law, it is of course there is nothing mentioned in the PF Act, But as per the internal circular from themselves, they used to insist this 70,000 rupees, 70%. Suppose if it goes to the court also, court will also accept because it is pro-employee. The PF department is more concerned with the lower employee earning less than 15,000 basics. They are not much interested coverage of highly paid employees subject to maximum 15,000 rupees. So even employee contributes, it doesn't bother, it is a voluntary contribution only. The HR structure and policy should address all the legislation such as Minimum Wages Act, adoption of proper price index, maternity benefit, etc. So Minimum Wages Act, there is a confusion in the industry that whether the basic salary for which PF is contributed can be less than the minimum wages. But in my view, there is an internal circular from the PF department also that the basic should be at least equal to minimum wages. So why I am saying that we have to implement in the from the beginning itself is, if they come and find out after 2 or 3 years, employees' contribution also should be paid by you. You cannot legally recover from them. So if you, of course, for the saving a small penny in the year, later on you will be falling in a big dump. So that is the reason whenever you structure, ensure that you are complying at most with the law so that nobody can question you, first of all. That too particularly the lower level employees. As penal damages interests are heavy, we need to advise the employers to cover up all the employees to the maximum extent, as justifying non-applicability of a component of a pay structure would invite long-term legal fight which would eat our precious time as well as money also. Policy of incentivization of production needs proper documentation, and the pay of incentive should be in line with such policy. Any deviation would unnecessarily result in higher contribution in the later date. Generally in leather and small level manufacturing companies, the pay structure will be lesser than of course they used to maintain at least equal to the minimum wages. So for them, so for example, in leather salary is say 9,000 rupees. Production incentive, they will be earning more than that generally. They fix like that so that to avoid the PF component. So if you don't have any proper documentation for that, then the production incentive should also be included in the basic wages so that unnecessarily you are bound to contribute on that part also. So when the demand comes in later date, we cannot recover the employee's contribution particularly, hence it will become an additional burden of cost. So in the day one, if you have proper pay structure as well as recover from them, at least you will save 12%. Later on if you do, then you have to bound to unnecessarily waste that 12% cost also. Contract employees. It covers all sort of employees, permanent, temporary, regularly or seasonal or direct, indirect. So as per the employee definition, it covers all sort of employees. He must have been employed and paid salary directly or indirectly or through a contractor. Here, contract employees are well covered under the PF Act. The possibility of applicability on such contract employees are certain if they work on a company's premises. Under this, the company becomes principal employer. Hence, the law being social security having pro-employee approach ensures to cover such employees under the PF law. Generally, when PF first they see who are all the securities employed. Generally, housekeepers, housekeeping employees as well as security employees, we used to outsource from the contractor only. As they are working in the premises, in our premises, you will become a principal employer. Generally, these contract employee suppliers, they don't maintain the records properly. They used to have say 50 employees in their payroll, but they will be having a manpower limit of say 500 also. So that is the reason I insist every client to ensure that whenever such contract employees are coming in, all the PF card and ESI card you must have. Otherwise, in later on, if the department come and verify that the employees are not held out, then ultimately it will fall, the liability will fall on your head. So for contract employees, when you are employing, there is a act called Contract Labor Regulation Act. Under that, you have to maintain some records. Particularly, they insist that the payment of contract employees, the payment should be paid to the contract employer. In turn, the principal employer should ensure that the disbursements of salary are done in time. That's what the object of the law. So the principal employer should also take a registration under the CLRA. The principal employer should ensure to disperse the salary in time to contract employees, and in turn ensure that the contract disperse the same to the contract employees and the migrant employees. And there is another called building and other construction workers. In construction industry, they have to comply on that. These schemes are introduced so as to encourage the employer to induct the new employees. Generally in Tamil Nadu, there are a lot of migrant employees from North India only. So, as earlier I said, it's a contract employee, they used to cover the migrant employee also. There is a separate act called Migrant Employees Regulation Act. Under that also, there are some obligations. We have to maintain the records. We have to intimate to the concerned labor officer about the employment of migrant employees. Under this PMRPY, ABRY and PMGKY schemes, the PMRPY means Pradhan Mantri Rozgar Prasadhan Yojana. It was launched in the month of August 26 and it get entered in March 2026. Here the benefit is 12% employer contribution will be paid by reimbursed by the government. So if you in your payroll you have to ensure that there are new employees. These are mainly applicable to the new employees. So after uploading the paying the employer contribution, it can be reimbursed by the PF department. Condition of eligibility is first time employment in the PF. So they used to, after introduction of Aadhaar, there is a conclusive evidence. So if you put the Aadhaar number in all over India, wherever you employ, it will clearly tell. So it should be first enrolled. The system will use to check. In ABRY, it was launched in the month of October 2020, and it was extended to March 2022. Both 12% of the employer as well as employee as well as employer contribution are reimbursed. First time employees are eligible for that, and that too it is only applicable to employees with less than 15,000 basic salary. In PMGKY, that was mainly for COVID period they introduced. So March 2020 they introduced, it was lasted till August 2020. Both 12% of the base employer as well as employee contribution they were paying. But the condition is the establishment having less than 100 employees, which is 90% or less than 15K should be employed. Say for example the company is having 90 employees. Out of which 90% employees must be earning less than 15,000 basic salary. But these are generally many of leather companies they have availed this scheme. Now, employer-employee relationship, how to establish? But suppose a person walks in, whether he should be treated as employee for the purpose of PF Act. There are some testers there. So employee means any person who is employed for wages. So he must be employed for wages. You are sending many chartered accountants, they used to send article clerk to the employer office. Suppose PF inspector comes. Can he treat those employees as for the purpose of PF? Because they cannot be included because they are not employed for wages. So for wages in any kind of work, manual or otherwise, in or in connection with the work of an establishment, or who gets his wages directly or indirectly from the employer, and includes any person employed by or through a contractor in or in connection with the work of the establishment, engaged as an apprentice, not being an apprentice, engaged under the Apprentice Act. So if you have any apprentice under the applicable under the Apprentice Act, you may not beg for this. You have to go to the Labour Commission and get the approval from them. But why apprentices are excluded means they are taken for the training purpose only. They will not execute any production related work. They will be trained to do the work. So they cannot be treated as workers. And another one terminology is excluded employee means an employee who, having been a member of the fund, withdrew full amount of his accumulation in the fund under class A and C of the subparagraph para 69. An employee whose pay at the time of he is otherwise entitled to become a member of the fund exceeds rupees 15,000 per month. So here the first point is, suppose a person has joined, he worked for some period, say 10 years he worked out. Then he applied to the PF department and he withdrew the entire money. Suppose he joins in another company, whether he is eligible for PF or not. He is not eligible because once he withdraws the full amount, he becomes an excluded employee, he cannot even. But if the employer wanted to pay and his salary is less than 50,000 rupees, he can voluntarily add him as an employee. So generally when you are taking a person, if it is more than 50,000 rupees, you do not contribute unless he is a member already in the EPF organization. Suppose he is already a member in the EPF organization, you are bound to contribute up to 15,000 rupees, even though if his basic salary exceeds 50,000 rupees. Exempted employee means an employee to whom the scheme of the insurance scheme, but the exemption granted 17. Suppose some establishment they used to apply for the exemption purpose. For example, under PF law, the employer can register with the under the PF Act. Whereas, suppose the benefit given by the employer to various employees are better than the benefit given by the EPF organization, means then they can form a separate trust or some NGO, non-profit organization, so as to manage this fund. So the employer will contribute the entire money to the organization, so that they will manage the entire entire balance held by them for the purpose of the disbursement of the provident fund. Under this case, an employee of a railway, he was working with the railway and he resigned and he took the money from the GPFO. GPFO means general provident fund maintained by the, because EPF is applicable only for the private sector employees. For public sector as well as government employees, they are maintaining under the GPFO. So Indian Provident Fund Act is applicable for them. So in this case, a railway employee, he withdrew the money from his GPF account and he joined a contractor, who is doing his work for the railway department. So he has approached the court that the benefit under EPF Act should also be given to me. Whether he falls under this excluded employee is a question raised before the court. So under this, an employee who having a member of the fund withdrew the full amount of his accumulation in the fund, and so here the fund is not defined. Whether fund means under this or GPFO is a question. So the court says that if GPFO, if he already withdraw the fund from the GPFO retirement benefit scheme, means then he cannot, the approach of the employer is he is not eligible under the EPFO also. But the court said that even though he has been with the GPFO and withdraw the money, he is eligible under the provident fund maintained under the EPFO also. Why? Because the court has said that here the fund refers to the fund maintained under this act. So even though he was a member under the GPFO, it is irrelevant for the purpose of enrolling him in the EPFO. So the court ultimately held that he is eligible and he should be taken as an employee under the EPF organization. Employees, some legal observation I have listed. Separate balance sheet cannot be pressed as a proof of functional independence more than when there are common supervisory and management control. So when the management control is same, then all the employees should be clubbed, as I already told. When 5 partners were drawing wages and the same was shown in the balance sheet, in addition to 16 employees, the establishment were covered under the EPFO Act. So in case generally in partnership, we used to pay salary to the partners. So for the purpose of coverage, the partners should also be taken into account for the purpose of applicability of the PF Act. Any person employed in connection with the work of an establishment is an employee of the PF Act. A person having control over the affairs of the establishment is an employer. It is immaterial whether he has control or supervision over the functionality of the employees. So here, in case of companies, it is better. In case of company, a managing director should also be treated as an employee. That's what ultimately decided. Trainees are not employees under the EPF Act, so contribution is not payable under the in respect of them. But now unless you get the approval from the Labour Commissioner, you cannot exclude them from the such apprentices from the PF applicability. Whatever the even stipend if you pay, that is applicable. That's applicable. Two schools run by the same management, catering and nursery class. I think I already told this. The employees who have been appointed as learners cannot be set as other than apprentice in view of the standing orders. So there are apprentices under the Apprentices Act and not covered under the EPF Act. Generally, if you don't have any HR policies, it is advisable to have a standing orders duly vouched by the Labour Commissioner. So standing orders are nothing but a HR policy designed by them, and whatever the wanted to adapt, you can clearly spell out and get the approval of the Labour Commissioner. In that, one of the thing is you can specifically have a clause that I suppose 10% of my labour force will be through a trainees only. So for them, I used to pay stipend of so on. So if you clearly list out, if they approve, then they cannot be taken for the purpose of PF, applicability of PF. When trainees are recruited as per standing orders and imparted training as per the scheme framed by the, they are not employees under the PF Act. This is one of the important case. It is held that employees drawing salary and wages inclusive of DA more than 50,000 per month are not covered under PF Act. Such type of employees are exempted from making PF contribution on amount higher than 15,000 by proviso of para 26A of the EPF Act. So as I already told, when a person is more than 15,000 rupees, they need not be covered. Even if they wanted to include, for them, if they wish to contribute, that can be done only with the consent of the employees. Who are all covered? Section 26 of the PF scheme says all employees other than excluded employees to which this PF scheme applies should become of the members of the PF establishment, or the employer and employees relationship is essential applicability of PF provisions. A chartered accountant is doing an internal audit. Every month he used to go and do the internal audit, whether he can be included or not. He need not, because he is not doing for wages. Okay. All employees drawing a basic salary of 15,000 or less are mandatorily covered. Employees are of casual or piece rated employees or seasoned employees are also covered if their monthly basic salary is within the above limit. Here, the casual and piece rated employees and seasoned employees should be evaluated. Generally, the casual employees, they in a month we used to hire them for say 7 days or 8 days. So how to compute the applicability of PF to them? So we have to see the average rate of wages earned by them. Say for example, for 8 days they came, 4,000 rupees we have paid. So average salary is 500. So 500 into 30, you have to apply 15,000 rupees. So automatically PF is applicable. So this plays a vital role in construction industry. Construction industry, as I already told, many works are carried out by the contractors. Contractors in turn, they will have their own employees. They used to pay on per day basis only. So in that, you have to ensure that the ultimate employees for whom that contract is paying, his salary, per day salary is more than the limit, say 500 or 600. If it is say safely 1,000 rupees means it is good. You not bother. They used to put lesser amount, say 300 if they put, then automatically for 30 days comes to 9,000 rupees, automatically PF is applicably. That contract will run away because he is being individual, it will run away, but it ultimately falls on the head of the builder only. Okay. Employees employing through contractor are also covered under the PF Act. The employer is not obligated to contribute more than the basic of 15,000 rupees. Employee can contribute on wages beyond 50,000 rupees, known as VPF, subject condition of the employer to contribute on the administration charges payable. Suppose up to 15,000 rupees your employer is contributing. More than 15,000 rupees, suppose he is willing to pay, you need not give consent for that, because the 1% admin charges is levied on that, on their contribution also. So that cannot be recovered from them, you have to contribute. So if the employer is ready to bear the cost of the admin charges, then you can give consent to them. See, this is because of course now it is up to 1 lakh. When it is 2.5 lakhs, they don't have any personal commitment. People used to contribute everything to the PF, so that they will get assured return of say 8.5%, and that too it's government, so they can save with the money also. There is one case law. An employee drawing wage above 5,000 is an excluded employee. Of course, at that time it was 5,000 rupees when the dispute was going on. Excluded employee under the PPF Act. The question of there being any compulsion under the law to pay contribution 12,000 over and above the monthly salary of 5,000 cannot arise. So in PF inspection, people used to say, sir, avanga employee katrangana, then you are also bound to. It is not so. So you have to clearly say the section 26 of the PF scheme. It is very clearly mentioned in that also. Any doubts if you can raise? I think I am alone speaking.
The previous slide you said that there are 5 partners and 16 employees. But partners and partnership firm are one and the same in all.
Under the income tax law, I know, but for the purpose of PF it is should be clubbed. Why? Because as I said, it is a pro-employee approach only. ஸோ உங்களுக்கு தானே வந்தோடனே என்ன சொல்லுவான், பைசா உங்களுக்கு தானே சார் வருது, நீங்கள் கட்டுறதுக்கு என்ன இருக்குன்னு கேட்பாங்க. பட் அப்ளிகபிலிட்டி பார்க்குறப்போ நீங்கள் வந்து இட் இஸ் பெட்டர் டு இன்க்ளூட் தட் ஆல்சோ. வெதர் இஃப் இட் இஸ் மோர் தேன் 15,000, சப்போஸ் யூ ஆர் ட்ராயிங் a salary of more than 15,000 rupees, they will not bother. But applicability purpose they will include. Timeline. The employer need to apply registration when the number of employees crosses 20. ஜென்ரலாகவே இதில் வந்து நம்ம விட்டுருவோம். காரணம் என்னென்னா, எல்லா எம்ப்ளாயும் கரெக்டாக பேரோவில் 20 வச்சு வந்தோம்னா நம்ம கொண்டு வந்து கொடுப்போம். நாங்கள் எல்லாத்தையும் பார்ப்போம். இப்போ இதெல்லாம் விட்டுறேன், நான் தனியாக நான் என்ன பண்ணுறேன்னு பேசிடுறேன். ஓகே, ஸோ பேரோல் கொடுப்பாங்க. பேரோல் பார்த்தோன்னா 20 நம்ம எடுத்து உடனே கொண்டு போய் அப்ளை பண்ணக்கூடாது. நம்ம வந்து ஒரு அட்லீஸ்ட் ஒரு 5 வருஷத்தோட அக்கௌண்ட்ஸாவது பார்க்கணும். அஃப்கோர்ஸ் அதுக்கு முன்னாடி அதுக்கடுத்து ஆரம்பிச்சிருக்கான்னு இல்லை. ரொம்ப ஓல்டு கம்பெனினா கண்டிப்பாக ஓல்டு கம்பெனினா பயங்கர பாசிபிலிட்டி இருக்குது. பேரோல் 20னா உடனே 10லேருந்து 20 ஆகாது. அது கிராஜுவலாக இன்க்ரீஸ் ஆகி 10, 11, 12, 15, 17, அப்புறம் 18, 19, 20 வந்தவொடனே தான் நம்மகிட்டே வருவாங்க. ஸோ நீங்கள் வந்து மெயினாக பார்க்க வேண்டிய ஹெட்டு ரிப்பேர்ஸ் அண்ட் மெயின்டெனன்ஸ் ஃபஸ்ட்டு பார்க்கணும். ரிப்பேர்ஸ் அண்ட் மெயின்டெனன்ஸில் எங்கேயாவது இடத்துல ஸ்வீப்பர் வி பெய்டு சேலரின்னு இருக்கும். இல்லைன்னா வந்து பெயிண்ட் அடிக்க உள்ளே வந்தான், இது வருஷத்துக்கு கூட ஏதாவது பெயிண்ட் அடிப்பாங்க ஆஃபீஸ்க்கு. ஸோ ஒரு 10 பேர் வந்து ஒர்க் பண்ணான்னா அது போதும். ஸோ அப்ளிகபிலிட்டின்னு பார்க்குறப்போ யூ ஹாவ் டு கோ த்ரூ த லெட்ஜர்ஸ் ப்ராப்பர்லி. அதெல்லாம் அதில் வரும். ஸோ த கான்ட்ரிபியூஷன் நீட் டு பி பெய்ட் ஆன் ஆர் பிஃபோர் 15th of the following month. For all the employees, the employer should generate UAN by giving the name, gender, DOB, DOJ, இதெல்லாம் ஆதாரில் இருக்கும். ஆதார் இது இல்லைனாலும் you have to collect from the employees. Earlier, there were concept of annual return under 3 and 6A. Nowadays, it is dispensed with because all the data are immediately uploaded as and when the employees are inducted. But generally, எல்லாரும் பண்ணுற தப்பு என்னென்னா 15th அன்னைக்கு ரிப்போர்ட் ரிட்டர்ன் ஃபைல் பண்ணுறப்ப தான் எல்லாமே பண்ணுவோம் நம்ம நியூ எம்ப்ளாயீஸ்க்கெல்லாம். பட் அது பண்ணாதீங்க தயவுசெய்து. ஏன்னா இப்போ ஃபார் எக்ஸாம்பிள் 1st April அன்னைக்கு ஒருத்தன் வரான், நீங்கள் இன்டைட் பண்ணிட்டீங்க. அடுத்த 15th May அன்றைக்கி தான் நீங்கள் வந்து ரிட்டர்ன் ஃபைல் பண்ண போகிறீங்க. மந்த்லி பே பண்ணுவீங்க. அப்போ நீங்கள் பண்ணிங்கன்னா ஊடால ஏதாவது நடந்ததுன்னா தலைவேலை நம்ம தலையில் தான் விழுகும். அது பிகாஸ் நாம் பக்காவாக ரைட் ராயில் கொடுத்துருவோம், அப்பாயின்மெண்ட்லாம் கொடுத்தா இது பண்ணுவோம், அவனுக்கு எழுத்து போட்டிருப்பான். சப்போஸ் ஒரு 10ஆம் தேதி எதாவது ஆயிடுச்சுன்னு வச்சுங்க, நீங்கள் என்ரோல் பண்ணாலும் அவன் கையை தூக்கிடுவான் பிஎஃப்காரன். இந்த இன்சூரன்ஸ் ஸ்கீம்லாம் அப்ளிகபிள்லாம் கிடையாது, பண்ணி தான் என்ரோல் பண்ணவே இல்லை அப்படின்றோம். ஸோ அதனால் வென்எவர் யூ இண்டெக்ட் திஸ் இஸ் பர்டிகுலர்லி ஃபார் இஎஸ்ஐ. இஎஸ்ஐலாம் 10 நாளைக்குள்ள பண்ணி ஆகணும் கண்டிப்பாக. பட் இதில் இல்லை போய்ட்டு இருந்தாலும் நீங்கள் வந்து அப்லோட் பண்ணுறது நல்லது. ஸோ earlier there was a concept of annual return which is dispensed with nowadays. Now as the date of new employees and resigned employees are to be uploaded on or before the paying the monthly dues. But yearly the uploading of joining of data as above will reduce the risk of unforeseen circumstances. Presently, employees with Aadhaar alone are being inducted. Hence, employees without Aadhaar cannot be included in the EPF membership. இது பெரிய பிரச்சனை எங்கன்னா எல்லா ஃபேக்ட்ரிலையும் நார்த்துலேருந்து வரவங்க ஒருத்தனை ஆதார் வச்சுக்க மாட்டான். அப்படியே வச்சுருந்தா அது வந்து சரியாகவும் இருக்காது. ஆல்ரெடி எங்கேயாவது இருக்கும். இதெல்லாம் இண்டெக்ட் பண்ணுறதுக்குள்ளே மண்டை காஞ்சிரும். அது மட்டும் இல்லாமல் உள்ளே வர்றப்பே உள்ளே போனோன்னு ஏதாவது நடந்ததுன்னு நம்ம தான் ரெஸ்பான்சிபிள். அதனால் ஆதார் இருக்கான இண்டெக்ட் பண்ணுறப்பே நம்ம வேலை ஆதார் இருக்கியா இருந்தால் தான் ரெசியூமே பார்க்கணும், பார்க்க வேண்டும் நம்ம, இல்லைன்னா பார்க்கக்கூடாது நம்ம. Interest and damages. Any delay in remittance of PF dues will attract an interest of 12% per annum. On day basis தான் கால்குலேட் பண்ணுறாங்க. பரவாயில்ல, நல்லவங்க. இன்கம் டேக்ஸில் வந்து மந்த்லி பேசிஸ், அதனால் இவங்க பரவாயில்ல. The damages for delayed remittance are given below. So 0 to 2 months delay இருந்ததுன்னா 5% per annum. அதுவும் நம்பர் ஆஃப் டேஸ் பேசிஸ் தான். 2 to 4 months 10%, 4 to 6 months 15%, more than 6 monthsனா 25%, subject to maximum even 100% also they can levy. Earlier it was 37, of course நல்ல மனசு பண்ணி 25 பண்ணியிருக்காங்க. ப்ராக்டிக்கல் சேலஞ்சஸ் இதுதான் வந்து முதல் எழுதுனதெல்லாம் அதில் இருக்கிற காப்பி பேஸ்ட் தான். இதெல்லாம் என் மனசில் இருக்கிற எழுதியிருக்கேன். ஓகே, ஸோ இண்டக்ஷன் ஆஃப் EU எம்ப்ளாயிஸ். Generally workers at low level are migrant employees. They don't have proper Aadhaar card and bank account. Hence covering them for PF is nowadays the biggest challenge in the industry. They don't understand the importance of PF and savings made through the said scheme and the benefit derived of thereunder. உள்ளே வந்தோடனே வந்து சார் உனக்கு 12,000 சம்பளம்னா வீட்டுக்கு எடுத்துகிட்டு போய் எவ்வளோன்னு தான் கேட்பான். 12,000 கொடுத்தா தான் வருவேன் அப்படிமா. ஸோ எம்ப்ளாயி டிடக்ஷனு எல்லாத்தையும் நாம தான் உட்காந்து ஆட் பண்ணிக்கிட்டு பண்ணணும். பட் நிறைய பேர் அதுக்கு தெரியுது, அப்பா உனக்கு தான் வரப்போகுது பைசா, இதனால் இன்சூரன்ஸ் இருக்கியாம்னா கேட்கவே மாட்டான். எவ்வளோ எடுத்துகிட்டு போகிறேன், 12 மணி நேரம் கூட ஒர்க் பண்ணுவான். ஆனால் வந்து இதெல்லாம் ஒத்துக்கவே மாட்டான். They are mainly keen on taking more salary to home. Many issues crops up when not able to upload PF data due to incorrect Aadhaar card and mismatch with the industry. இங்கே ஃபேக்ட்ரியில் வந்து ஒர்க் நடக்கணும் அப்படின்ட்டு சார் அவனை உள்ளே விடுங்க சார் அப்படின்னு நம்மளை தான் சொல்லுவாங்க. பட் ஆதார்லாம் உள்ளே விடக்கூடாது சார் அப்படின்னு சொன்னால் நீங்கள் இதே ஏதாவது சொல்லிட்டு தான் நான் எப்படி ப்ரொடக்ஷன் பண்ணுறது நம்மளை தான் கேள்வி திருப்பி கேட்பாங்க அவங்க. Hence, complaints before inducting them in the shop floor is a big issue as unforeseen circumstances would lead to unnecessary hardship to the employer. இது வந்து எல்லாம் ஸ்மூத்தாக போகிறதுன்னு தெரியாது. மகனை ஏதாவது நடந்த பிறகு தான் வந்து சார் இது முன்னாடியே சொல்லியிருந்தால் நான் செஞ்சுருப்பேனே அப்படின்னா எல்லாம் அந்த வசனம்லாம் அப்போ தான் வரும் உங்களுக்கு. ஸோ as to encourage the employers, also government introduced PMRY, ABRY எல்லாம் கொடுத்தாங்க. அது நல்ல பெனிஃபிட்டாக இருந்தது. நிறைய இண்டஸ்ட்ரி we also claimed. The government is planning to introduce ELI, புதுசாக வரப்போகுது, employees linked incentive, under which the first time employees will be rewarded 15,000 rupees in 3 installment. Every month 5,000 rupees அவங்களுக்கு கொடுக்க போகிறாங்க. அஃப்கோர்ஸ் பட்ஜெட் 2025 கொடுத்தாங்க, இன்னும் அது வந்து வரவே இல்லை இன்னும். Similarly, there is a plan of 3,000 per month to employer also as reimbursement of PF for newly inducted employees for 2 years. 2 வருஷத்துக்கு மாதம் 3,000 rupees கொடுக்குற மாதிரி ஒரு பிளான் இருக்குது. பட் இன்னும் வரல அது. Migrant employees. Complaints under Contract Labour Regulation Act as well as Migrant Employees Act and record maintenance are biggest problem. This issue leads to penalty, even prosecution to employees of the factory. ஜென்ரலாகவே இப்போ ரீசெண்டாக ஒரு பெரிய தலைவலி, ஃபேக்ட்ரியில் ஒரு டெப்யூட்டி டைரக்டர் வந்தார். யாருமே ரிசீவ் பண்ணலான்னு பெரிய நிலத்துக்கு ஒரு பெரிய லிஸ்ட்டு போட்டு கையில் கொடுத்து போயிட்டார். அப்புறம் நாங்கள் போய் நின்று அவட்ட எல்லாம் சொல்லி. ஸோ எந்த ஒரு பிஎஃப் டிபார்ட்மெண்ட்டோ எந்த லேபரில் பிஎஃப் பர்டிகுலராக சொன்னேன் வர்றாங்கன்னா கூட்டிகிட்டு போய் நல்ல ஒரு ரூம் ஏசி ரூம் போட்டு டீ காஃபி கொடுத்து என்னென்ன பண்ணணுமோ அதெல்லாம் பண்ணணும். கம்ப்ளைண்ட்ஸ் லா இஸ் டிஃப்ரெண்ட். இது மேனேஜ்மெண்ட் பண்ணது ரொம்ப முக்கியம். என்னுடைய ப்ராக்டிக்கல் எக்ஸ்பீரியன்ஸில் ஒரு கம்பெனியில், அஃப்கோர்ஸ் இட் இஸ் இன் 2005 தான், பணமும் கட்டலை. இவங்க பணமும் கட்டலை, வந்த ஏசியை கொண்டு போய் ரிசப்ஷனில் 1 மணி நேரம் உட்கார வச்சுருந்துருக்காங்க. அந்த பொண்ணுக்கு தெரியலை, அன்ஃபார்ச்சுனேட்லி ரிசப்ஷனில் இருந்த பொண்ணுக்கு. ஏசி வந்திருக்காருன்னா என்ன பண்ணிக்கணும், போய் விபி கிட்ட போய் சொல்லி உட்கார வச்சுருக்கணும். இந்த சார் தேர் மீட்டிங் சார் ஏதோ சொல்லியிருக்கு, பெரிய லெட்டர் கொடுத்துட்டாங்க. இங்கே தான் நான் தான் போனோன்னே ஹூ ஆர் யூ சார், ஐ எம் சார்ட்டர்ட் அக்கவுண்ட், ப்ளீஸ் கெட் அவுட், இதுதான். அப்புறம் இந்த விபி இவரை வந்து வெளியே உட்கார வச்சுட்டாங்க. காலையில் 10 மணிக்கு போய்ட்டு 5 மணிக்கு தான் உள்ளே கூப்பிட்டாரு. 5 மணிக்கு கூப்பிட்டு ஒன்றுமே பண்ணல, ஜஸ்ட்டு பேரில் கொண்டு எடுத்தார். வரிசை எக்ஸ்பென்சஸ்லாம் டிக் பண்ணிட்டே வந்தார். ஸ்ட்ரெயிட்டாக 25% டிமாண்ட் போட்டு கொடுத்துருவார். ரிப்பேர்ஸ் அண்ட் மெயின்டெனன்ஸு, கன்சல்டிங் ஃபீ, என்னென்ன இருக்கோ லேபர் இது மெட்டீரியல் மட்டும் தான் அவர் எடுக்கல, மிச்சதெல்லாம் எடுத்துட்டார். ரேட்ஸ் அண்ட் டேக்ஸஸ் எடுக்கலன்னு நினைக்கிறேன், அவ்வளோதான். மிச்சதெல்லாம் ஆல்மோஸ்ட் எடுத்தார். 25% போட்டு ஆர்டர் போட்டு கையில் கொடுத்துட்டார், அவ்வளோதான். சார் நத்திங். பட் அன்ஃபார்ச்சுனேட் என்னென்னா இப்போ அட்லீஸ்ட்டு ட்ரிபுனல்லாம் இங்கே இருக்குது. முந்தி வந்து டெல்லிக்கு போகணும், டெல்லிக்கு தான் போகணும் நான் சொல்கிற பீரியடில். ஸோ நீங்கள் நினச்சி பாருங்கள், இது ஒன்றுமே இல்லை. அவரை கூப்பிட்டு உள்ளே போய் உட்கார வச்சுட்டு காஃபியை கொடுத்து சார் கட்டிடுறோம் நீங்கள் போங்க பின்னாடியே செக்கோட வரேன்னு சொல்லியிருந்தால் ஒன்றுமே நடந்திருக்காது. இது பண்ணாதனால அந்த வேலை எவ்வளோ நடந்திருக்கு. ஸோ லா தெரிஞ்சுக்கிறது வேறு, ஆனால் மேனேஜ் பண்ணுறது ரொம்ப முக்கியம். அதான் சொல்ல வரேன் அல்டிமேட்டாக. இதில் முக்கியமாக இந்த கான்ட்ராக்ட் லேபர் அண்ட் மைக்ரண்ட் எம்ப்ளாயிஸு சொல்ல வேணாம். ஒருத்தனும் வந்து டேட்டா வச்சுருக்க மாட்டான். நம்மளை வந்து டேட்டா முந்தியாவது மேனுவலில் 4 நாள் கழிச்சு பண்ணலாம், இப்போல்லாம் எல்லாம் ஆன்லைனில் பண்ணி தான் ஆகணும். ஸோ அதனால் டேட்டா இல்லாமல் மெயின்டைன் பண்ணது ரொம்ப இப்போல்லாம் வெரி டஃப். இந்த சொன்னேன் இல்லையா, when they told the topic to me domestic workers, I was thinking it is labor law code தான் வருதுன்னு நினைக்கிறேன். ஸோ அதனால் இதையும் கொஞ்சம் ஆட் பண்ணியிருக்கேன். ஸோ அந்த லேபர் லா கோட் domestic workers as per labor law code means with respect to the employer will take care through the EPF organization. For those who are self-employed, சின்ன சின்ன கூலி வேலை பார்க்குறவங்க அவங்களாம் பண்ணுறோம், அவங்களுக்கெல்லாம் எப்படி சோசியல் செக்யூரிட்டி கொடுக்கணும் அப்படின்னு தான் under the labor code they have introduced. So the object of this code is to extend the social security to all employees and workers in the organized and unorganized sector also. The social security for organized sector can be forced through the employer. The employees of unorganized sector, known as domestic workers under the labor law code, can be regulated by the government by implementing some social security measures through implementing social security schemes. The government of India has launched a website called eShram. நீங்கள் தயவுசெய்து பாருங்கள், நல்லா இருக்கும் உண்மையிலே. பட் இன்னும் ஃபுல் ஃப்ளெஜ்டாக வரல. I went to eShram.gov.in wherein the various schemes are being introduced. The beneficiary should register with the eShram portal for availing the benefits. ஸோ அவங்க வாலண்டரியாக தான் பண்ணணும். As on date 30.63 crores eShram card have been issued. In the eShram process, these are all the schemes they have listed. I have taken just 4 or 5 schemes to explain how the pension schemes as well as the savings scheme have been extended to the unorganized sector also. The first one, Pradhan Mantri Shram Yogi Mandhan Yojana. So இது வந்து old age protection-காக pension for self-employed. So voluntary and contribution pension schemes, monthly contribution ranging from 55 to 200 rupees depending upon the entry age of the beneficiary. ஸோ இப்போ ரோட்டில் செருப்பு தைக்கிறான்னு வச்சுங்களேன், அவன் வந்து தாராளமாக இதை பண்ணலாம், தாராளமாக. ஸோ he has to contribute 500 to 200 rupees பண்ணணும். Under this scheme 50% of monthly contributions payable by the beneficiary and equal matching contribution is paid by government. ஸோ இது நிறைய பேர் தெரியாது. நிறைய பேர் இப்போ நம்ம வீட்டிலே வேலை பார்க்குறாங்க இல்லையா, அவங்களுக்கு கூட நீங்கள் பண்ணலாம். உங்களுக்கு வந்தவொன்னே நான் பண்ணணும்னு வச்சுக்கேன், வந்தவொன்னே நீங்கள் தயவுசெய்து வீட்டு மெய்டுக்கெலாம் அவங்களாம் தெரியாது பாவம். ஸோ 200 rupees நீங்களே வந்து ஒரு கிஃப்ட் மாதிரி நினச்சி கொடுத்தீங்கன்னா அவங்களுக்கு ஒரு பென்ஷன் ஸ்கீம் வரும். ஸோ எலிஜிபிலிட்டி பார்த்தீங்கன்னா should be the beneficiary should be an Indian citizen, unorganized workers in working as street vendor, agriculture related work, construction site workers, workers in industry of leather, handloom, midday, என்னென்ன இருக்குது, ரிக்ஷாக்காரன் கூட பண்ணலாம், ஆட்டோ, இதெல்லாம் வந்து நீங்கள் எழுதவே வேணாம், இதெல்லாம் சைட்டில் இருக்குது, நீங்கள் நேரில் போய் பார்க்கலாம். இதை அப்படியே காப்பி பேஸ்ட் தான், டோன்ட் வரி. ஓகே, எக்ஸ்பிளைன் பண்ண தான் எடுத்துகிட்டு வந்திருக்கேன். ஸோ ஏஜ் குரூப் இஸ் 18 to 40 இயர்ஸ் வரைக்கும் அவங்க என்ரோல் பண்ணிக்கலாம். மந்த்லி இன்கம் ஷுட் பி லெஸ் தேன் 15,000 rupees. ஜென்ரலாக அப்படி தான் இருக்கும். Not a member of a EPF organization. So why they have excluded EPF means then it be done by the employer. So அதனால தான் they have been excluded. Benefits என்னென்ன கிடைக்குதுன்னா, after attaining the age of 60 years, beneficiaries are entitled to receive monthly assured pension of 3,000 rupees per month. So monthly pension 3,000 rupees. நீங்கள் வந்து உங்களோட வீட்டு வேலைக்காரமாக இது பண்ணிங்கன்னா 60 வயசு வச்சு அவங்க 3,000 கிடைக்கிறப்ப உங்களை நினச்சிக்கிட்டே இருப்பாங்க எல்லாம் டெஃபினட்டாக. ஆன் டெத் ஆஃப் த பெனிஃபிட் இதெல்லாம் முந்தி இல்லை. அன்ஃபோர்ஸ் லேபர் கோட் வந்த பிறகு இது முந்தியெல்லாம் எப்படி யாருமே பண்ணியிருக்க மாட்டாங்க. இந்த லேபர் கோட் இதெல்லாம் கவர்மெண்ட் கொண்டு வந்துருக்கு இதெல்லாம். ஸோ ஆன் டெத் ஆஃப் த பெனிஃபிஷியரி ஸ்பௌஸ் இஸ் எலிஜிபிள் ஃபார் 50% ஆஃப் த மந்த்லி பென்ஷன். இஃப் த ஹஸ்பண்ட் அண்ட் ஒய்ஃப் போத் ஜாயின்ஸ் த ஸ்கீம் தே ஆர் எலிஜிபிள் ஃபார் 6,000 rupees மந்த்லி. ஸோ 6,000 இஸ் அஃப்கோர்ஸ் இது 60 வயசு வரப்போ காஸ்ட் ஆஃப் லிவிங் படி தேவைமா தராது எனக்கு தெரியாது. பட் இப்போ 6,000 பரவாயில்ல அவ்வளோதான். அப்போ வந்து பீடா வாங்க கூட 10 எனக்கு தெரியாது. ஸோ நேஷ்னல் பென்ஷன் ஸ்கீம் ஃபார் ட்ரேடர்ஸ் அண்ட் த செல்ஃப் எம்ப்ளாய்டு பர்சன்ஸ். ஸோ அதே மாதிரி தான் த சேம் ஒன். they have to contribute 55 to 200 rupees depending upon the entry age. It is applicable to small shop, restaurant, hotel, இதெல்லாம் ஓனர்ஸ்க்கு தான் இதெல்லாம் மெயினாகவே. ஸோ நாட் கவர்டு இன் இபிஎஃப் இருக்கணும். ஆனுவல் டர்ன் ஓவர் நாட் லெஸ் தேன் 1.5 crores. அங்கே வந்து மந்த்லி சேலரி ஷுட் பி லெஸ் தேன் 15. இவங்க வந்து திஸ் இஸ் ஃபார் த ஓனர்ஸ். ஸ்மால் பெட்டி வெண்டார் வச்சுருக்கான் அவன் இருந்தானா தே கேன் கோ அண்டர் திஸ் பிகாஸ் அவங்களுக்கு சேலரியில் எதுவும் இருக்காது இல்லையா. ஸோ அதனால் டர்ன் ஓவர் 1.5 crores கம்மியாக பண்ணுறாங்கன்னா தே ஆர் எலிஜிபிள் ஃபார் திஸ். ஸோ அண்டர் திஸ் ஸ்கீம் த பெனிஃபிஷியரி ஆர் என்டைட்டில்ட் டு ரிசீவ் மந்த்லி அஷ்யூர்டு பென்ஷன் ஆஃப் 3,000 rupees after attaining the age of 60 years. Pradhan Mantri Jeevan Jyoti Yojana for insurance, இது வந்து இன்சூரன்ஸ் கவரேஜ் இஎஸ்ஐ மாதிரி. ஸோ should be an Indian citizen, entry age should be 18 to 50, having Jandhan and saving bank account இருக்கணும் with Aadhaar card linked, auto debit from the bank account. ஸோ இன்சூரன்ஸ் ப்ரீமியம்னால எவ்ரி இயர் there should be some premium. ஸோ ஆட்டோ டெபிட் தான் பண்ணணும், ஏன்னா இதை போய் ஒருத்தங்க வாங்க முடியாது. அதனால் பெனிஃபிட் வந்து 2 lakhs on death due to any issue, premium வந்து 436 rupees. ஸோ less than 500 rupees an insurance scheme of 2 lakh is being given to them. இன்னொன்று பிரதான் மந்திரி சுரக்ஷா பீமா யோஜனா, சேம் ஒன், பட் இது ஏஜ் வந்து 18 to 70 years, ஹேவிங் ஜன்தன் சேவிங் பேங்க் ஆதார் அக்கௌண்ட் இருக்கணும், ஆட்டோ டெபிட் தான். திஸ் ஸ்கீம் கவரேஜ் அண்டர் த ஸ்கீம் இஸ் 2 lakhs ஃபார் ஆக்சிடென்டல் டெத் அண்ட் ஃபுல் டிசபிலிட்டி. மேலே வந்து என்னென்னா நேச்சுரல் ஆக்சிடென்ட் மட்டும்தான், அண்ட் 1 lakh ஃபார் பார்ஷியல் டிசபிலிட்டி. ப்ரீமியம் இஸ் 20 rupees தான். இது முக்கியமாக ஏன்னா நேச்சுரல் டெத்து கவர் இல்லை, அதனால் ப்ரீமியம் வந்து ஜஸ்ட் 20 தான். சாரி பெர் ஆனம் இது. நீங்கள் டில் டெத் வரைக்கும் கட்டிகிட்டே இருக்க வேண்டியதான். ஆமாம், என்ட்ரி ஏஜ் தான் இது. 18 to 50ங்கிறது என்ட்ரி ஏஜ். ஸோ நீங்கள் ஒன்ஸ் எடுத்துட்டிங்கன்னா அதுக்கடுத்து நீங்கள் கட்டே போக வேண்டியதான். இல்லை நீங்கள் கட்டிகிட்டே இருக்க வேண்டியதான். அது கிளாரிட்டி இல்லை. சாரி, கரெக்டு, நீங்கள் கேள்வி கரெக்டு தான். மேபி கண்டிப்பாக ரசிங்க அதில் இல்லை நான் பார்த்த வரைக்கும். பட் ஸ்கீம்ஸ் இன்னும் ஃபுல்லாக வரல, ஃப்ளட்ஸில் வரல. சைட் பண்ணியிருக்காங்க, பட் இன்னும் அது சரியாக ஃபுல்லாக வரல. அட்டல் பென்ஷன் யோஜனா இதுவும் அதே தான். பட் இதில் என்ன ஷுட் பி அன் இண்டிவிஜுவல் பிட்வீன் 18 to 40 ஹேவிங் பேங்க் அக்கௌண்ட், அதாவது த கான்ட்ரிபியூட்டர் ஆன் ஹிஸ் சாய்ஸ். அங்கே மொதல் வந்து அமௌண்ட் ஃபிக்ஸ்டு 3,000 rupees தான் சொல்லியாச்சு. இங்கே வந்து யூ கேன் ஃபிக்ஸ் அமௌண்ட் 1,000 to 5,000 rupees வரைக்கும், டிபெண்டிங் அப்பான் தட் யூ கேன் contribute an amount, or he can also get an accumulated sum of pension after his death. The accumulated amount will be given to the spouse, or if the spouse is dead, as well then to the nominees also. இது வந்து PDS, I mean ரைஸ் அந்த மாதிரி கொடுக்குறது. should be an individual. All families below the poverty line is eligible. Any family which doesn't have a member between 15 to 59 years இருந்தால் அவங்களுக்கு கிடைக்கும். Any family which has a disabled member is also eligible to avail the benefit under the Pradhan Mantri Awas Yojana. Those who don't have any permanent job and only engage a labor இருந்தாலும் பண்ணிக்கலாம். 35 kgs of rice or wheat, இதுக்கு வந்து எதுவும் பே பண்ணலாம், ஜஸ்ட் என்ரோல் தான் பண்ணணும், ஃப்ரீ தான் இது. இல்லை இல்லை, அதாவது ஏர்னிங் மெம்பர், அதில் வந்து ஏர்னிங் மெம்பராக இருக்கும். ஏர்னிங் மெம்பர்,
ஓகே.
These are all the practical challenges. Coverage date is very, very important. As PF is applicable when the head count employed crosses 20 in number, hence the head count need to be arrived after considering the indirect employees. Generally, the date of coverage should be far earlier than the date of enrollment. PF department used to take such employees by digging various heads of accounts such as repairs and maintenance, staff welfare, contract labor charges, loading and unloading, freight charges, driver beta, etc. Hence, cash should be taken all these aspects before deciding the coverage date. ஸோ நீங்கள் வந்து என்ரோல் பண்ண ஒருத்தர் சொல்கிறாருன்னா நீங்கள் உடனே ஓகே பண்ணிடலாம், நாளைக்கே பண்ணிடலாம்னு சொல்லக்கூடாது. நீங்கள் வந்து ஒரு மாதம் உட்காந்து எல்லாத்தையும் ஒரு இன்டர்னல் டேட்டே பண்ணணும். அதுக்கு உட்காந்து டியூட்டி எலிஜென்சி தேர்மா தராத அப்படின்னு சொல்லணும். ஏன்னா இன்ஸ்பெக்ஷன்லாம் வருவாங்கலாம் உடனேலாம் வரமாட்டாங்க. நீங்கள் கொடுத்தோம் நம்பர் கொடுத்துருவான், வாடா மாட்டினாடா அப்படின்ட்டு. அதுக்கடுத்து 1 வருஷங்கள் தான் வருவாங்க. வர்றப்போ ஃபஸ்ட்டு கவரேஜ்னாலே முதல்ந்தே தான் பார்ப்பாங்க. ஸோ 5 வருஷம் வரைக்கும் தே கேன் கோ பேக். ஸோ 5 வருஷம் எடுத்து பார்த்தான்னு வச்சுங்களேன், ஏதாவது ஒரு பாயிண்ட்டில் இஃப் தே ப்ரூவ் தட் இட் ஹஸ் கிராஸ் 20, அந்த டேட்டு தான் கவரேஜ். அதுக்கடுத்து நான் சொன்ன கேஷுவல் எம்ப்ளாயி கூட இருப்பாங்க. ஸோ 20 கிராஸ் பண்ணியிருப்பாங்க. அதுக்கடுத்து வந்து ஆட்டோமேட்டிக்கல் அப்ளிகபிள் தான். ஸோ அவங்க அரைவ் பண்ணுறப்பே வந்து அந்த மோட்டிவோடு தான் வந்தே பார்ப்பாங்க. நீங்கள் சார் இது பார்க்க வேணாம் வந்ததே அதுக்காகன்னு சொல்லுவாங்க அவங்க. ஓகே. Arriving basic salary. Industry faces lot of issues on designing the pay structure. They used to structure in such a way that the cost of labor is low. They used to keep 30 to 40% of the gross salary as basic. நான் இதை நிறைய இதில் பார்த்துருக்கேன். 30 to 40 தான் வைப்பாங்க அது ஜென்ரலாக. PF inspector used to insist for 70% of the gross as basic. As generally PF inspection is conducted after few years, the employers are burdened with both employees and employer share with the interest and damages. Hence, keeping a proper HR policy and contribution on all allowances paid across the board are essential to avoid these type of disputes and demands on later date. So, முக்கியமாக வந்து HR பாலிசி தான். எந்த கம்பெனி தயவுசெய்து எடுத்திங்கன்னா ஒரு HR பாலிசியை போட்டு வச்சுருங்க. எல்லோரும் சைன் பண்ணிடணும். ஈவன் எம்ப்ளாயீஸ் கிட்ட வந்து கையெழுத்து வாங்கலாம். ஒரு அந்த டீம் லீடர் மாதிரி இருப்பாங்க இல்லையா, ஒரு யூனியன் இருக்காது. யூனியன் இல்லாட்டினாலும் அவங்க ஒரு மினிட்ஸ் மாதிரி போட்டு எல்லாட்டையும் அந்த அப்போ என்ரோல் பண்ணுறப்ப யாராவது இருக்காங்க அந்த HR பாலிசியில் கையெழுத்து வாங்கி வைக்கிறது நல்லது. ஏன்னா அவங்ககிட்ட கேட்டு தான் பண்ணணும்னு சொல்கிறதுக்காக. இதெல்லாம் நீங்களே கிரியேட் பண்ணிருக்கீங்கன்னு சொல்லுவாங்க. ஸோ மல்டி சிக்னேச்சர் வில் வேலிடேட் த டாக்குமெண்ட் இன் a better way. Okay. Hence, keeping a proper HR, okay, right. The new labor code has drafted giving a relief to the dispute that the basic salary should be at least 50% of the gross salary. So, yeah, the 70% ஒரு unwritten law தான். But லேபர் கோடில் இட் இஸ் a written law, 50% enough அப்படின்னு சொல்லியாச்சு. மினிமம் வேஜஸ் as per the circular dated 23/5/2011 by the EPFO, the basic wages should be at least equal to minimum wages. The state government every year fixes the minimum wages for every industry. PF department used to insist this so as to arrive some more contribution dues. Hence, care should be taken that the basic wages are at least equal to the minimum wages so as to avoid the disputes. So, இண்டஸ்ட்ரி அந்த இண்டஸ்ட்ரி லெதர் இண்டஸ்ட்ரி அப்படின்னு லெதர் இண்டஸ்ட்ரிக்கு ஒரு லிஸ்ட்டு கொடுத்துருக்காங்க. ஹாஸ்பிட்டல் கொடுத்தாங்க. ஹாஸ்பிட்டலில் ஒன்றும் பிரச்சனை இருக்காது, ஏன்னா ஆல்ரெடி மினிமம் வேஜஸில் கொஞ்சம் அதிகமாக தான் இருக்குது. அதில் ஹாஸ்பிட்டலில் இருக்கிறதுலே மினிமம் வேஜஸில் ஹையஸ்ட்டு வந்து ஹாஸ்பிட்டல் இண்டஸ்ட்ரி மட்டும்தான். மிச்சதெல்லாம் வந்து ஒரு மோர் ஆர்லஸ் கொஞ்சம் ஒரு 1000 rupees இந்தியன் டாலர் தான் இருக்கும் ஹாஸ்பிட்டலில் பொறுத்த கூட. ஸோ ஏதாவது ஒரு ஹாஸ்பிட்டலில் சப்போஸ் த பேசிக் வேஜஸ் 9000 rupeesனால் தயவுசெய்து செக் பண்ணிவிடுங்க. அது டெஃபினட்டாக வந்து கம்மியாக தான் இருக்கும். எப்போ வேணால் அது பிரச்சனை வரலாம். HR policy. Small companies generally don't have proper HR policy. Having proper HR policy duly documented and signed by the employee's representative would strengthen our argument with the PF inspectors on basic wages issue. Thank you, sir. I have to take one more session. If there is a break means I will... Okay. Thank you, sir. Thank you all.
We have a another short version of session from him, requesting all the members to settle down so we can begin the session. Thank you.
Hello. Last session I was very confident because of course I only generally know except Navaratna sir, but I should be very careful now because it's a taxation aspect, so everybody are well versed than me. Okay. So if I do something deviate, please correct me. Okay. Shall we start, sir? Of course, this all is spelled out earlier, but still little recapturing it. So, EPF, a retirement cum savings benefit scheme, mandatorily applicable to establishment with 20 or more employees, mandatorily applicable to employees whose basic salary is less than or equal to 15,000 per month. ESI, a social security scheme providing medical, monetary and other benefits to employees earning up to rupees 21,000 per month in establishment with 10 or more employees. So contribution rate is employee 12% on basic plus DA, employers 12% plus on basic plus DA, out of which 3.67 to EPF and 8.33% to employees pension scheme. If the employee earns salary of more than 50,000, the employer's EPS contribution is subject to limit of 1,250, and the balance amount of employer contribution, that is 12% on basic pay, should be transferred to EPF account. It means out of say on 15,000 rupees, 1,800 will come. So 1,250 you have to contribute to the pension scheme, and balance should be transferred to the EPF account. Suppose your contribution is more than that, say for example employer also willing to contribute more than that, means then the contribution to the pension scheme is restricted to 1,250, balance should be transferred to the EPF account alone. So their employee contribution is 0.75% and employer contribution 3.25%. Here on basic plus DA, there on gross salary, ESIs. So for employees with less, with salary exceeding 15,000, the employer contribution of EPS is capped to 1,000. For EPS it is 1,050 only per month. So total contribution 1,800 means then employer contribution restricted to 1,800, out of which 1,250 is to EPS. The employees earning up to 176 rupees are exempted from their contribution to ESI. 176 rupees per day ங்கிறது எதுவுமே இல்லை, அதனால் அவங்க வந்து எக்ஸம்ஷன் கொடுத்துருக்காங்க. எம்ப்ளாயர் மஸ்ட் ஸ்டில் கான்ட்ரிபியூட் ஃபார் தர் ஷேர், இட் இஸ் ஃபார் ESI. ஓகே. So type of provident fund what are prevailing is, one is statutory PF, another one is RPF, another one is unorganized provident fund, another one is public provident fund. அது வந்து சேவிங்ஸ் பேங்க் மாதிரி தான். So first one statutory PF means it is applicable to government employees, particularly railway, கவர்மெண்ட்டு, அவங்களுக்கெல்லாம் வந்து யூனிவர்சிட்டி, யூனிவர்சிட்டி ரன் பை த கவர்மெண்ட், அவங்களுக்கெல்லாம் வந்து ஸ்டாச்சுரரி பிஎஃப்னு சொல்லுவாங்க. ஆர்பிஎஃப் மீன்ஸ் இட் இஸ் அப்ளிகபிள் டு ப்ரைவேட் செக்டார். ஸோ தே ஹாவ் டு ரெஜிஸ்டர் வித் த இபிஎஃப்ஓ, தட் இஸ் நோன் அஸ் ஆர்பிஎஃப். டெஃபினிஷன் பின்னாடி வரும். அன்ஆர்கனைஸ்ட் ப்ராடக்ட் மீன்ஸ் தட் மீன்ஸ் இட் இஸ் ஆல்சோ பை த ப்ரைவேட் செக்டார். பப்ளிக் ப்ராடக்ட் மீன்ஸ் இட் இஸ் அ சேவிங்ஸ் பேங்க் அக்கௌண்ட். So employees contribution to the fund வந்து deduction is allowed under section 80C for statutory PF. Recognized PF ல வந்து deduction allowed under section 80C, whereas unorganized provident fund the deduction is not allowed under section 80C. Public provident fund it's a savings account, so it's also eligible under section 80C. Employer contribution to the fund is, it is exempt from tax under statutory PF because being a government is there. Recognized provident fund பொறுத்தளவு exempt up to 12% on basic plus DA. Unrecognized provident fund not taxed when initial contribution is made, whereas at the time of withdrawal it is fully taxable. In public provident fund it is not applicable because it is a one savings account only. Interest income in SPF it is totally exempt. In recognized provident fund it is up to 9.5% it is exempt, but what they are declaring is lesser than that only, 8.25 like that. So as per law it is up to 9.5% is exempt. Unrecognized provident fund not taxed on year of accrual. It is taxable at the time of receipt. Public provident fund interest is totally exempt. Statutory PF, it is generally applicable to employees of government department, accredited university and education institution etc. run by the government employees. It is regulated under the Indian Provident Fund Act 1925. அது வந்து EPFO 1956. The employees are used to contribute around 8 to 10% depending upon the terms of engagement and department. Employer also makes equal contribution. Interest is paid to central government each year and compounded annually, paid by government. The interest and employer contribution is fully exempt. If withdrawn before 5 years, they are subject to TDS, subject to tax as well as TDS also. RPF doesn't mean that it is recognized under the EPF Act, but RPF means recognized provident means a provident fund which has been and continues to be recognized by the Principal Chief Commissioner of Income Tax, Principal Commissioner, Chief Commissioner or Principal Commissioner of Income Tax, in accordance with the rules contained in Part A of the 4th schedule, and includes a provident fund established under the scheme framed under the EPF Act. So all registration under the EPFO is recognized only. You need not go separately go and approach the principal commissioner for registration. Certain companies, they used to have their own provident fund scheme without enrolling with the EPFO by having their own rules and regulation, and it should be approved by the PF commissioner. Generally, it is allowed if the benefit under the own created provident fund is better than the EPFO. Suppose they are awarding better schemes, then after verifying all the credentials on that, they used to approve that. Okay. It is applicable to all private sector employees. Organization with, but the first one, the principal commissioner, we have to once they create their own provident fund means then it should be applied to the EPFO and get their approval, then only it is a valid one, or it is recognized provident fund. It is applicable to all private sector employees. Organization with 20 or more employees need to register with EPFO and mandatorily contribute to employees earning less than or equal to basic salary of 15,000 per month. It is regulated under the EPF under Miscellaneous Provision Act 1952. The employees are to contribute 12% of the basic wages by way of deduction by employer. Employer also makes equal amount of contribution with administration charges of around 1%. Hence, employer has to contribute 25% every month. So generally, they have to contribute 25%, out of which 12% can be recovered from the employee. The same analogy is used by the PF department. When they come for audit, if they deduct something, they used to collect 25%. This is the analogy. The said fund are managed by EPFO by investing in various prescribed securities. For every year, the EPFO declares the rate of interest applicable for each PF contribution and credited to each member's account. The interest and employer contribution is fully exempt. It includes provident fund created by employer and managed by them, subject to approval of EPFO through EPF scheme. It is generally permitted if the employer submits a scheme that the scheme framed by them gives better yield and return and safe to the employees. If that be the case, then Regional Provident Commissioner will approve it. Unrecognized provident fund, any saving scheme framed by the employer of their own not recognized by EPFO shall be termed as a unrecognized provident fund. For example, an employer having less than 20 employees can frame a scheme for retirement benefit with the consent of the employees, but it is known as unrecognized provident fund. However, it may be noted that such organization can voluntarily enroll with the PF organization with the consent of all the members then existing. Suppose they don't want to get into the EPFO shoulder, they wanted their own means, they can form a savings scheme that is known as unrecognized provident fund, but in income tax there is a deductions cannot be claimed. So better they can go to PF organization and voluntarily enroll with them, even the number of count is less than 20. Once made applicable, then all the provisions are mandatorily applicable. Taxation of contribution made and interest thereof. Employer contribution with respect to the RPF, mandatorily monthly contribution in excess of 12% of the salary is taxable under salary. So generally, the contribution is 12% only by the employer, is 12% only they used to cap. So there it is not taxable. In FPF, fully exempt. In PPF, it is not applicable. Employees contribution eligible for deduction under ATC, not eligible for deduction under ATC, and FPF eligible for deduction under ATC. Of course, in PPF, it is also deductible under section ATC, subject to a maximum of 1,50,000. Interest credited on employer contribution. Amount in excess of 9% per annum is taxable as salary under section 17(1). But nowadays it is around 8.5 to 9%. URPF not taxable at the time of credit of interest. In FPF it is fully exempt. In PPF it is totally exempt. Interest credited on employees contribution. Amount in excess of 9% is taxable as salary, not taxable in URPF, and SPF it is exempt up to a certain limit of contribution. In PPF it is fully exempt. Amount withdrawn on retirement or termination. Under RPF it is fully exempt subject to certain conditions. Taxable if the amount withdrawn is less than within a period of 5 years. Under URPF, employees contribution is not taxable. Interest on employer contribution is taxable under income from other sources. Employer's contribution and interest thereon is taxable under the head of salary. In SPF, government எல்லாருக்கும் அள்ளி கொடுத்துருவாங்க, எல்லாமே exempt தான் அவங்களுக்குலாம் ஃபுல்லாகவே. ஸோ PPF பொறுத்தளவு it is totally exempt under section 1011. Taxation on withdrawal of contribution. On death of the employee while still in active service இருந்தா, any withdrawal of amount by their legal heirs are not taxable in the hands of the such legal heir. Vide CBT circular number 573 dated 21/8/1990 ஒரு சர்க்குலர் கொடுத்துருக்காங்க. Withdrawal of amount of PF on retirement is taxable as detailed below. Government employees it is fully exempt. Private sector employees when the interest in excess of 9.5% taxable. Employees contribution is exempt. Employer contribution is exempt under section 1012. However, any withdrawal of employer contribution before 5 years of becoming member of PF organization for reason other than stated above, death na onnu adala kediyadu, other than that means then it is taxable fully, employer contribution. Any loan availed from PF department does not tantamount to withdrawal. Suppose if you avail any loan, then it is not a withdrawal. TDS on withdrawal. PF department is obligated to withhold a portion of amount withdrawn as TDS if the employees withdraws more than 50,000. So if the amount is less than 50,000, there is no TDS at all. Of course, it is more than 50,000 means then TDS is applicable. The employee has not completed 5 years of continuous service also, that is also TDS applicable. The rate of TDS is 10% of amount withdrawn. If the PAN of the employee is provided, if they don't have PAN, then PF department is bound to deduct 30% of the amount withdrawn. Exemption from TDS on EPF withdrawal. Under the following nature of withdrawal, TDS is not deducted by PF department on its withdrawal even if the amount is crosses 50,000. So even if the amount is more than 50,000, under these circumstances there is no TDS at all. Like on death, when the EPF is transferred from one PF account to another PF account, from one employer to another employer, it is not a withdrawal. It doesn't tantamount to withdrawal. When the employee's service are terminated because of his bad health, when the business is discontinued, when the project is completed, or in case of any other reason that is not under the control of the employee means, then also TDS need not be deducted. If the employee has submitted his PAN details with details under form 15G, like bank la kudukra mari kuduthingana, then also there is no TDS at all. But generally PF department will not entertain. They used to deduct 15G, 15H, they will not entertain. So tax impact due to premature withdrawal. இது வந்து just first of all I want to clarify that relief 89 is not applicable for this withdrawal. Okay, so this is prepared with a view to see the tax impact on premature withdrawals. This example for 4 years I have put 6 lakhs. Contribution is 72,000, interest வந்து 8%, employer contribution 72,000. So interest 80% வந்து 5,000 வருது. So for 4 years I have put the tax liability of said mentioned financially would be as follows. So section 80C deduction EPF account is 72,000. So 10% on the 2.5 lakhs and 20% on the 28,000. On 28,000 it comes to 30,000. So the tax liability is, without considering the amount, 30,000, 68,000 and 88,000, 1,23,000. His tax liability will be calculated as follows by including the premature amount means then the total tax liability comes to 59,904, 90,208, 137,730 and ultimately what I wanted to say is even the amount is withdrawn before 5 years, tax is leviable, TDS will be deducted, 89 relief cannot be claimed. That's what. Taxation and benefit for the employers. As per section 43B of the Income Tax Act, certain exemptions are allowed on payment basis. One among them is PF and ESA contribution. The employers are obligated to remit the contribution on or before the relevant due days prescribed under the PF and ESA law. So the due date is for PF it is 15th and the ESA is 21st of the following month. The employer contribution and admin charges to EPF and ESA are treated as business expenses and are deductible under section 36(1)(4) of the Income Tax Act, but as per 43B, allowed as expenditure only on payment basis. Under section 36, it is very clearly mentioned it is a allowed expenses, but we can claim only if it is paid under section 43B. Suppose the 36 section is not available, then the question of allowability will come. That's the reason they have added in section 36 as well as they have allowed on payment basis under section 43B. So to claim these deductions, employer must have deposited the contribution before the set due date of, or at least before the due date of filing the IT return. Damages paid to PF department is disallowed because being a penalty. Tax impact if not paid before the due date. Suppose there are two impact. If the dues both employer and employee's share are not paid before the due date, the employers are penalized on both part of contribution. Section 224.10 reads as follows. Income includes, of course, in 10th point, any sum received by the assessee, that is employer, from his employees as contribution to any provident fund or superannuation fund or any fund set up under the ESI Act or any other fund for the welfare of the employee. So, income includes any sum received. Blatantly they added the employee contribution. Whether claiming is possible, it is 43B. So, you have to add, then you have to claim like that. So, if you don't pay under 43B, automatically it is disallowed. But it should be included in that. But general memo purpose we will not add and deduct. Once if it is paid means then the employee's part, if blatantly limited, we will add to the income part. So, section 224.10 of the Income Tax Act empowers the department and treats the employee's contribution as income in the hands of the employer. Hence, even though it is not credited to the P&L account, the said amount need to be added in the memo separately. Generally, the employee's contribution will not come to P&L account. So, everybody knows. So, it should be added specifically in the memo. But general memo parappa the disallow the manuva. General, but it should be added under income not credited to P&L account, considered separately. We have to add under that head. We have to add. Employer contribution is an expenditure to the employer, hence it is debited to P&L account. If the dues are not paid within the due date, the said contribution is treated as inadmissible expense under section 43B and to be disallowed at the time of computation of income. Hence, a default on remittance of tax would have the following tax impact on the employer. Under PF Act, payment of interest at the rate of 12%, damages at 5% per annum for the delayed, when I have already told the slabs also, and the last one 25% per annum for delays more than 6 months, subject to maximum 100%. They can go to the limit of 100% also, because for 6 months, suppose they pay after 4 years, commissioner will decide whether 100% or not. So, under Income Tax Act, tax impact is 30% to 25%. Of course, partnership firm, 25% for company, on the addition of the employee's contribution as income under section 224.10. And on disallowance of employer contribution and admin charges under section 43B. So, see the impact, 100 rupees you don't pay, you have to pay 12% interest. And damages, 25%. Then thereafter, there it comes, 100 rupees 30% tax. Then employer contribution. So, totally if you see, it is worth paying by borrowing at a hefty rate also. That's what I mentioned. Kanduvati vaangi kuda kattalam. நான் ஜெனரலா தான் சொல்லுவாங்க. கந்துவட்டி வாங்கி கட்டிடுங்க பிஎஃப்எஸ்ஐ, அப்புறம் நீங்கள் அதனால் கம்மியாக கட்டலாம். ஓகே, இதில் ஒரே ஒரு பாயிண்ட் நான் மிஸ் பண்ணிட்டேன். சப்போஸ் எம்ப்ளாயீஸ் கான்ட்ரிபியூஷன் நீங்கள் கட்டலை டியூ டேட்டுக்குள்ளே, சப்சிக்வெண்ட் இயரில் வென் யூ ஆர் ரெமிட்டிங் ஆர் பிஃபோர் ஃபைலிங் த ரிட்டர்ன் இஃப் யூ ரெமிட் த பிஎஃப், வாட் will happen? எம்ப்ளாயீஸ் கான்ட்ரிபியூஷன் யூ cannot claim. அதுதான் பெரிய டேஞ்சரஸ் பார்ட் இதில். ஏன்னா 43Bயில் ஆன் ஆர் பிஃபோர் த ஃபைலிங் ஆஃப் ரிட்டர்ன் இருக்குது. ஸோ அதில் ஸ்பெசிஃபிக்காக இருக்குது, நீங்கள் எப்போ கட்டுறியோ கிளைம் பண்ணிக்கலான்னு. எம்ப்ளாயீஸ் கான்ட்ரிபியூஷன் அலோவ் பண்ணதே கிடையாது, அந்த டியூ டேட்டுக்குள்ளே தான் கட்டணும் நீங்கள். ஸோ டியூ டேட்டுக்குள்ளே இஃப் யூ டிலே 1 day, தட்ஸ் அவுட். தட் ஷுட் பி ட்ரீட்டட் அஸ் இன்கம். ஏன்னா இது இன்கம். 43Bயில் யூ கேன் கிளைம் எக்ஸ்பென்சஸ் அலோன். ஸோ அதுக்காக தான் நான் சொன்னேன், இன்அட்மிசிபிள் நீங்கள் ஆட் பண்ணாதீங்க, இன்கம் கன்சிடர்ட் செப்பரேட்டில் போகணும் அதை. ஸோ அதனால் 43Bயே எம்ப்ளாயீஸ் கான்ட்ரிபியூஷன் அப்ளிகபிளே ஆகாது. So once you add, then automatically, even if you delay 1 day, that employee's contribution is out. Employer contribution, okay, there is some judgment saying that before filing of before the due date it must be remitted, but some are saying that before filing of return it can be claimed. But in my personal view, before filing of return we can claim. In subsequent years also, as per 43B section, we can claim in the subsequent year also at the time of remitting the dues. Yeah. Thank you. Of course, it is a very small subject. I cannot go beyond this. Okay, sorry. Okay, bye. Thank you all.
Thank you, sir. Thank you for giving such a great lecture on labor law. Now we are going to, invite the next speaker, Mr. Ram K Navaratna. So, before letting him speak, we can have a few words about him. Mr. Ram K Navaratna is a postgraduate in social work from Karnataka University. In addition to his PG qualification, he is holding Diploma in Labor and Administrative Law, Diploma in Personnel Management and Industrial Relations, Diploma in Training and Development. He had started his career in 1982 as Personnel Officer and rose to the rank of General Manager HR. He has rich experience in mining, steel, transport, printing, engineering, garment, granite, food processing and pharma industries. He served in Sandur Manganese and Iron Ore Limited, Indo-Nissan Foods Limited, Hind High Vacuum. He worked in the capacity of General Manager at Sami Labs Limited. So basically we are going to have a person who has vast experience and vast knowledge and vast education. To his achievement, he is a successful HR practicing professional. He has also authored 11 books in HR field. And he has received recognition award from NIPM, Karnataka chapter, and few other bodies for his literary works of HR and labor laws. In addition to his authorship, many of his useful articles has been published in professional journals, and he is a regular writer in few professional forums and journals. Many of his talks are also broadcasted in All India Radio, Bangalore for industrial field. He is a member in ISTD Trainers Forum Bangalore, life member NIPM NHRD, ISTD Karnataka chapter, founder secretary of Kunigal Taluk Industries Association, member of FKCCI Federation of Karnataka Chamber of Commerce and Industry. So basically we have a member who has so much credentials that I am not able to complete in like 5 minutes. So let me call our chief guest, Mr. Ram K Navaratna, on the dais now. A strong big round of applause again. And I'm going to request our member CA Sriram sir to come on the dais to provide the memento here. Thank you.
I'm very happy to be here before this August gathering of Chennai chapter. It is my privilege, as already introduced, in Karnataka for the Institute of Company Secretaries, ICA chapter of Karnataka, Hosur and some other chapters. For more than 2 decades, I am a faculty and resource person in labor laws. Particularly for the study circle, I have taken a lot of classes. But first time I am coming to Chennai. I don't know how they got the name. Maybe institution is a universal and a great institute. So it is my pleasure to be here. The topic given to me is contract employees and employer obligations. Dear friends, and this particularly as my previous, some of you, can you come forward? Lot of seats are empty. Backside people, please come so that it will be better. I think some of you can occupy. Lot of seats are there. Okay. As my previous speaker told about contract labor also. As far as the labor law is concerned, like your taxation laws, so as like taxation, labor law is also, particularly again in labor laws, there are about 14 to 16 laws for any shops and establishments or factories act is applicable. Particularly for my chartered accountants fraternity, I tell you, other than you are doing a human's job in all taxation, provision, finance and all that, about these 14, 16 laws, due importance has to be also given. Otherwise, the employer is going to be trapped if there are any employees issues. Government they can manage, no problem. All of us are expert in managing government officers, authorities. But when it comes to the employee issues by union or any other thing, then we can't answer. So therefore, due importance has to be given. Even under the labor laws, we make three provisions: serious, medium, and mean importance. Serious means like Factories Act, Minimum Wages Act, Contract Labor Act. Okay. Some of these like Factories Act, Mines Act, same way Plantation Labor Act, what we call regulatory laws. They are all very serious laws. Medium, okay, like Payment of Bonus, Maternity Benefit, Industrial Employment Standing Order Act, okay, Labor Welfare Fund Act. These are all medium. Mean, like Employment Exchange Return, Apprentice Act. They are all mean. But particularly what I mean to say, serious acts, there employer has to give a little attention, and you finance professional has to also give due advice to the clients. So the friends, what I mean to say, contract labor is also one of the very serious act as far as compliance is concerned. It is a regulatory laws like Factories Act, where it regulates the employer-employee relations, conditions and compliance laws. So with that angle, now I am going to present. I have made my presentation in three formats. Number one, first contract employees, employer obligations. Employer mean what? I am not talking contract labor here. Contract employees I am talking. Supposing Navaratna, you want to hire me for 1 year or 2 years or 3 years, some X project or X marketing project or something very special thing you are hiring me. On contract you take, where you deduct TDS and all that, may or may not be whatever, your ways are there. That I am talking contract employees. That topic is not given to me. Since it is mentioned, principal employers obligations, I thought let me cover that way in before my core subject of contract labor obligations, employer obligations. So first part I am taking this. The second my PPT is on contractor employees, principal employer obligations. The core topic which is given to me, which you all must know. It is not that you know, but I am insisting more importance and trying to trigger your thoughts on that matter. Okay, where you have to give really due importance you have to give, and what we say, good corporate governance to be ensured. And in the third part, what I have taken after all that, with now as my previous speaker also told, labor codes. Labor codes are going to come. Now still they have got all the pains. Okay, already baby is delivered and all that, only naming ceremony we have to make. Though it is passed in parliament, though gazette is made, we are waiting for the enforcement date. Otherwise, almost all states have already devised rules. Acts have been passed, including Tamil Nadu. I think they have devised already rules. Once it comes, labor codes are going to come. Wherein my previous speaker said 50% should be the basic. In that, all that, that is the constitutes in that code of wages, 50% should be the wage in all the parts. Where now we are all employer telling it is a liability as far as PF and gratuity is concerned. Anyway, that is subject. My last part, what are the principals employers obligations under the contract labor and the labor code also? That is my short presentation. My friends, these are the three menus I am giving you. In that, now I want to take you to those presentations. My friends, all of you are here? Not physically. All of you are here? Okay. My dear professional friends, each trainer or each presenter, they have got their own style, okay, and own system. And I have also got my own style. I am a trainer also, because I am very passionate about training. Because I travel across India, I speak Hindi, English, Kannada, and I have got, apart from HR, labor law program, and I do a lot of training program at various levels. Earlier also for the All India Manufacturers Organization, Tamil Nadu also I have done a lot of labor law programs. Okay. what my various methodology in conveying the subject. Number one, first methodology is clapping. Okay, I'll show you. That is one of my methodology which I request all of you to follow me throughout this session. Number two, in between small 1 or 2 lines of rhymes I will say. Entertainment, engagement as well as enjoyment, because I have to hold your interest. Now lunch is fast approaching. After lunch also I may continue. I have to hold and make you to sit also. Man. So some exercise also and some meaningful. Okay, those are my 2 styles. I hope all of you will follow me. I hope you will not mistake me but enjoy. Okay, I will make you enjoy. Number one, first clapping I will show you. First I will show you, then throughout the session whenever I make like this you have to clap. Agree? All of you are agreed? Okay, I will show you first. 1, 2, 3. 1, 2, 3. Third one, Joseph. 1, 2, 3. Like this, you have to clap. Okay, all of you are ready? Please sit straight. Please sit straight. Loosen your body. Loosen your. Yes. 1, 2, 3. So some are not still shy. Yes. Please hold on. Thank you very much. So when you clap, I hope now you have got all your palms are burning. This burning is nothing but a blood circulation. Nothing but people who have got BP, people who have got anemic patient, if they stand and clap daily like this more than 100 times for 6 to 8 months, many of these diseases have been withered away. In some of the cases they have vanished. This is told in the Ayurveda Shastra, not by Navaratna. Therefore, my dear friends, today throughout the session, I am providing you a good health without bill and pill. Okay? I am giving you without bill and pill, but only thing you have to clap without shy. Remember your LKG, UKG days, okay? And remember, okay? I hope you do that. I hope you enjoy. Now one small rhyme I will say, everybody should chant after my telling, okay? This is entertainment, exercise, because otherwise, why I make all these things, labor law is a very, very dry subject, okay? Labor law is a very dry subject, nobody will enjoy. Particularly you finance people can not enjoy also, but I have to make you enjoyable. Because having got thing, I have to make, okay? That is the whole idea. Okay? Now I will say, you have to say, listen, listen. Everybody should chant. Listen, listen. Full listen. Without listen. Don't talk. Perform, perform. What you listen. Record, record. What you perform. 1, 2, 3. This rhyme is nothing but a effectiveness of listening. In our HR we say a good manager is one who is a good listener. If at all a professional want to be successful, he should be a good listener. Okay? That is the whole idea. Even in our home, we forget our spouse, we forget our elders. Whenever they are talking, I have a listener, chuka. Yes, yes, I know all that we say, but we don't listen. But by not listening, we may end up in problem. So that is the importance of listening. Like this in between, I may tell you the rhymes. You should all cooperate with me. Okay? Is that okay? Yes. Is that okay, my dear? Okay. Now, well, this contract employees. Okay, what is this contract employees? Please remember, so far my previous speaker they are contractor employees. Now I am not talking contractor employees. Now I am talking contract employees. Okay, so that you please. They are known as independent contractor or temporary workers. They are individuals hired for what? Specific duration or project under a normal agreement. Normally many of the companies they do not. Even most of the multinational companies also, okay, now they say outsourced. They are consultant or various guys they are contract employees. Unlike full-time employees, the contract workers are not considered as a permanent staff because they are governed by the contract. Whatever that will be stipulated under that. And usually they don't receive the normal benefit whenever they hire the contract employee. But however, in spite of that, when the organization hire, still they have certain legal and ethical obligation on them. Towards what? Contract employees to ensure what? Fair treatment and compliance with applicable labor laws. That is where all the responsibility of employer and employee comes as far as contract employee is concerned. Let me give you quickly. For such employees, what are all the obligations? Compliance with employment laws. What is employment laws? Law of contract. Okay. Law of contract, we say there should be an agreement. In turn, for that there is a consideration. Then there should be terms. Then should be terminations, etc., etc. We are doing law of contract. So organization should what they have to do? Adhere to local, state or central laws governing whatever the contract employment are there. So therefore, whenever you make anything, if you have any specific, you have to say. Like that, as I know, in Tamil Nadu also there is one permanent something law is there. Appointment of some permanent something temporary casual, some appointments for certain period if they acquire, then they become permanent. Some law is there. Now I have forgotten that terminology. And these law may change from jurisdiction, but they generally cover minimum wage, working conditions, health and safety, and also the appropriate applicable tax laws for these employees like TDS and all that. You make health and safety everywhere that will be there. Leave provisions will be there. They are all common. The reason being they are human beings. Okay. Ultimate, the topmost importance is apart from productivity, major activity, humans should be taken appropriately care. Then next, clear and detailed contracts. Even my previous speaker was telling, anything you make, document. Whatever you make the document, there should be a document. Even in fact, to add to my previous speaker's one point, whenever an employee joins, we take Form 11 for any employee provident fund. Whether I was a member or not member, had I been a member, Form 11 declaration has to be taken. Because that constitutes most important document in provident fund, particularly for already non-members and members also. So like that, one of the documentation, employer he should draft very well the defined contracts, outlining what are their duties, responsibilities, terms of employment, including what? Duration of the contract, very important. There no liability all comes, scope of the work, what is the scope of the work, then compensation structure, how that will be there, then termination clause, naturally should be there. It is not like a Hindu law of marriage. Okay, divorce cannot be done once it is married. But here it should be, termination clause should be also there. Then confidentiality agreement. Most of the companies, because of the product or R&D nature or whatever that will be there while in the work, they acquire certain confidentiality. So therefore, confidentiality agreement, if applicable, all these have to be drafted in that contract employment. Care has to be taken. That is number 2. Number 3. Next, payment and compensation for contract employees. Maybe senior employee may be there, or retired employee may be there, or some expert may be there. Then contract employees must be compensated according to the agreed terms. Whatever the term is mentioned, openly or expressly, they should be complied and they should do timely payments. Timely payments are very, very important. Even in PF we have seen earlier, if contributions are not paid in time, what happens? You are all away. Even what is that SC audit, something you say, there also is now obligations of all the chartered accountant. Other than that, go and see. Beyond they have to see, otherwise it will be disallowed or they will be questioned why you are not seeing, including environmental laws. Today, your responsibility and your purview has been grown very widely. And reimburse agreed upon expenses. If there are any expenses are agreed, that one. Then clarify tax responsibilities. What is that tax to deduct or not deduct and all that. That it may be for their own taxes depending on jurisdiction. So this is also one of the important aspect of that. Then next very important, workplace and healthy safety. This is all very, very important. The employer it is the duty of the employer to provide safe working environment even for the contract workers. Very, very important. Then it includes adhering to occupational safety health regulation, what we call OHS, because health is applicable for everywhere, whether it may be sitting size or smelling or inhaling or seeing computer or working on any machine, okay, whatever that will be there. Necessary safety equipment and training depending on the job. Ensuring contract employees are aware of emergency procedures also. If the organization is hazardous, then it is a mandatory to have a crisis management. You are all aware. On-site emergency or off-site emergency will be said, depending on the organization. They must be also aware, because accident may happen anywhere. In all such cases, what are their rules? They cannot be neglected, because their life is also important, failing to which obligation of the employer accountable, occupier is accountable. So therefore, health and safety is also very important. Next is non-discriminatory practices. This is all very, very important. Okay, nowadays almost most of the companies, they incorporate this law. Contract employees should be treated fairly, of course, we expect everybody. And without discrimination based on race, caste, gender, age, etc., etc. Nowadays it is all very, very important. Particularly the women employees, POSH is very serious, you are all aware. Okay, very serious act like the Contract Labour Act and the Taxation Law. Then employers should provide equal opportunities. They should not discriminate for any reason. Address grievances if there is effectively. Even my previous speaker was telling, insisted on HR policies everywhere. In HR policies, there should be grievance redressal procedure should be there. Only you cannot go on making the work only. There should be grievance. There should be somebody to address, even in our office. If it is more than 10-15 number, your office also needs some grievance procedure or redressal, including POSH. It is required. Otherwise, when it comes to the light, one should not open the eye. And prevent harassment or unfair treatment by employees. Okay, so that is also non-discriminatory clause will be there. Next important is intellectual property and confidentiality. This is also one of the upcoming subject nowadays, particularly where chemical industries, pharma industries, IT industries, their intellectual properties are very, very important. Okay, so organization require contract employees to sign agreements protecting intellectual property and confidential information, and these must define ownership of work products, confidentiality terms, outline restrictions on sharing proprietary information, etc. You being a chartered accountant or you being you come across so many things, you see the figures, confidentiality figure, PL, okay, taxation, hiding or manipulation. Whenever all those things will be there, what are all the outlines for protect? In fact, 2 days back I signed one contract because I am management consultant. I signed one agreement with one of my client company. They are into construction company. They build a big factory. In fact, they asked me to sign their confidentiality agreement also for me. Though I am a labor law, HR consultant also, because I do a lot of strategies and all that in HR. But they asked me to sign. I want to take as far as your product is pertaining to concern, yes, it is my duty to oblige. I should not deviate or diverge to anybody. That is important, protecting the rights I have to sign. So that is also one of the very important. Then end of contract obligation. This is the last point, very, very important. Because whenever anything has to start, it has to come to an end also. Whether it is retirement, whether it is termination, whether it is a separation, whatever that will be there, at the end of the contract, employer should provide proper documentation of contract completion. How it completes, when it completes, what are all the terms, whether age, whether project, whether time, whatever, or any assignment, etc. And also settle any pending payments. That is also very, very important. Because ultimately, payments matter a lot. Okay? Otherwise, relationships are going to be affected. And smooth transition of handover of work. That is also very, very important. Particularly where confidentiality, R&D structure, or any proprietary thing, and IT companies, wherever things will be there, handovering is mostly sales companies. They give mobile, SIM, so many proper laptops they provide, but they don't have most. They hand over most of the employees nowadays. They disappear. Suddenly they disappear, or they keep tomorrow morning onwards I will not come. So all these problems are emerging. So therefore, end of the contract, how they should be there, and conduct exit interviews if applicable. That is all very, very important. Anyway, relationship is going to end. How was my company? What was company? What is good? What is bad? What are your observations? What do you suggest? Okay, what is that we have to do? That is all helpful in so many ways, because it is introspection as well as we can take for development also. So that's what one has to do. Then ultimately to sum up, as far as the contract employees contract is concerned, they are not considered, but they fulfill their obligations to ensure what? Legal compliance, fair treatment, and positive working relationship. Ultimately what? It's a good place to work. Because employees are also ambassadors of the products. When we speak about good company, naturally, otherwise today, talent is not available. We are not getting employees, proper employees are not available. Then a well-structured contract, adherence to the labor laws, ethical employment, which is most important, practices, it is a contribute a productive and compliant work environment of the contract employees. So this is how, as far as the contract employees are concerned, an employer, whenever they take, okay, they have to keep it in mind. Anyway, this is not a new practice, it is existing. But of late, in the modern industry, appointment on contract employment is also most dominant. In Bengaluru, we come across a lot, particularly in IT companies, non-IT companies, startups and all that. They take all employment on contract too. Because they fear. I think this type of thing has come up in new labor code, that's called fixed term employment. Okay, in fixed term employment, employee is eligible for even gratuity also, whether it is 3 years, 4 years, 5 years. Okay, their terms are different. It has come in other format. Whatever, that is one form of the law, but ultimately what? Economy has to run smoothly, industry has to run very well, productivity has to come fine, ultimately income has to be generated very smoothly, meeting the requirements of the both employer, employee as well as the state. So therefore to do that, whenever there is this is one type of hiring the employees on contract basis, whether for skilled, unskilled, particularly for skilled, high skilled, specialized jobs, marketing, okay, senior consultants. For such type of people normally on contract that will be all taken, and employer has to keep these things in mind. Accordingly, they should draft the letter of contract, sign with each other, complying all these kinds of the law. So thereby, everything will go smooth, and entry is also beautiful, exit is also beautiful, and they can go very well, ultimately meeting the objectives of the corporation. So friends, this is what one of the contract employees. This is what one has to keep in mind. Now, having completed that one, now let me go to my next core area of the topic.
One question.
Yeah, just a minute, just a sec. Yes, sir.
All the industries employee attrition is very high. Is it okay to add a bonding clause that you cannot leave the organization for 1 year, 2 years, because I have invested a lot of training in you. Okay, is it looked upon legally or illegally?
Very good question. I really admire this question, because I also worked for 28 years in industry in a senior management. I was working for one of the US multinational pharma company. I was general manager, HR, and we had a R&D center. I was employing almost about more than 60 PhDs in my R&D. Now, one thing, whatever this kind of bonding you make, okay, then I change the terminology. I don't use the word bonding. I made use the agreement, gentlemanly or gentlewomanly agreement, I used to call it. What do I use it? There, you cannot say you don't join and do all that, it will be not there. But agreement will be for minimum 2 years or 3 years, because I am going to perform all this your training or investment or whatever that will be made. All that should be specified, and also those have to be carried forward. They have to be implemented. Proper documentation should be there. There, you can insist. And in case of any violations or infringement, definitely based on those points with the proper thing, you can file a suit. File a suit and you can get it. To give an example, in my company where I said R&D, because I was the HR head and all that, for all that the training, investment and all that, even we used to purchase equipments also, particularly on that technology and all that, expensive equipments, because they have to carry on all those research activities. We used to mention all that at the appropriate time and all that. These are the things you have done. You have gone for training, you have gone for a seminar, we have invested in these certifications we have made, this is the money we have sent and all that. We used to take, and normally, some people they don't care, they left also, but we filed a suit and I was grilled in the court by the opposite side of the advocate, how I did all that. Many of the cases I won. I won and the compensation they were able to pay. And those court orders I displayed in my company for the threat of the employees, if you do this, you are going to be there. Therefore, these follow. Of course, we cannot stop anybody going out. That is different. But some obligation, moral obligation. What your period I agree, that should be there. But one thing you have to keep in mind in that question, whenever you make such agreement, it should not be unilateral. Because going for employment, my choice is my right. My right, you cannot insist me. Okay, you cannot insist me. But it should not be single-sided. It should be on both sides. Okay, subject to that, yes, you can do that. So therefore, whenever such contracts are drafted, better to consult appropriate advocates, discuss, do that, discuss with the employees also in a fair and all that, make a documentation for that. Make a documentation. Even video conference, talking, doing, agree, date, whatever, minutes of the meeting and all that. So that if you make that one, your interests are to the extent they are protected. They are protected. So that's what you have to keep in. Any other question pertaining to this? Now I am going to the core subject of contractor employees and principal employer obligations. Any questions or any doubts? Okay, now I think one more line. Good, better, best.
Good, better, best.
Oh, I think all are alert. I am very happy that okay, it means I was able to hold it. Yes. Good, better, best.
Good, better, best.
We should never rest.
We should never rest.
Till our goal is better.
Till our goal is better.
And better is the best.
Better is the best.
1, 2, 3. Okay, thanks for all your cooperation and involvement. Okay, now the very important subject, and this subject is very serious. Serious, I mean, Contract Labor Regulation and Abolition Act 1972 something is a serious act. Okay, but normally most of the employer, contractor, they take it very lenient. That's the practice. But however, now since you are all very important with a lot of clientele, practitioner, and you are influencer of the industry as well as the management and employees, I think some of these things I am trying to refresh you. You know all that, but I am trying to refresh you and giving you the point of view, how that will be there and all that. My dear professional friends, one thing you have to remember in labor law is emanated from Constitution of India. There are 3 lists are there: state, central, state, and concurrent list in labor law. Central, whenever central government of India will make the laws, state makes a law, shops and establishment. Your Tamil Nadu permanent something like that. It is there. In Maharashtra, Hamali workers something is there. Okay, like that state can make the subsistence laws. Okay, these are all state laws. And concurrent list where state and central both they can meet. Both of them are the stakeholder. Like health, education, like that labor is also concurrent list. Therefore, state as well as central government they have the laws. So whenever you study any labor laws, apart from studying the act, parallelly you should study the rules also, respective state rules. If you are in Tamil Nadu, reference to that Tamil Nadu rules. If you are in Maharashtra, Maharashtra rules. Act is only the guidelines. Okay, it is hard. But how to go and all that is the rules. Rules give the ways to how to implement, how to follow, what is that you have to make, what form I have to make. Okay, it shows a path. So both have to be. If it is a central, Regional Labour Commissioner, Government of India, Assistant Labour Commissioner, bracket central, or Regional Labour Enforcement Officer, bracket central, he is the authority for enforcement of these laws. They are very strict compared to any state department. For example, mining, shipping, insurance, okay, and multi-state companies, they all come under the central act. Where no regional labour banks, they are all central. Regional Labour Commissioner or Assistant Labour Commissioner, Government of India will be the inspectorate or authorities like DDMS in mines, Director of Deputy Director of Mine Safety. Okay, and rest all is state. And in state, respective labor department depending on the state structure. So you have to go through the respective state rules also. Most of the rules are same, acts are same. Rules they may little vary. Rules they may little vary, form little may vary. Okay, some specifics may be there. With reference to that, then only your study and your understanding will be complete. Number one, the applicability. Contract Labor Act, when it is applicable, one thing my dear professional friends in all the labor laws, first, am I coming under the purview of these laws? This is most important question one should ask. Whether this law is applicable for me, am coming under the purview of that? First you must be aware. If you are coming, then naturally your compliance will start. If you are not coming, you will not bother. So, like that, Factories Act, 10 with the power, 20 without the aid of the power is a factory. If it is running for the manufacturing, ornamental and all, it is a fact. Maternity Benefit Act, 10 number of employees. It is employee only telling male or female, married or unmarried, it is not saying. Only 10 employees. Then 10 for gratuity, 10 number of employees. Okay, if that is a gratuity act is applicable. Bonus, 20 employees. With notification, 10 also will be there. Then only bonus act is applicable. Otherwise, I am not coming under the purview. Whenever you are making set on, set off, computation of the bonus and all that, you must be aware about all these things. In other words, what I am telling, just refreshing, in all the labor laws, first number is your head counts. Whenever any inspector comes, you ask, sir, how many number of employees are there, sir? Sir, how many number of contractors are there, sir? What is the number of labor they are engaging? They ask the first question. Because that is a decisive factor. Okay. With that, now as far as the contract labor is concerned, presently it is a 20 and above. If there are 20 and above employees are there in the establishment, then this CLA Act is applicable. Okay, it is a central act and all the states have got a rules also. Every establishment in which 20 or more workmen are employed or were employed, my previous speaker was telling any day, when it exceeds 20, PF will start. Like that here also. Okay, like that it here also. 12 months as contract labor, and to every contractor, same way contractor also, two things you have to understand here in this definition. One, for example, I am X company, I have got 3 contractors. One contractor has got 3 employees, one contractor has got 5 employees, another contractor has got 18 employees. It means I have got 3 contractors. 18, 5 or 3, whatever, all that constitutes what? About 20. As an employer, now that CLA Act, it is applicable for me. Then as a principal employer, as an employer, I have to start my compliance as an employer, establishment. The same way the contractor, any contractor, you may engage contractor, housekeeping, only 3 people are there. You may engage security people, only 4 people may be there. Okay, 4, 3, 7. Okay, you need not ask that contractor to have the license because that contractor don't have 20. But that contractor has got innumerable establishment. He may be employing 800 employees or 1000 employees. But contract labor, he has to obtain license for each separate unit. Each unit is a separate. So in other words, friends, what I am telling, Contractor Act is also applicable wherever he engages 20 and above work. So now we have to check. In my company, in my clientele company, other than regular employees, any contractor or any vendor, is he engaging or is he deployed 20 and above workmen? Whether it is staff or anything and all that, anyway, they are all there, workmen or semi-skilled, unskilled, whatever you say, are there. Or any contractor, whomever they have engaged, vendor, maybe housekeeping, maybe repair, maybe maintenance, or maybe gardening, cleaning, whatever you call, are they employing more than 20? If this is there, then no licensing and registration will start. That is the first parameter, which all of you must be aware and educated. So that is the applicability. Then once it applicability starts, then what happens? Then no documentation. That is legal shape has to come. Act applies to establishment with a specific number, then it can be by the. And one more thing, what I would like to say, in Maharashtra, number is 50 and above. And in new labor code also, it is going to be announced 50 and above. Now, since current law, I am talking, I am not clubbing labor code now. Okay, foreigner. Then principal employer must register under the act if it is applicable. This is the first obligation of the principal employer which you must do. Number 1 point, if I am coming under the 20, my first duty is to register with the labor department with the appropriate authorities. By submitting document, fees and all that, his name should appear, then first registration, then legal entity will start. Employer is protected. The same way, non-registration. Supposing you may ask, sir, what happens if I don't register? It will attract penalty. And a non-violation also. Tomorrow in your SC audit or something, this observation may also come, he has not complied with the law. As a CA, while conducting the audit, why you have not seen? Okay, that question may also come. So that is one of the point. That may be all penalties, etc. What is the penalty? I am not going to deal with that. Okay, so but it's a corporate governance. What I mean to say, today we are all talking of compliance. Most of the organizations are in compliance. Now it is not like earlier days avoiding and all that. Everybody wants to go with the law. Okay, nowadays lot of improvement is there. There is applicability. Now next is roles and obligations of the principal employer. Now the meanings of that starts. I am going directly into the point one by one, which you must be aware, remember, make a document, insist and advise all your clientele or your company wherever you are there. Under section stands and all that, principal employer, the government or local authority, the head or specific officer, who is the employer there is, in the factory is the owner, occupier or named manager is the responsible person there. In factories who is responsible? Occupier. Who is occupier? An occupier is one who has got ultimate control over the affairs of the company. MD, owner, manager to carry on day-to-day activities. They are the two authorities under the factory. Same way, shops and establishment act, other act, whatever that will come in mines. Just since now you are all labor law student, therefore I am telling owner, agent or manager. In mines act, he is called agent, not occupier. In factories act, we call it an occupier. In other establishment, any person responsible for supervision and control, proprietary organization. What he does, proprietor, supervision and control. That is the job of the thing and all that. So they are responsible person. Now first I say what is applicable. Second I say who are all responsible persons. These persons are ultimately liable for any legal prosecution or accountability. These are the persons held responsible. Okay. Now next, what are all the obligations? Various obligations and responsibilities are there, which one must be aware. Number 1, in view of various judgments, innumerable judgments are there, so many books are there, lawyers are making money in all that. Okay, and while engaged in contract labor through the contractor, some of these points, my dear friends, obligations are to be covered. Keep in mind. Number 1, the establishment in the first instance should ensure they got a registration certificate from the competent authority as provided before engaging the contract labor. Employer, whatever, establishment, 20 and above. You may be having 10 contractors, but all put together, if it is less than 20, don't bother. 1 or 2 or 3, 4, all that together, it exceeds 20, all their names have to appear, you have to take the registration, then you are compliant. Otherwise, it's a thing. Then, establishment should ensure that they issue, suppose now, the employer over them, contractor, labor contractor, he has got 25 persons. You are going to ask them tomorrow you engage 25 women. I need all agarbatti factory. I want to make tagging. I want to engage female only. I want to engage female because I want to provide employment. Then he has to take the license. Why? Because his number is exceeded 20. So to obtain the license for him, we have to provide form 5. Principal employer. There is a form called 5. If anybody is doing, tomorrow when you go back to your work desk, please read that form 5. What is that form 5? Very important. Such is, this is all, this size is, this is all. Only this size is, but you have to read. There principal employer is telling, I am responsible for the entire compliance of Contract Labor Act A to Z. For this contractor in case of his failure, that is what undertaking he gives to the labor department. Based on that, labor department will issue a license. My dear professional friends, what I am trying to drive the message in your is, when you issue the Form 5, it is a principal employer's obligation to see that all that law is followed in act and spirit. In act and spirit. Just by giving the engaging contractor as a principal employer, he should not forget, no, I have already outsourced. No, any contractor is there, no, you will do, why I should bother? No. Because in case of any of his failure, it will come to your head. So therefore, you have to keep in mind. And that's what Form 5, this is the first responsibility. Then it must be ensured that contractor who is going to employ more than 20, he has to obtain a license. Two things you have to keep in mind. I am making it very simple. The employer's document is called registration. Contractor's document is called license. Don't say license for both. The employer document is called registration, RC. Contractor is called his license. Okay? Just keep in mind. It is not very, very difficult. Just I am enlightening you for that. Okay? Valid license, okay, by the appropriate authorities. Normally the respective state department, labor department will issue in central, okay? In state, they will issue. Nowadays in all the governments, everything is online with the due forms, registration fees, particulars, form and all that, they will get the license. Then, next, payment of wages to the employees. Employed by the contractor is most important aspect. Ultimately what? We all work for the salary, you know. We all human beings work for what? Something return. Something return. So whatever that thing is there, earlier days, of course this is old act, while disbursement there used to be a lot of cheating used to happen earlier days because it was all cash payment, benami names and holding the money and harassing the women, okay, all that were there. Therefore, while disbursed to the employees by the contractor, before the payment, there was a law that the employer representative should be there in the presence. In his presence, he should be disbursed. And for having disbursed that, the employer representative has to sign. There is a format is also there, I am going to show. He has to sign and put the date. In my presence, salary is disbursed. Okay? So that's what, and the payment registered in token of having disbursed salary in his presence by the contractor. Because earlier labor were not so smart. Of course today now labor are more smarter than us. Okay? They are more smarter than us. But anyway, nowadays everything is bank payment only. But even then when you make the bank payment, take the bank statement and below that at the end of the month, yes, salary payment is made to the bank and we confirm hereby, put the seal and signature. Otherwise, some of the recalcitrant inspectors may come and ask, sir, this is not there, sir, then all unnecessary arrest you for nothing. You have done your duty by paying the thing and all that. But anyway, ultimately it is a documentation. Documentation is most important. Even in ISO means what? ISO is nothing but a document. Document, what you say you do, what you do you write, what you write you follow, what you follow you write. That is only the ISO. ISO is nothing but a documentation. I hope you will all agree. And not only that, as an HR and as an auditor, because I am a labor law auditor also, I conduct a lot of audits for various companies in HR and labor law. In the absence of any document, it is as good as not done. If document is not there, in the absence of document, it is as good as not done. Yes or no? I want to give one example. I worked for a Japan company. Top ramen. What is top ramen? Noodles. You might have heard, all your children may be ramen. I was personal manager there. It was a Japan company. I was heading HR. And I was a power of attorney holder to sell, purchase the company also, those days. They gave me power of attorney because head office was in Japan. So then my MD used to tease us. Ram, what yaar, in your company pollution. Irrespective will see the paper and he will say go or go. But book, all that will come, but he will not see certificate if it is there. He will ask to the what country are he used to say exactly. In documentation for pollution, document was there for pollution, but smoke used to come. It means just those smoke used to come, but document was there, so irrespective used to. Okay, friends, why I give this example? If it is a document, then nobody can catch you. If it is Aadhaar, today what's your name? I will not register, but show me your Aadhaar. Then even in airport, what do you do? Navaratna, they will see the face. Oh, then you go, they will say. No? What I need to say? Importance of document. Of course, particularly you are all audit people, you are all finance people. Whatever you do, ensure documentation. Even in safety management is also very, very important. factory inspectors, labor, they file the case. But if you provide proper documents and show, what is that you have to do? Beyond the control, I have taken all steps in implementing the law, taking care of the employees. If you prove that by document, then you are not going to be prosecuted. Even if you are prosecuted, okay, penalty will be not there for you. I am telling you. I am telling you. In all the laws, of course, in taxation and income taxes, without documentation, nothing is there. Because everybody is claiming because it's a money, because it burns. Whereas in labor laws, it will be not there. But documentation, that's what you have to keep in mind. And next, there should not be any supervision and control by the principal employer. Very, very important. But normally, practically what happens? Everything principal employer will only do. Why? Because that contractor is a brother-in-law of his wife, MD's wife, or MD's native place, or MD's classmate. Therefore, he has become the contractor and everything in the principal employer only will do. Billing, paying, doing all his headache, he only his HR has to take. Naam kya vaste contractor. That is called sham contractor in labor laws. Supreme Court has charted. Sham contract is a wide. That's what Supreme Court has said in one of the cases. Therefore, don't do that. Okay. So, therefore, control and what I mean to say, supervision. At the end, what is control I say? In respect of employees employed by the contractor to fulfill the obligation of the contract. Then you may ask me a question, what Ram, you are telling this is silly, how we can do for that? Today manpower is very difficult, everything is cost. You people say cost, yeah, here's the cost, I have to reduce cost. Otherwise my client will not listen to me. Then you know all that employer should, there should be one supervisor. Through that supervisor instructions has to go. Supervisor has to do, he should be in between. He cannot call directly, speak, give, order, control, it should not be done. Okay. In case of any disputes, this issue will come. Otherwise in normal thing, nothing will be there other than safety. Other than safety health, okay. There you can do because you cannot wait for the safety. It may be time. Okay, that time, oh, I cannot do, you cannot say. Okay. Or he is working, wrong thing he is doing, you have to stop. Because it is a health and safety. Next. The work of which contract labor is engaged is not of perennial nature. Very important. It means what? Contract labor has to be engaged for non-allied work or non-core areas. Now you may ask me, what is core area and non-core area? Core area is what? For example, I am R&D. My core area is R&D only. For example, I am a piston manufacturer. My manufacturer is piston manufacturing only. Or I am a pharmacist, pharma company only. That is my core area. Rest all housekeeping, contract, loading, unloading, or any other thing, whatever that comes, they are all allied job. Core area means in other words, and the absence of that, operations will stop. I think more than that I cannot give any explanation. That is a core area. In non-core areas, you have to engage the contractor, not in the main area. That's how the labor department will also not give you the license. For everything they write different, because hand in gloves with the labor department. Okay, something they do and something they write administrative work, or technical work, or maintenance work, something like that they provide, but there should not be any supervision and control. Perennial nature should not be. Next, discipline of the employees of the contractor. Very important. He should not admonish. He should not admonish. He should not warn. He should not issue any letters. He should not take any disciplinary action. Contract. Why? Contractor is the employer. He has to tell to the contractor, internal contractor has to take. Of course, we may be all Sutradhara. As a principal employer, we may be Sutradhara. But directly, we should not. Directly, we should not do that one. Okay? So, contract in discharge of duties must be regulated by the contractor and not by the principal employer. Very difficult, huh? What sir, we are all doing contract is everything, we are only doing non-Kavase contractor and all that. Now you are playing on, then we can't run the industry. Okay, you run. But when problem comes, all these will remember. All these things will not come to the remembrance. Okay, that's how we see. My duty is to enlighten you. My duty is to enlighten and caution you. These are the things, be aware. Accordingly, you take steps and do that one. Okay, next. Contract should not specifically number the number of persons, but it will quantify the work itself. For what work you are taking. Manpower may vary. Male, female, number, maybe seasonal, non-seasonal. Okay, that may vary. Then leave to the employees of contractor must be sanctioned by the contractor and not by the principal employer. You should not sign on any new paper. Orally anything is all right. But you should not sign or regulate. Okay, I'll ask my manager, I'll ask my thing, then I'll ask the owner, boss and all that. No. Contractor employee, you should not do. Regulate through the contractor. No advance should be paid by the principal employer to the contractor's employees directly. Only contractor must regulate the same. But from where contractor will pay? Any contractor will pay? Ultimately he will come to you only, sir, I am doing your work, you pay, sir, ultimately. Okay, ultimately we have. Just I want to give you one example. I was general manager HR, I said, one of the pharma company, US Fish company, Sami Lab Limited, which is a US manager. I was general manager HR. Okay, before starting my consultancy. In the Dasara time, we used to give sweets to all our employees. Anyway, that's a custom in South India. Everywhere we provide sweets, So I had 300 contract laborers in my factory, in one of the factories. Okay, and whenever we used to bring this sweet box, for all my regular employees, I along with the unit head used to give and provide. Contractor 300 employees, what I used to do, I used to call those days contractors those days, make a provision in the canteen, you used to keep all the boxes there, contractor you come and disperse. That day and other than billing days, only these 2 days this contractor used to come, other time they never used to bother, okay, those contractors. But I made to distribute the sweets through the contractor one. And accordingly anything is there because I used to do, because contract labor is nothing but hire and fire. If I want to fire, it's easy. I should not take burden on my head. I should call contractor, tomorrow no work is there, you reduce 50 number. Because it is contractor's headache, not my headache. Otherwise people will come and stand before me. Sir, I am poor, sir. Sir, please help me, sir. My wife delivery is there, sir. My mother is sick, sir. I want employment, sir. My marriage is fixed, sir. If you remove me, then what happens? People will come and stand before me. These are all human problems. So, please ensure it means by doing that, friends, what I am telling, contractor should have the accountability. What I want to establish is, one thing, I want to save my skill, no doubt, as a principal employer, but ultimately what accountability to the contractor should be there. Okay, so that is what the thing of that. Next, maintenance of all types of records in respect of the employees employed by the contractor, by whom it is his responsibility. Principal employer should not intervene in the matter at all. Friends, in many other companies, I have, because I am auditor also, I conduct HR and labor law audits. Okay, so whenever I go and see, all this contractor's job will be done by the HR or MD or commercial man. Sir, that contractor what to do, sir, he will not listen, sir, he is very close to our MD, he is the localite, sir, we cannot do, he is the employer, we are employees, we are under his obligation. They only do everything wrong. Because in many of the cases, court has said, no, it is all sham. It is all sham contract. And if the establishment is covered by under PF and ESI, okay, even my previous speaker was also telling, very serious laws. PF, ESI are very serious social security laws, number one. And also we need, because they take care of the employees. And they indemnify. So they must be covered compulsorily. Of course, nowadays Aadhaar, UAN number, employers are also enlightened, contractors also inside, everybody, compliance are improved, no doubt. But even then, thing is there. Therefore, whenever you are employing any contractor, always I advise you, hire valid vendors. Valid vendor means what? Who has got GST, who has got shops and establishment license, who has got the PF, who has got ESI, who has got other certifications as required under income tax, etc., etc. You engage only such vendors, so that your responsibility, your headache will be not there. Otherwise, in case of any failure, it comes to your head. Okay, you have to waste your time and energy and money and all that, and ultimately, okay, your management will blame you for that. And to ensure compliance of the obligation pertaining to the various provisions regarding amenities and benefits as prescribed under the Act. That is also important provision of the Employer Act, because the principal employer has to regulate that. Now one more right I will say, everybody should stand. Labor law compliance, a bit more fun. Labor law compliance, right.
Rights in place. No worker dismay. Follow the rules. It is all okay. Keep compliance. Make the pay. Fair week, fair work all the day. Work with no delay. Rights in place. No worker dismay. Follow the rules. It is all okay. Keep compliance. Make the pay. 1, 2, 3. Okay. So all the records, okay. Principal and this I have already told. Okay. Now, what are all the amenities that principal employer has to provide? What are all the obligations? Let us see that one. Number 1, to ensure submit annual report to the prescribed authority. Annual return is there online. Principal employer under this act, one return. Annual return is called on or before 1st February. Online it has to go in all the states. In all the states. Central, state. Okay. He has to do that one. And he has to submit. Otherwise it is a non-viable. Whereas contractor has got 2 returns. Half July and January. And he has to submit and make a copy to the inspector as well as to the principal employer. Whatever contractor does, you keep all the documents with you because ultimately you are responsible. Then certification, I said, certification should be like this. Record of the authorized representative of the principal employer shall record under the signature certificate certified that the amount shown in column so and so has been paid to the workman concerned in my presence on so and so act. Okay, like this, he has to write, put a seal, signature, time and date. Even bank payment statement and then you ensure. So that at least that day you will see whether it is done or not done. Otherwise during only audit time or any inspection time, one will open their eyes. Okay, at that time blaming will not help. Okay, next. Then what are all the obligations? Then welfare and health of the contract labor, very important. What are all? Number 1, canteen 100 or more workmen. If there are employees or workmen are more than 100, then canteen is a obligatory. Even under the Factories Act, 250 and above. Okay, if it is a factory, 250 and above, like that in all the laws I said, there is head counting. This is not labor law class, I am not going into the detail, but just I am telling you. Then restroom. Restroom with sufficient light and ventilation and shall be maintained clean and comfortable condition. But my friends, as an auditor, I have gone to the many companies, I am seeing. In fact, next week I am conducting one audit in Bangalore in Tumpur near Bangalore, one of the companies. All these restrooms, in the many of the companies I have seen, they are very dirty. They are very dirty, unhygienic, not maintained well. Naam ke vaste it is all done. Very bad. In all such cases, whenever I have come, then I got the occupier, managers, owners, I showed them and I have taken to the task for them. What is all this? Why can't you do this one? Ultimately, man has to live hygiene. Hygiene starts from everywhere. Health starts from there. Okay? Do it to maintain well. You should not discard. Because health is important for whoever it is. Okay? That's what. Then other facilities, wholesome drinking water at convenient place. Of course, water has to be provided free. Where? Getting water is a fundamental right. Okay? Even in Rajasthan and all that, whenever we go, they provide first glass. Even Marwadi companies, they provide with glass water. Why? In Rajasthan, a lot of it is there. That is how their culture. That is how their culture. Okay? Drinking water. Then, sufficient number of latrines and urinals with the proper sanitation. Again, here is a problem. I have come across worst candidates. Stinking, flap, going, doors are open, no boards. Okay? Nothing will be there. Very badly made. So, employer, contractor, we compliance people or auditors, once in a while, we should ensure. Because ultimately what? What our Veda says, Sarve Janaha Sukhino Bhavantu, Samasta Lokan Sukhino Bhavantu. That's what our Vedavani says. Our aim is not to harass or not to point out anybody. Pointing out is required for the improvement, not for any criticism or any of these things. Then washing facilities. So these are all the obligations of the principal employer. If the contractor fails to maintain all these things, then the principal employer has to provide and debit to his account. That's what the law says. The employer can debit in case of the failure of the contract. But nowadays, what happened? Talent crunch is there, people are not available, everything the employer is doing, they want to make best factory, best thing and all that. Okay, days have changed, I am not telling good. But even then, okay, some percentage is there. So that's what, these are all the facilities that principal employer has to ensure at his place in whatever that will be there. Then first aid facilities. Anyway, first aid box is available everywhere because accident may happen any time. It is particularly manufacturing. Then possibility of accident, injury may happen. If women are more, normally they will get giddiness, maternity period time and all that. They get lot of problems and all that. That all such times something should be there. Okay. That is why the first aid box readily accessible during all working days. First aid box equipped with prescribed contents in the first aid box. It should not be medical shop. One thing you remember, first aid box should not be medical shop. In the some of the companies I have seen, it has become medical shop. Why? Sir, headache. Sir, this is gale mein khich khich kya karu? Sir, my pain is going to give Amrutanjan and all that. It is not medical shop prescribed. Then, trained person to be in charge of the first aid box. Why trained person? In case of accident, for example, heart failure or any suffocation or something ailment, then trained person will give first aid, it will be effective. It will avoid further precipitation. That's the whole idea. A person in charge of first aid work shall be establishment where number of contract labor is 150. If they are more, then they should be trained first aid person should be there. And this training will be given by St. John Ambulance Bureau all over India, and their certificate is valid certificate, and that will be accepted by all vendors, customers, government. You have to ensure that one. In the absence of that, government medical officer who will be there, that will get and keep that one. Make your organization strong and pakka and avoid any problems. Okay, then liability of the principal, then amenities of the above, whatever that will be there, they are all for the benefit of the contract employees. Okay, and all expenses, this I have already told you, should be borne by the contractor. In case if it is not done, then principal employer has to debit and pay. That is a thing, it is all there. Then what is the problem? Then what is all problem? If at all your organization has to generate good revenue, good income, uninterrupted thing and all that, people should be happy. People should be happy. People should be satisfied. Satisfied employees rather than happy. Happy may be very difficult word. We cannot make anybody happy. Even God also we cannot make. But satisfied employees. Okay. So that is the whole idea of that. Then respond. Next very important aspect is payment of the wages. Very, very important. This is a crucial area. This I have already told you. It has to be paid. It has to be paid in presence of the principal employer representatives, certified, and also correctly should be paid, and also in time, on or before 7, where there are less than 1,000 employees. Where there are more than 1,000 employees, on or before 10th, that is the law under the Payment of Wages Act. Okay? So that we have to do. He has to pay all that duty of the representative to ensure right payment. And disbursement of the wages in presence in the case of contractor fails to make the payment. Normally they will make. Though you pay the money, they don't do because they disburse in other areas. Okay, then your labor will suffer at your unit. Then you have to make the payment, ensure, and all that unpaid wages also there. Principal employer has to ensure that it will reach right place and right hand. Okay, and in case if a contractor fails to make the payment or even the short payment, it is the principal employer's duty to do good of all that. Sir, with all these things, do you want to engage contract labor? Do you want to engage contractor with all these things? Anyway, principal employer has to do, instead of that, just third, buffer, okay, contractor we have kept and we are running the show. Okay. Anyway, display the notice regarding the rates of the wage, hours of the work, etc. in English and vernacular language. And that copy has to go to the inspector under acknowledgement. That is a compliance. And if it is mixed up all language people, because nowadays in most of the companies, northern Indians people are coming, Biharis and all that, because local people they don't work or they are not coming. Everybody has gone for IT industry, IT-BT industry they have gone. Okay, everybody wants to settle in metros only. Now in that case, majority of the people, what language they understand, that language should be there apart from the English. Okay. First is vernacular language, whatever that state will be there, that should be there. Notice showing the rates of the wage, all that, and name and address of the inspector, that should be displayed on the notice board, copy has to go. Why? Worker has to complain, in case the employer don't do. That is the whole idea. and English and local language and work or near the site, it should be there. This is another obligation of the principal employer, very small, but no, we don't care, we don't do that. Oh, work is going on, no, take it. The notice shall be correctly maintained in clean and legible condition. But most of the time, whenever I go to the audit, I'll see a lot of half kg dust will be there on that. Some rainwater will be there or in a teared stage and all that, you know. Even on GST certificate, on owner's face only, dust will be there in GST certificate. Very shy, very, you know, very bad, you know, all that. Sometimes it should be all cleanliness. Because our life says cleanliness leads to godliness. Okay? All our says cleanliness leads to godliness. That cleanliness should be there. Copy of the notice shall be sent to the inspector, okay, and shall be communicated with him, and that should be kept intact in your file for auditors, for government officers, compliance, etc. My dear friends, whenever any foreign auditors will come, regulatory authorities will come, they see everything word by word, paper by paper, inch by inch. Okay, particularly the foreign customers, because I go to a lot of companies, international companies, foreign companies, pan-India companies, all these compliance are very intact. Inspectors, they don't have any job. What inspector cannot do, all customers have done. They insist. They will be all in the compliance. Okay? There is no way to find out anything and all that. So anyway, it is a pride. These are not very big thing in my opinion. Only thing what we have to make, we have to keep one good guy to maintain all these things. But the thing is that guy should have the brain. Okay, if that guy has don't brain, then you know it will be all disastrous. It will be all disastrous. Okay, that is what my experience. Therefore, hire proper people, competent people, train them and keep them. Next, every principal employer of registration shall annually file a return. That is the number. Okay, earlier I have showed that is the number. Not later than 15th February. It has to go for all that. Then another one obligation is principal employer. Whenever any operation commence, notice of commencement. Whenever closing, notice of completion. Okay, notice of completion. All the commencement and it is not closure. Okay, it is not, I am not telling closure. Completion. Commencement and notice completion has to go under the acknowledgement. That has to be maintained intact in the file. Intact in the file. That is another obligation for all that. Okay, then power to call for information. And the next step is the board, committee, or the labor commissioner, inspector, any authority shall have the powers to call for any information, statistics in relation to the contract labor from any contract principal or any other time by order in writing. Now in Karnataka, they have made a gratuity compulsory. Compulsory insurance they have made. Of course, it is in the act since 1972. Like Andhra, some other governments have made in Tamil Nadu, what is the position, I don't know. Gratuity they have made compulsory insurance. Because of that, now ministry is calling all contractors, everybody's information from all the factories, even petty shops and all that, they are collecting. Like this, whenever any government calls for, even National Sample Survey of India, NSS, I think you are all aware, they take a lot of statistics for planning commission. So they will also see. Any person called upon to furnish information and shall be legally bound to do so. Okay. So you have to provide the information. This is one more important of principal employer. Then these are all Form 1, application for registration of the staff, that's for your information. Form 2, certificate of the registration, what I said in the employer's thing. Form 12, register of the contractors. This is the main duty of the principal employer. Register of contractors, Form 12, he has to maintain, that is mandatory. Whenever any inspector comes, whenever I go for the audit, first I go directly to the HR or commercial, whatever department, I'll ask, give me register of contractors, first I'll ask. Then I'll see if it is maintained, then I'll go around the factory site, go 2, 3 toilets I go, restroom I go, workers I talk, shop floor I'll go, gates I go, everywhere I go and see and all that, talk and all that, assign the information. Then, you know, I go to the record, talk to the concerned, then I compile my report. Okay, whatever that will be all there. Okay, so register of contractor is also one of the mandatory things under that. Okay, that also you have to see. So thus ultimately these are all various compliance responsibilities or the obligations of the principal employer. Now ensure that there is no notification. One more important. While employing contract labor, you must see it should not be prohibited. Okay, in Tamil Nadu, certain operations are prohibited long back. Okay, in such areas, you are not supposed to engage any contract labor, otherwise it becomes null and void. If prohibition is there, you cannot engage contract labor. Okay, there you have to engage regular labor only. That way, principal employer has to be aware and check and see that. Only contractors to be identified who have their own independent, I have already told you. You have to engage such contractors, whom I call valid vendors with the GST, shops and establishment license, then income tax, whatever, that will be all there, PF, ESI, professional tax, all these registrations he should hold. Then, it is always good, and tomorrow for any financial liability, you can show him. Even PF, ESI will not ask their compliance to you. Oh, number is there? Okay, otherwise they will ask you show the record. You show me the thing in this ledger, this payment is showing, what is all this? They will eat your head. If their number is there, okay, we'll issue the notice to them. They will conduct only your inspection. So, therefore, always hire valid vendors for that. And the contractors are not have independent codes, then no, it is a liability of the principal employer to pay under your nose, you do and all that, for that documentation, etc. it will be there. But one thing, you ensure coverage. One thing, my dear friends, out of the box I am telling you, compared to the previous speaker, PF, ESI coverage all the time you ensure, don't become miser in that. Don't become miser. Because ESI, even one day, let us assume I am a worker, painter, I am doing the painting, I fell down, I died, or broke my leg, just only 3 hours I have worked in factory. If I am under ESI, whether let there be crore expenditure for my treatment, ESI will take. You as a principal employer, you need not bother a lot. Only thing, his entry should be there, his particulars should be there, wages, these should be fixed. If that is there, ESI will take care. Same way, if he dies only for 3 hours, if he is covered under the PF, had he been on the day on the roll, had he been worked on that, his wife and dependents will get pension. His wife and dependents will get pension. Only 4 hours, but he is an employee, he has already worked. There, 1 year, 2 years, 5 years you have to work, no, it is there. If he is an employee, while in the service, while doing the work, during and in the course of the employment, if he died, his wife and children will get pension. Taka. Not only that, I salute PF Act. Why? Because, supposing that the deceased person wife is pregnant, let us assume. Okay, deceased wife is pregnant. Even that child in the womb, posthumous child will also get pension. Till what? Till 24 years. Supposing he has reared a lot of children, let us assume. 3 children, that couple have reared. If they are for first 3 children, below 24 years, they will also get pension under the PF. How much amount you don't ask? Whatever, let it be 100 rupees. Who will give 100 rupees also? Who will give 100 rupees also? My dear friends, these are all the benefits. Therefore, don't become miser. Please insist all your clients, companies, mercilessly, you cover under PF, ESI, 15,000. Kya baat hai aajkal? 15,000 is what nowadays? Okay. Can any person lead a life? Okay. Let us be practical. Okay. I am not favor of anybody, but whatever it is, cover these things. Because even many of the IT people, I bank them. Some of my clients are IT company. Sir, I don't want PF because I am getting 1 lakh rupees. I say, idiot, don't do 15,000, let it be PF. Though you have got 1 lakh, how much money you save, you tell me. Every evening bar, dinner, travel thing and all that, they will all go. Where you are saving the money? Money will not save. Tomorrow if you die, if you have any other setup or establishment, then that money will be also not there. But this PF, some money will come. DLI, 6 lakh rupees maximum will come if a person dies. Deposit linked insurance, maximum 6 lakh rupees will come. PF will come. Then pension will come. Don't you think these are all the good things, my dear friends? Without any cost. ESI. In West Bengal, there was one labor who had 164 operations, multiple operations. 1 crore, 13 lakh, 13,300 rupees was spent on that labor. 64 operations. Labor. Everything was borne by ESI. No single paise. That labor survived. 1 crore, 13 lakh, 3,000 something money. This is the ESI. And one more thing, just I am educating. ESI, let us assume I am ESI employee. I retired. 58 or 60 I retired. Had I been a member for 5 years ESI, before retiring or coming out, then even if I come out, myself and my wife will get throughout my life ESI treatment. Just by turning 10 rupees per month, 120 rupees in a year, I will get in entire India in all ESI hospital, myself and my spouse will get free treatment. Where it is there, you tell me. Today any quack will take 200 rupees if you go to any medical quack. Yes or no, my dear friends? Yes or no? That is the power of the ESI. Don't think I am propagating, but these are good is good. Okay, good is good, whatever that is. Therefore, please ensure all this coverage to your clients or your companies, whatever, mercilessly. And of course, law has permitted you, they are all exemption under Income Tax Act, which my previous thing has already told. They are all exemption under the ES Act. What is that you are going to lose? Only thing you have to make timely payment, that's all. Come what may, make the payment in time. So, my dear friends, because today days are very difficult, okay? Even for us, okay, for all, what we talk, even all our life when it has become difficult, okay, the importance I am telling you, what I am telling you, the importance, okay? Then contractor does not independent code, okay, that he has to make the payment. Then, contract laborers are employed for same or similar kind of work. If they are employed like our regular employees, then employer has to pay the same wages. To what his permanent workers he is paying, same wage should be there. There should not be different wage. But normally what is the impression of all of us? Contract labor means low cost, cost cutting, okay, less wage. Wrong. Wrong. If you are getting the same like your permanent worker, same salary should be there, on par with the permanent employees. Okay, that you fact, please keep ensure from all your clients. Okay, then principal employer should not involve himself in selection process. He should not make any recruitment. Again, Sutradhara is okay, but he should not sit in interview, selection, I want to see the face, yeah, do. No. Contractor only has to select, bring, let him stand before a manager or think, sir, these are the people, what is your name? Senthil, okay, Ramaya, or Purnima, yes, all right, go, do well, chalo, okay, that's all he has to do. But he should not select, bring, interview, sit, no, please don't do that. Then it becomes sham contract. If you do that, under the law, it is a sham contractor. Naam ke vaste you are doing to avoid all your legal liability, etc. That is the card. Okay? Must be regulated by all that. And undertaking for each month contractor that only wages have to be paid in time. You have to take undertaking from the contractor. What I used to do when I was working, I used to keep 1 month his payment with me. Because any time if he delays, I used to disburse. Because I never missed any time less than 7th, on or before 7, everywhere I ensured, thereby I became very popular in my companies. Even after 18 years when I go to my company, their laborers, they treat me as God, okay, in that company. Because all the time I ensured. I was very strict. Of course, management was also very supportive for me in that. And any lapse on the part of the contractor, okay, in the discharge and all that, monetary obligation, the contractor is responsible for that, deducted from the dues of the contractor. That is what you have to think. So ultimately what? One more important duty of the contractor is maintain records of contract labor engaged, including register of contractor, payment of wage record, wage slips, attendance and working records. Not only that, one more, conduct regular inspections to ensure the contractor complies with labor laws. Earlier my speaker, the due diligence report, due diligence audit, you all call professional, finance professional. Due diligence is what? Diligent are there or no? Duly, we are making diligent of them. Okay? So that is what you comply. Ensure equal treatment to contract workers with regular employees regarding safety and working conditions. Safety is same, because they have also got limbs like ear, nose, hand, leg, okay, because they are not available in any scrap yard. Okay, any legs or hand or anything is available in Sabi's scrap shop? No, they are not available. Okay, therefore, for their limbs are also very, very important. Ensure that one. And prohibition and ensure that no child labor or bonded labor is engaged through contractors. This is one more thing. Some of the contractors, they hire, okay, they hire what? Child labor. Below, child labor is what? Below 18 years. Child is what? Above adult and adolescents we say. Okay, below 14 and below 18, never do. Please check. Okay, sometimes they wear the saris and bring the girls. Sir, she is wearing salary, sir, she is 19 years old. They say, don't agree. See the certificate.
Okay, see the certificate, photo and all that, not fake certificates, original certificates. You see and ensure, otherwise, you are going to be prosecuted. Spot 10,000 rupees penalty will be there for engaging the child labor, which is a serious act. And even we don't allow our child also, because child has to get all their due place, enjoyment, playing, learning, education. It is every child's right. Okay, like our child. Okay, that is what the important of that. Okay, and principal employer has to ensure, employer should submit the printed bills and sign under the rubber stamp, that the contractor should maintain records through his staff and not by the principal employer. Contractor labor should do only specific work agreed by the contractor. Other than that, we should not engage. That the contractor should issue the photo identity card to his worker under his name, trading style and signature. Contractor has to issue. And their place of work, company has to do. Company name has to be there. Not company should not issue. Okay, please be care about that one. That the contract should not be cloak suppressing facts. It means sham contract. Contractor shall issue appointment order, provide a copy to the company. Contractor has to issue appointment order to everybody. Since contractor is unable to issue appointment order like corporate company, there is an employment card. Phone number something 13 or something is there. Card, this much card is there. He has to issue. Because everybody wants to know, even their wives want to see what is your, tell me where kitar kaam kar raha hai, dekho, this is my appointment order. Everybody proud of it, nothing wrong for all that. That the contractor should comply law relating to female employees, including POSH Act. POSH Act is a very serious act. Even for the contract labor also, POSH Act is applicable, because they are also very prone for all these harassment, okay, humiliation, etc., etc. Okay, friends, I think Gautam Buddha once he said, if you preach the dharma without any food, dharma will not go in the mind. So I think, my dear friends, now you are all hungry. One more, what are all the ingredients of the agreement will be there. Okay, I think after lunch, 5-10 minutes I will take. So you are all hungry. Sorry, I made you too hungry and feel happy. Let us break for the lunch. Okay, then quickly after lunch, 10-15 minutes. Okay, we will do with all operation. Thank you very much. Thanks for your patient listening. The participants may sleep, snore, okay, get sleep, but it is a challenge for the trainer or presenter, okay, because it is a big challenge. I don't know how I am going to handle that challenge in the next few minutes. Let us see. All of you are here? Okay, now let us start with the chanting and clapping. Okay, everybody should say loudly. An employer must ensure. I think after lunch, how you should be there? You should fly away. No voice. An employer must ensure work is safe and jobs are pure, health and care, a must to give, helping workers safely live. An employer must ensure. Clapping. 1, 2, 3. Okay, my dear friends, how was the pre-lunch session? How was the session? Any questions or any doubts? Quickly, 1 or 2 questions. Any questions or doubts? Yes, sir. Sir, give the mic. Sir.
No. Sir, is it practical for any small or medium business to comply with all this? Be profitable?
Sir, you asked a very right question. Sir, as a prudent professional, if you really see the list, whatever I showed about 15 or 18 points, except 1 or 2, rest all are very small work. Only thing they are all one-time work. No, I'm just telling, the practicability I'm talking.
Comply with 80, but penalty will be levied for 90.
It is possible, even if you make 75 to 80, that is great, sir. Even authorities will also accept. Even to 70 to 80%, it is authorities will be happy that they can take. Some practical aspects will be there, it has to be taken into consideration.
You respect your experience. Have you interacted with the PF ESA officials of Tamil Nadu government?
No, I have not interacted with Tamil Nadu, but since I am in Karnataka, I have interacted, but yeah. No, even what happens, small employers, SMEs, they have problem, no doubt about that. They are facing a lot of problem. Big industries and all that, there it is not there, but small employer, it is a problem right from payment. That will be there. Yeah, no, redraft also they have done, only thing now it is has to come from the womb of the mother out. Okay, we are waiting for the notification, otherwise everything is ready. They have tried to simplify by avoiding many repetitive work. But otherwise some work will be there that, we have to find it. Thank you, sir. Thanks for the question. Okay, quickly friends, now I will not take much of your time because next speaker is also there. Having started the presentation, I will complete now. One of the thing in any document, we will all agree as a sales and accounts professional, there should be a document, agreement, what we call, like contract and consent, whatever we say. An agreement should be there with the contractor, apart from all these compliance. On all due paper, if possible, registration, etc. What should be the agreement contents? That I am now sharing with you. Between principal employer and contractor, the agreement should be drafted and executed on non-judicial stamp paper. That the agreement must disclose the name, address of the contractor and the principal employer. That the agreement must contain the rights and obligation of both the parties. That the agreement must disclose the place of work, time of working, rate of compensation towards consideration, consequences arising out of breach of contract, and procedure of termination by other parties, whatever the period. Agreement must carry out objectives of the statutory provisions and if possible few judicial pronouncements. Agreement must disclose the scope of work, deployment of manpower, period of validity, compensation, security deposit and terms of the payment of bill. Agreement should be between contractor and principal employer should be witnessed by 2 witnesses. Okay. Then a note. No, these are all ingredients of the agreement must be there. Okay. Plus whatever your points are there, always in a written and all that, that will always go. That is a basic document. Even the buyers, auditors, whenever they come, they will ask all these things. In the absence of document, again I said, it is a problem. Even if it is not done, now please ensure. Okay. And one more very important thing, we have seen the contract employees. Now contractor employees I have seen. What is the difference? Just I try to highlight. Contract for service. The first one is contract of service where it is a dependent master and servant relationship will be there. The first one what I said on that one. Second, contract for service. Independent, no relation. The second is contractor because he is independent. He is an employer, not principal employer. Or should, that is why I said principal employer, this do, that don't do, all that. Supervision but not instructions. Do the supervision but don't give the instruction. Instruction who will give? Boss will give. Employer subordinate relationship, mother will give, husband wife will give. Relation is there. Okay. Then inspection is not supervision. You can make the inspection but not the supervision. I hope this difference you are understanding. That is the crux of that problem. So ultimately principal employer is responsible for what? Ensuring contract workers' rights and cannot escape liability blaming the contractor. For everything, principal employer is liable. Regular monitoring and strict compliance. Regularly you have to monitor. Like internal audit, once in a while or 6 months you have to do, talk to their workers, contractor, how things are all going, etc., etc. So that they will all make all these things to keep in place. And necessary to avoid penalties and legal action. And ultimately see that all contract labor should be happy at their work. Ultimately what? If they are happy, better work will be there. They can give the production, productivity, everything that they will give. And for contract labor, what are all the laws applicable? Almost all laws are applicable. Payment of Wages Act, Minimum Wages Act, Festival Holidays, payment of bonus, gratuity, WCA, maternity benefit, prevention of sexual harassment. You may ask one question here, sir, what about gratuity and payment of bonus? Of course, contractor is responsible, principal employer is not responsible by law. Okay, but they take the provision of Payment of Wages Act, then he has to pay the bonus and gratuity, all that say. But one thing in reality, contractor, how he will pay? Contractor is not a rich person because he has to get commission and based on that is nothing but a one type of commission. For all manpower, whatever he supplies, based on 10% or 5%, whatever stipulated, that is his only income. But ultimately what? Principal employer only has to go, he has to take from him and give to him. So therefore, ultimately, please make a provision for that as a principal employer. Whatever you are giving, for make them also provision, give to the contractor, let him pay. Ultimately, all employees should get, they should be happy.
objectives of the organizations have to met. That is what production and productivity cost, whatever we call. Okay, ultimately that's all the thing, my dear friends. So this is what, as far as the contractor labor liability and responsibility of the principal employer. My dear friends, those who have got mobile, I request all of you to please take photo of this. So in this, my website is also there, and I have got my YouTube channel, more than 140 videos on various management topics, HR, IR, management, including the labor codes. My various videos are there, both in majority they are in English and few are in Kannada. Okay, those who can understand, you can do. Okay, you can become subscriber, which is a free. Like, share, okay, and write your comments whenever that will be there and all that. Nothing but a knowledge sharing, not great. If it is helpful for you, I am really very, very happy about that. Okay, so that is what the thing for all that. Now let me with the one rhyme. Final 2 slides are there. I am going to show for that. Wage is fair and no delays. Loudly. Wage is fair and no delays. Workers happy all the ways. Compliance clear. Work in praise. Uplift each other with working days. Clapping. 1, 2, 3. Okay, friends, last 1 or 2 of my slides about the labor code. In the labor code, whatever it is showing, very, very crisply I try to bring in that. Okay, contract labor and labor code. So far I said principal employer is responsible, he has to do that, this, all that, blah, blah. But labor code has taken some change, okay, which I am bringing to your notice. Number 1, chapter 6 of special provisions for contract labor and interstate migrant workers act in the occupational safety, health and working conditions code. 4 codes are there. Morning one of the speaker has showed you social security code. Now I am showing you the occupational safety, health and working conditions code. In this code, for chapter 11 speaks about the contract labor. Okay, wherein in that part 1 contract labor, applicability of more than 50 contract laborers are employed by every establishment. Currently it is 20. You are all aware. Here in new labor code, it is 50. 50 and above, that will be there. Same way for the contractor also. Okay, that is one change. Secondly, core activity of any establishment has been defined. So far, core activity is not defined, except Andhra Pradesh. Andhra Pradesh, last time when Chandrababu Naidu was there, what is core activity he has defined in Contract Labor Act. Taking same provision similar, now labor code has taken core activity of an establishment has been defined as an activity in which establishment is set up and includes any activity which is essential or necessary for such activity. Non-core activities have been listed, non-core activities have been listed around 11. 11 non-core activities have been defined, given. Henceforth, once labor code comes, employer is allowed to engage contract labor only in those 11 non-core areas, not in regular core areas. In core areas, depending on the marketing and conditions, for a very short period, is allowed to engage but not permanently like current. Okay, that is one different that will have really bearing on the employer and the employees. Like non-core areas are like, just for example, sanitary work, disposal of all kinds of waste, watch and ward. So any activity of intermittent nature, even if that constitutes a core activity of any establishment, etc. Contract labor abolished except in non-core areas. Okay, there the contract labor is really established. Therefore, this change means that areas listed L1 contractor cannot be engaged. Okay, that is what the thing. Labor department cannot permit employer to employ contract labor, and areas of core activities carried out by contract labor is discontinued. This has major impact legally. Okay, then registration, it will continue, okay, with some change. Safety, health and welfare continue. Principal employer is liable. But here in new code, here the contractor can provide. If he fails to provide, employer can deduct, provide and deduct. But in new labor code, contractor is made employer. That contractor, if he is employing in some other place with appointment order, service conditions, standing order, etc., if he is there, then he amounts to an independent employer. We were, as an employer, we were fighting with the Ministry of Labor. Please consider contractor as an independent employer. Why you make principal employer as responsible? That is what we were fighting with the government. Even I am in the Committee of Labor in Karnataka, the Federation of Karnataka Chamber of Commerce. Okay, that has been considered here. Then PE has to employ licensed contractor only. That is mandatory. PE has to take first license he should have, then employ. Now what happens? Now we employ, then we take contractor. Responsible for payment, that is continuing. Contractor made an employer under the new labor code. Well friends, these are all the some of the points as far as the labor code is concerned in respect of contract labor, principal employer, which you can go through. Probably I was told during the next accounting year, all these labor codes may emerge. That's what they were talking. Though all the states have been made rules and though parliament has passed, though it is gazette is there. However, that we have to wait for all that. Well friends, again anybody has missed, please take the photo. Okay, this is all my presentation, my dear professional friends. I thank the Institute of Chartered Accountants Southern Regional Council for having identified me and called me for giving the presentation all the way from Bangalore, for which I am thankful to the Institute and all the office bearers. I may be knowing a lot of things. If listeners are there, then for whom I have to say. I came across very interested, knowledgeable, patient, all the audience, because I am seeing nobody is yawning, nobody is seeing at mobile, nobody is dozing, nobody is sleeping, everybody is very active. I have come across extremely good audience. Okay, extremely good audience. Thank you very much for your patient listening. I have troubled you by clapping, singing, only thing dancing also I wanted to make, but I will not trouble you now because my presentation is all over. Thanks for all your active participation. My dear friends, well, this is my contact details. Please enroll to my YouTube channel. It may be helpful. My website is also there. And any of you, I have got more than 45 training modules. I speak Hindi, English, Kannada. Unfortunately, I don't know Tamil, though I understand little. Anytime for any of your level of employees, top management, middle management, lower management, I have got 45 modules in HR, IR, labor laws, soft skill, managerial, supervisory, production, productivity, cost control. Okay, various programs I have got. Okay, I conduct across programs online as well as offline. Anytime if you need, it is my pleasure to associate with you. And once again, thank you very much for all your patient listening. I really enjoyed. Good day. All the best. Thank you very much.
Thank you, sir. Thank you so much. On behalf of all the members here, we really enjoyed the rhymes, singing and clapping, everything. Thank you so much. Also, the session was really good. Let me, along with my members, invite the next speaker, CA Ramamurthy Teja Murtula. He has completed his chartered accountants and was working with Nataraja Iyer & Co, Hyderabad. He is also a fellow member of the ICAI, law graduate and postgraduate in commerce and law. He has been in practice since 1999. Sir, CA Ramamurthy Tejo Murtula, please, we request you to come on the dais. Saranya. So, sir has been in practice since 1999 and is a founder partner of Mrs. Tejo Murtula Associates. His core area of practice includes taxation, audit and assurance. Also litigation practice both before direct and indirect tax tribunal. Filed cases in high courts through known advocates, tax matters. He has served the members of Hyderabad as a committee member of the Hyderabad branch for 2 terms. Served as a treasurer for the year 2011 and 12 and as secretary for the year 2013-14. He is also an active speaker for seminars organized by various forums and professional institutes. On behalf of all the members, we invite sir to give a lecture on labor law. Also, I request CA Sir Sri Ram to come on dais to present the memento. A big round of applause, please.
Good afternoon, everybody. Before start of session, let me extend my pranams to my parents and my gurus who made me to stand before you as a chartered accountant. I am indeed very happy to share whatever I studied as a part of my professional services regarding the labor laws. I did my LLM from labor laws, in labor laws. This I divided my presentation in such a way that core areas of labor laws and then 4 codes that have been introduced, then challenges as a practitioners what we face, and out of the challenges how we can search for the opportunities. This is what I thought of sharing with all of you. I was asked to talk on the unorganized sector. I think all of you may be familiar what is organized sector. But we come across in our life in many ways, many folds, it is all unorganized sector only where we come across each and every day our practice. Like if you take a small shop, he may be having sales girls or sales boys, whatever it is. He may be paying some 10,000 or 12,000 or whatever it is. And what are the securities what they have, or as an employee what are their rights, what they can take from their employer. Those things hardly anybody may come across or anybody might have thought of. And initially I was asked to talk on the domestic applicability of PF on domestic servants. Then I said it is not domestic servants what we have to talk, it is better if we talk on unorganized sector. If you see the agricultural sector, as of January 2025, 159.02 million people are dependent on agriculture as unorganized sector laborers. That is January 2025 census. 159.02 millions. Likewise, there are around 28 sectors where people are involved. For your information, just I have jotted down those things, but not part of presentation. In construction sector it is 27.61 millions, and apparel sector it is 19.94 million. Automobile and transportation it is 8.19 million. Capital goods and manufacturing it is 6.41 million. Likewise, the list is going on. Out of this, office administration and facility management it is 2.89 million. Why I am more interested to discuss this? As chartered accountants, we may have n number of clients who are doing management services, manpower services. Okay, if you see this hotel industry, you have housekeeping service, you have laundry service, you have transportation service, you have in-house catering and outside catering service, all these things. So as a chartered accountants, when we are discharging our functions, I was told we should know 109 statutes to be a small practitioner of a chartered accountancy. only 109. And out of that 109, let me tell you, this labor legislations, there are 45 acts, labor legislations. Sorry. "45 legislations are there." So, after this BJP government has come into power, don't feel that I am BJP, though I am a RSS. They tried to enact these out of 45, 29 important enactments they have taken, and they tried to divide that 25 into 4 labor codes. That is Social Security Code, Wage Code, Working Conditions, and one more code they have made it, that I will come back. Okay. And when you see this Social Security Code, in that we have ESI Act, PF Act, Maternity Act, all these things they have subsumed, and they have made this code applicable from, it got the President assent in the month of September 2020, August 2020 if I am not wrong. So, from September onwards they have made this as a act. So, how many of us know this fact? How many of us know this fact? Now, I will take you to our responsibility. All of you may be doing tax audit. All of you may be doing tax audit. Form 3CA for corporates. In that class 5, it states whatever we mention is true and correct, right? Then I will take you to class 20, subclass B. There we are writing contributions, employees contributions, 36(1), class 5A. That we are certifying it. So, there is a due date, and if within that due date that is not, payment is not made to the respective fund, it will be disallowed. Of course, we were under the impression that if they contribute before due date for filing of the return, it will be allowed as an expenditure, but there is a Supreme Court case wherein they mentioned that it is the respective act we have to see, not the Income Tax Act. If I am right, okay. Otherwise, if I am wrong, kindly share with me. Yes. Yes. Okay. So, likewise, if you see non-corporates Form 3CB, their class 3 also talk about true and correct. So, I humbly submit before all of you to kindly look into these acts and how we are made to accountable for non-reporting. Because so many tax audits we have seen, big companies, just they don't give any details, and we auditors certify it. If something goes wrong, first you know the word scam. Unfortunately, middle two words talk about CA. Okay? Whatever it is there, CA is there, you call him. Whether he is related, not related, different issue. They feel that is also scam, and we are involved in that. So, humble my submission is, kindly look into this while discharging your functions. Now, this picture, I think this is not an organized sector, if all of you agree. There is one act, Workmen Compensation Act 1923. If you see this, out of 45 acts, many acts are passed prior to our independence, and some acts have been made amended subsequently, and still some more acts are there like that only. So, we are filing the income tax return of a contractor who is a contractor to the railway, loading and unloading. How many of us have verified his labor registration? Honestly, let us question ourselves. If something goes wrong, railways will become the principal employer. And we might not have applied our mind to see whether the particular SSC for whom we are filing the return as a contractor to the railways, whether he got the labor registration first. Next I will come to ESA registration. Labor registration is different. Though all these things are falling under concurrent act, there are certain acts that are state acts. So labor department, it is there. ESI, PF. And if he don't discharge, we deduct TDS, now GST, and we don't, or I don't say we don't, rather we believe the SSC that he is doing all these statutory requirements. But at the end of the day, we should keep in our mind whether we are doing justice to our work or not. Very recently, I think here also you have electricity department in state of Tamil Nadu, right sir? So there are more contractors for the electricity department who carry on the work of, say suppose tree cutting or wire connecting or pillar erection or substation erection, okay, or connecting that to grid, all these things. To my knowledge, these works are done majorly by the contractors. Though works are executed by contractors, they are supervised by the officials of the state government, but they don't do anything physically. And I think here also you have the system of doing bookkeeping, accounting for electricity department. Many of maybe our chartered accountants may be doing that, or back office operations. So in this process, they are passing their bills and they are deducting 194C honestly, remitting, but not verifying the contribution part of PF and ESA. I was told there was a survey like our income tax by the PF authorities in various states, and they have identified the list of the contractors who are appearing in the books of accounts of the electricity department. In that they found big list. So in that list they found some of the chartered accountant firms also, because they are rendering services for accounting, bookkeeping, bill reconciliation, okay, all these things. With due respects, we have a system of getting the work on tender basis. Am I right? So this work is covered under tender work. There, this CA qualified firm is known as a contractor. So we are happy because 2% or 1%, whatever it is there, they are deducting, accounting our bills. But when this survey has taken place, in the list they found these names. They have issued letter to our co-brother also. And he has, I am a professional, I know everything. He has submitted his balance sheet, income and expenditure, receipt and payment, everything they have submitted. Now, as a part of this enquiry, they have issued letters to our brothers. They said, yes, we are paying stipend to our articles under Apprentice Act 1961. It is not taxable under PF, that is a different issue. But they found some word, salaries. So, to whom you paid this? Yes, I paid to my clerk, my data entry operator, my sweeper, my driver. Crux of the issue here is, to get the contract, they need to take a compulsory or voluntary registration under the PF Act without applying the number of employees clause. So they have taken the registration for the firm name. When they have taken the registration for the firm name, they don't have option to bifurcate the amount, whether it is applicable to your own staff who are helping you as a part of chartered accountancy and the staff who are helping you to execute or to supervise or to carry on the work of the electricity department. Clubbing both the things, they started enquiry, what we know as 142.1 or 143.2, whatever it is. So there it is known as 7A enquiry under PF Act. So they issue notices. Our people submitted data, they have given the list. And people landed in payment of liability of 12 lakh, 15 lakh, 20 lakh, 5 lakh, like this. So where we will stand in this scenario? Anybody can share, please. Having said so, PF authorities issued letter to our brothers. You have taken compulsory registration, you pay this. Then they started thinking and arguing. They said nothing doing. Even Supreme Court also, if we go, taking voluntary registration, in voluntary registration you will disclose the names. So suppose 5 or 4 people who are directly connected with, okay. Previous speaker was mentioning about documentation something. So our people, we do 230 everything. SA 230 we maintain documents, everything, that is different issue. But when it comes to our own, how many of you are acting as a peer reviewer? As a peer reviewer, anybody is acting here? Nobody. So, when you do the peer review of our own co-professional, you will know what are the lapses of the documentation. They carry on the tax audit, no appointment letter. They carry on the tax audit, no working paper. In peer review, you are supposed to take the samples what you have verified for the review period. So, this is one type of opportunity for learning and our helping our co-professional. This peer review work is safeguarding our co-professional from looking after all these statutory obligations. So ultimately, in this case, though they have given all the representations and other things, PF authorities coolly made them only two things: you pay or we attach bank account. Only these two things they said finally. Our people were not having any other option except to pay. Why I am bringing this to your notice that knowingly or unknowingly, if any of us or any of our friends, they are discharging these type of functions to government or any other private organizations also, let them enlighten that these are the minimum requirements. Under the labor laws, we have to make a bifurcation regarding our presentation. Actually, in Hyderabad, I only attended our friend's case in 2018. So, with great difficulty, since I was knowing the Regional Provident Fund Commissioner there, I made the bifurcation and helped our people. It is not advertisement purpose I am telling, but we feel pinched when our co-professional is undergoing unnecessary mental agony, and they ask only one thing: you have sweeper na, you have taken voluntary registration, pay for her, because they see from perspective of unorganized sector. Do you feel chartered accountancy is an organized sector? Yes or no? Now doubtful. We earlier in the form 3CD we used to have only 3 words: yes, no, not applicable. If we know used to write yes, no, something ambiguous, then no, not applicable. That provision is not there here. So I request all of you to kindly look into this and take care of this. Now, in unorganized sector, I will take, if anybody wants to share, you kindly share, otherwise whatever I have read, I will share. I am taking first example of vegetable market. Vegetable market. In vegetable market, I think there you have the, for farmers will come, they give it to middlemen, and from there retailers will purchase, sometimes wholesalers also will purchase. This middleman employs people for loading and unloading of the vegetables, and we are filing his income tax return. Now you tell me whether PF or labor laws, let us talk about labor laws, is applicable to him or not. Yes, no, not applicable, sir. Yes. So how many of us we have noted down this? And if something goes wrong, like some accident has taken place, so he will be dragged to the court of law under the criminal procedure code. So as a chartered accountants, we will claim FIR is lodged, so he has made compensation. That compensation we claim as a business expenditure in our profit and loss account, that we certify. So in this process, as a chartered accountants, what is the responsibility casted on us to look into this specific aspect that is dealt with this unorganized sector? Like we go to a shop, sales boys, sales girls, or you have your own in the house, your servant maid. If they ask you more amount, you will search for the alternative. If something goes wrong with the servant maid in our house, matter gone to police, there they will ask immediately first question, since how many years she is working or he is working as a driver, whatever it is. So immediately your liability started there. These are the areas where we have not thought of will have an impact as a practitioners on our heads. So that was the reason why when they asked me, the topic is household servants or something, then I said it is not that way. You put it as unorganized sector, so then we can cover in an elaborate manner. So this labor laws, unorganized sector, as I already told you, Parliament in September 2023 approved 3 key labor reforms covering 50 crore workers in the country. In 2020-23 it is 50 crore. Now in agriculture sector itself it is 159.02 million as on January 2025. You have list of around 18 categories in this. Out of 45 acts, 29 acts only they have subsumed into 4 labor codes. That 4 labor codes, 3 codes were earlier passed by Lok Sabha, and these will be now sent to the President for his assent, because but for Social Security Code, remaining codes were supposed to get the President assent. Subsequently they got it. These recommendations were made taking International Labour Organization observation made considering the working conditions of South Africa or African countries rather. They imposed this on all the member countries. India is one of the member country of ILO, International Labour Organization. India is one of the member. So, considering the requirements of ILO, government has taken first 29 enactments and made into 4 codes. This labor code on wages. Under this labor code on wages, Minimum Wages Act, Payment of Wages Act, Payment of Bonus Act, Equal Remuneration Act 1976. These 4 acts were clubbed together and made as a payment of code on wages. This Equal Remuneration Act, like you might have, all of you might have seen in the military, 1 rank, 1 pay. In this labor laws, you cannot make any discrimination. If I am not wrong, in the Constitution of India also, Article 15 talk about equal pay without any gender discrimination or anything like that. So, considering that, this Equal Remuneration Act is enacted. Now, highlights of this. This got President assent on 8th August 2019. Provisions of minimum wages and timely payment of wages to all the employees irrespective of the sector and wage ceiling. Here I want to take a little pause. We are certifying our balance sheets. I will not say managing the profit, but at the same time I will say, in case of a contractors and others, hardly we have any scope to reduce the profit. So what we say? Labor charges. Because if you go to any purchase or anything, nowadays for last 7 years, GST is there. No, it won't leave you. Earlier in 26 years, what are all the purchases you have made, they were reflected, but I think last year onwards it is not appearing. But in AIS it is appearing and TIS it is appearing. And we are providing in the balance sheet stating that payable. And it is but natural, sometimes we may forget next year to see and reconcile whether it is paid or not. After 4 or 5 years, fortunately or unfortunately, 133 has taken place in one of the clients of our other brother. So where ours is a connected case. He has paid contractor payments, we are filing a return, and they will call for our records also, and the amount shown as outstanding liabilities is not discharged in the subsequent year. So now, can it be treated as a 69C addition under the Income Tax Act? Unexplained expenditure. Sir, I am telling you, don't feel that I am trying to show my knowledge or anything. Practically, I am dealing these cases. And our friends, they are filing their returns. After losing the appeal, they come to us. When I see, these things are not available. Outstanding liabilities continuing for years together. Arey, what happened? I told us, sir, I have not seen that much, what to do. And now who has to give explanation? So with folded hands, I want to request to all of you, kindly look into these things. These are the opportunities to take some works. At the same time, our minimum responsibility is to discharge as attest function. So this minimum wages, we need to account minimum wages only in the case of wages. Less than that, if you are accounting or recording anything, you have to give an explanation. If it is a seasonal business, then there is something different. Okay. But otherwise, minimum wages, one has to account as a part of wages. That kindly keep. That is applicable as per the labor code on labor wages. Okay. And there were so many definitions for the word wages. All those things they have removed, and now only one thing is they have put. This, some other issues I have mentioned here. Industrial Relations Code. Fourth code what I was about to say was Industrial Relations Code. In this Industrial Relations Code, they have grouped 3 industry related statutes. That is, trade unions. Madam, don't write, I will share this, don't worry. No, I developed this. I completed my LLB in 95. Of late in 2022, I completed my LLM. So when I was reading that, it has given me interest to go into these things. So that trying to help our friends, co-professionals. Trade Unions Act, of course, though there is a Trade Union Act, earlier it was much impact, nowadays that much is not there in so far as trade unions is concerned, but Industrial Disputes Act is there. Okay. So industrial disputes, these things they are covered under Industrial Relations Code, and this also we need to know as a chartered accountants. In this highlights of the code, it allows companies with up to 300 workers to lay off people without state government's approval. So far, only companies employing up to 100 people were allowed to do this. That means layoffs and other things we are looking after. So, this industrial disputes, why we need to keep in mind, as a chartered accountants, we are certifying yearly whether they are doing business, not doing business or anything, we are certifying and they are making their files, income tax returns we are filing, say suppose nil or loss or whatever it is, right? In that, at least we write one employee, at least that one employee may be chowkidar or a sweeper or whatever it is. For him also, Minimum Wages Act applies, this industrial also will apply. This is third code, occupational safety, health and working conditions. This is a code termed as code occupational safety, health, working conditions code. Under this, they have clubbed 13 acts. First one 4, next one 3, here 13. So total 20. No calculator. In this working conditions code, how many of you agree with me that we should know the basic definitions of the Factories Act 1948? What, sir? Sir who has given me memento, I ask him to respond for this. What, sir, do you feel that we should know what is Factories Act or not? Because I tell everybody, we should learn from Tamil Nadu. Why? Because first thing, I don't know whether I am right or wrong, but I feel I am right. I will substantiate why I am right. If you see the Tamil Nadu, they are developing the state, concentrating one type of industry in one area. Am I right? Say suppose home appliances or something like Coimbatore, apparels, Tirshur, something like that. Okay. Here if you see TI cycles, there is a big Centlex's case was there on TI cycles. Okay. And you take TVS, you take Ashok Leyland. Because industrially, Tamil Nadu has been developed a lot. So, as a chartered accountant situated in the state of Tamil Nadu, I think nobody will say no to me or my statement that all of you know this Factories Act. So, this Factories Act, now Plantation Labour Act. I asked very curiously to my lecturer in LLM, sir, where is the Plantation Act? Then he said, no, in the state of Kerala, and as a part of Workmen Compensation Act 1923, Schedule 2, talk about this plantation workers compensation. Though there was no direct act, this act has come in 2008 only. Earlier to that, there was no specific act as such. And of course, we are taking, it is an exempted income. Okay, sir. Exempted income so far as income tax is concerned. But there is no exemption so far as labor loss is concerned. As a chartered accountant, when we are filing their, when we are attesting their balance sheet, we should take responsibility whether they are following that act or not. Like Mines Act, Motor Workers Act, and all of you will agree with me, in the year 1996, in respect of construction industry, they have introduced one cess, 1% and 2%. Am I right, sir? Madam, sir. So, how many of us we have applied this and seen whether it is deducted or not? For God's sake, kindly do look into it. There is lot more opportunities. As Mr. Ram sir was mentioning registration section 3, if you take the social security as section 3 talk about registration, there we can do service. Compliance, we can do service. Anyhow, daily, every month or quarterly we are doing the internal audit or something, and we are certifying wages are accounted properly. Correspondingly, you see whether ESA contribution is made or both contributions are made or not, or paid within the due date or not. These are the opportunities. Everywhere, in each and every breath we have an opportunity. But we feel everything is free. Because some are second generation chartered accountants or third generation chartered accountants. By the time they qualify, AC was there, AC is there, table is there, computer is there, everything is there along with a, if you knock the bell, boy will come, sir, what you want, coffee, tea or something like that. But at the same time, some people are there like me, who don't have anything but the wall backside me. I learned all these things. And just now only I got a call from the enforcement officer. I need to attend one hearing on Monday. Only liability is 1.990 crores. Of course, they will give some fee of 1 lakh rupees, that is different issue. But learning, no? why I am sharing this, we can learn that. And one of our, in Hyderabad, for a chartered accountant firm, I was appearing before the Appellate Authority, PF. He says only one thing, you have taken voluntary registration, you pay for the office clerk also. I said it is not applicable. But there is one case law in 1973, if I am not wrong, of the Supreme Court, wherein, in the case of Karachi Bakery, if you see definition of employee 2F, okay, for applicability of labor laws, basic crux of the issue is that it should have employee-employer relationship. If we can establish that there is no such relationship, then we are safe. But at the same time, with due respects, there are n number of loopholes which you cannot fill or fulfill to say that there is no relationship. In my second presentation, I have given some definitions as per the Social Security Code 2020. It will be easy for me to read, but all of you are well learned professionals. Reading before you, this is not correct. only requesting you to kindly read. Right, sir? If I read this section, sir, as this section says, it is definition of employer, employee, agent, minimum wage, working condition, all these things you also can read, sir. But only the thing I should take you to or corner you to read it. I think this evening all of you will think for this, whether to read or not. Okay, sir. Now, in this working conditions, as sir was mentioning, safe working conditions. Safe working conditions, when the statute talk about safety in the area where the worker is working. So, we may get doubt, what is the safety, what he will not have safety? Example I will tell you. When the gangman attaches engine with the rack in the railway, okay, they fix that compression tubes, two tubes, right, sir? In that they will have that side also one iron rod will there, both will come, both will have that spring action, right? So there is very less space to stand a human being in that. Suppose if there is a miscommunication so far as the distance at which it needs to be kept, what will be the fate of that worker? He will be crushed. Now you see whether it is a safe working condition or not. We feel that some accident has taken place, but at what cost? The reason could be miscommunication. Reason could be not stopping the driver to stop the engine at a particular place. Like worker is working, something has fallen down on his head. We feel safety helmet. Will it save us? Some iron part has fallen on his head. Will the safety helmet will save us? It won't save. But at the same time, without wearing safety helmet going inside the working place is a crime. And the supervisor who is supervising, gone. Very recent incidents. On 8th January and 9th January it has taken place at Tirumala Tirupati, Vaikunta Ekadashi. Around 5 or 6 people, and recently in Kumbh Mela, 28th, if I am not wrong, of January, around 50 people. So you may ask me why you are correlating that and this. Crowd management. Now you tell me and correlate me whether this crowd management is part of labor laws or not. You may be giving this responsibility to the police department or the department or the person who is giving the tokens or tickets or whatever it is. Okay. You might have engaged a contractor to put the barricades. If that barricades are not put in proper shape and with proper length inside, they will fall down. Then it is whose responsibility? So, knowingly or unknowingly, in day-to-day activity, we are coming across and we are crossing across this labor laws as a part of our life. That is the reason why when we were doing our LLB, what they say, don't feel otherwise, Hinduism is not a religion, it is way of life. So I correlated my CA profession with that. As a practicing chartered accountant, not only eyes I should keep open, brain also I should keep open. Tea time అయిపోయిందా అప్పుడే ఎన్ని టైం అంటే 2 minutes. Sir, until and unless we met with an accident, we feel we are safe driver. You are safe driver, but the other person is not so. You are safe because other person is safe. Not that you are great, you are safe. Kindly keep this in mind in each and every activity. In Caro, do we have any responsibility to disclose anything which is disputed as part of Caro clauses when we give the audit report to a private limited company or a company, rather you can take that way. Do we have any clause there? Yes sir, we have a clause. Now you tell me, in that disputed amount there is a case filed by the widow of a retired employee or a employee who has died during the course of his execution of work. Okay, will you recognize that as a liability or not? If you dispute it, do you mention it or not? Now you tell me whether that is covered under labor laws or not. Friends, continuing Occupational Safety, Health and Working Conditions Code, one registration for an establishment instead of multiple registrations. Presently 6 Labour Acts out of 13 provide for separate registration of the establishment. This will create a centralized database and promote ease of doing business. This the provision of one licensing, one return in place of multiple licenses and returns in existing 13 labor subsumed in this code to save time. See this, we have seen there are 13 enactments under the safety code. Every 13 registrations, returns filing, all these things, now there is only one return. Okay. And one more big industry is cine industry. What sir? If you take state of Tamil Nadu or state of Maharashtra or Andhra Pradesh, okay, so there are Bengal or Orissa, or you take Manipuri or Jharkhand. Each and every state they are having their own regional language films, and in each and every film industry there are, I was told there are around 24 departments, right sir, from the inception of that story writing till release. So these 24 departments are having 24 unions. In these 24 unions there are n number of sub unions which work as part of main union, and the producer happens to be the main employer because he is taking the help of all these 24 people, right sir. And if he don't discharge his liability, and we are, suppose all of you might have seen this recently, there were income tax raids at Hyderabad, and this movie, what is that sir, Pushpa 2, okay, just day before yesterday only that KUMAR auditor has come to me because they have received some notice, so I was fortunate enough to be in small way associated with them. So what is happening sir, why I am trying to take you to Cine Workers Organization, there you have, it is an unorganized sector. And we are filing the income tax return of the producer or a director or a writer. Even in case of a cine writer, he is having assistants who write the scenes, who correlate the scenes, and there is a editor who edits it, and there is a person who draws the pictures. They will picturize actually. If they want to take one scene, they will picturize whether how it looks. So they try to create that virtual this thing, and practical one they try to erect there and take the shooting. So something goes wrong in that area, we are also having opportunity in one hand, accountability on another hand. So this is the thing. Women in hazardous jobs. Under this occupational safety, if you see Sivakasi, I think it is in Tamil Nadu only, cracker industry, how many families are living on that? And what is their working condition? Whether they have safe, secured working conditions, and what is their minimum wages, what they get, what is the health facilities what they have. I was told many of the people are prone to lung related problems, okay, which may eventually take to them to breathlessness and others, ultimately cardiac arrest. So how these unorganized people, and state question may come to us, why we have to break our head for all those things. Our client is giving money, doing balance sheet, leaving it. But we have our own responsibility to look into the labor statutes so far as those industries are concerned. If you take apparel industry, okay, if you take apparel industry, to my knowledge, the thread what you get, it gets in only white color, right? The colors what you mix it is all health hazardous. Then what are the precautions what we are taking? And how that precautions are affecting our financials? As auditor, what responsibility I have to discharge? These are the areas where we need to look into. Regularization of working hours. You know, if you take the hospital industry, that is healthcare industry, or you take manpower industry, that is manpower contract labor. Suppose if the person who has to replace the worker or a security guard is not coming, or abruptly he met with some unwanted accident or something, he cannot report to the person. So this poor fellow who has already worked for 8 hours or 10 hours has to continue his work. We feel that he is paid 1.5 salary, that is different issue. What about his health condition? If something goes wrong in that time, how we will qualify that as a part of our balance sheet? Compensation paid to the worker. So, as a chartered accountant, do you feel we have certain responsibility to know that these are the hidden areas are affecting our profession in a larger perspective, to know and consider while signing the balance sheet.
Can I interrupt for a minute?
Please, sir.
Sir, when you are talking about this, I have a doubt. Suppose there is a client who runs a factory as compared to the factory, sir.
Yes, sir.
He is not a corporate entity,
Yes, sir.
unincorporated entity, but he comes under tax audit. Now, I have been to his place umpteen number of times. Now that you have given a lot of insights about our responsibility to repeat labor laws, suppose I sit and focus specially on this area, and I find at least 3 areas where there are lapses. Say there are lapses related to safety, there are lapses related to some compliance under a particular say compensation act, and I also come to understand that the wages are not in consonance with the
Minimum Wages Act.
prescribed under those relevant acts.
Yes, sir.
What do you think I should react?
Yes, sir. Here I will share my practical experience. Right, sir? What I have done, I am sharing with you. First, client will question you, sir, what for you are want to see that? Huh? First question will be that only. Okay? In what way it is affecting my income tax? In what way it is affecting my GST or sales tax or whatever it is? My banker is not asking me. Knowingly or unknowingly, we are giving net worth certificates for renewing their limits. And some of our friends, of course, recently there is a guideline. Earlier to that, they used to put their stamp and certified that. Future, how these people are able to certify, God only knows. We don't know whether tomorrow will wake up or not, but he will certify till 2030. It will be his turnover. If young people don't offend, I want to share one thing. One of our young chartered accountant went to a senior person like sir. Out of his curiosity, he asked, he is a qualified person. Arey Baba, what is the reason why trial balance will not be tallied? Because if I am not wrong, you are from manual side, I am also. If you say balancing book, you don't know what is that. If you say subledger, so this young chartered accountant could not understand his question. Sir, come back. What is the reason why trial balance will not be tallied? He scratched his head. After 5 minutes, all of a sudden he got thought. Sir, I have one doubt. Trial balance is given by tally. Why it will not be tallied? That is the question he asked that chartered accountant. No. The chartered accountant was in confusion state. What he asked, what he answered. That is the state of. I will not say all young people are like that. Conceptually, they are not concentrating. So, to keep our baton in good hands, at least we should feel them responsible, what they need to do, why they need to do, how they need to do, when they need to do. Now your question. You said no minimum wages, no safety. What, sir? 2 things. What is third thing, sir? In this process I have forgotten. Compensation. That is covered under Minimum Wages Act only. Okay. Any accident or something like that. Not in order. I will say like this. You have calculated the gratuity liability. Okay, sir? In gratuity, if I am not wrong, we have to take number of years of service. If it is 6 months and that and that, upper side or lower side, right, sir? So, it is 10 years, 4 months, 29 days. He has written 10 and a half years. Now you tell me whether we take 11 years or 10 years. So as a chartered accountant, what we might have done? We have read, we will take, okay, 11 years, we will calculate. So that, as sir rightly mentioned, the owner will say, sir, he worked only for 10 years, for 5 months, 29 days only, why I should give him 11 years? But you will try to convince him. If he is committed towards his workman, he will say, okay, sir, half month, half year, no, nothing, not, because there is no increment, suppose. It is not going to have any impact. If there is some increment in between, then only it will have an impact. Right, sir? So, you have done that. So, if there is a shortfall in calculation of gratuity, right, sir? You are mentioning as a part of your audit report, calculated accurately. Now you tell me, sir, where we will stand for this wrong calculation. Workman compensation in working condition. Sir, sorry for interruption. Minimum wages, if he is not following, now it is also one of the compulsory code from 2023 onwards. Social Security is from 2020. Minimum wages 2023. We have to point out that and qualify the report. Right, sir? Sir, it is our headache. See, tomorrow what will happen? That labor department raided you and raised a huge demand. Right, sir? They will levy penalty also. Now you tell me whether that penalty will you be allowing under 37? Will you allow under 37? Violation of Act. And if you don't, then he will ask you immediately question, sir, why you have not told me on that day? I would have paid. Hope I could communicate something, sir. That is what, sir. Better you qualify to that extent, na. At least we can save our skin. I told you, na, in the scam word, unfortunately CA, between two words are CA, standing for CA. And they will feel that, see, I will tell you, sir, till last 10 years, 10 years up to last 10 years, if you go to a state sales tax department or somewhere, and if you say chartered accountant, even CTO or assistant commissioner used to think twice to talk to you. Now what is the position? That bloody clerk will call you. How? Come down. As if you are his assistant. It is not that they have become more knowledgeable. We are not doing our duty properly. I take that way, sir. You may feel wrong, but honestly, because our gurus told us, we used to fear for 1 rupee difference in the trial balance to go to search room. Literally shivering. That is how we were taught. So we are trying to still go under that way only. I hope I have answered, sir. This is only humble submission, sir. Then sir, I fully agree with you, sir. Again, with due respect, I am telling you, I will share this one more thing. It is a practical, everybody knows. 80 crore rupees of income tax refund fraud has taken place. Right? There, each and everybody claimed 80 GGC. Okay? For your information, I will tell that none other than our own co-professional who has done all these things and is absconding even today. And that is leaving the income tax department to laugh at our faces.
So over a period, we should develop some audits for stomach, some audits for stomach.
Sir, everything is for stomach only, sir. Because,
Said if I start qualifying now, then
sir, he won't go anywhere, sir. If he goes somewhere, he will find more problems. I am telling you. Of course, I may be younger than you. I am 58. I don't know what is your age. Okay.
sir, today, that if I leave an audit, I would beg to differ with you. There are people who will do it signing on the dotted line wherever he wants. There are people. You yourself now told me there is a chartered accountant who has taken out of the way action by claiming refund or absconding. So there are people who mortgage their soul and do it. And there are umpteen number of online platforms where people can get it done.
Yes, sir.
You can do a GST
Yeah.
registration sitting at your home for 300 rupees in Tamil Nadu.
Yes, sir.
Okay, so
Sir,
I
now,
think I agree with you, sir.
no.
We have to expand our scope of practice.
No, it is like this, sir. See, I was talking one of the contestants. Why don't you make all members accountable for mistakes what they are doing? He fear next time he may not get vote. Because I was in committee, I know. I never gave any party to anybody. I used to say only one thing, I will work. If you have confidence, give me vote. Not even by swearing, not even tea I have offered to anybody. 2 terms I worked. Third time I was in number 9. Fourth time I was in number 11. Thank you very much. I am doing my work. I am happy, sir. I am sharing this, sir. Before you take your meals, question ourselves whether we are eligible to take that meals honestly. That is what my parents told, my gurus told me. I do even today, I do my practice like that only. No problem, sir. You may not have Mercedes Benz, but you have Maruti car, that is enough. What do you want? If somebody scratches Mercedes Benz, you have to spend 1 lakh rupees. If somebody scratch this, you can go like that only. Another scratches, then we can get it repaired with an insurance. Right, sir? Of course, people may differ with me, but the practice what I follow is that. Okay, sir? And industrial hygiene, our earlier speaker also highlighted this. These are the working conditions code which is made applicable, sir. And this is main important thing is social security. We come across in day out of our practice. Workmen's Compensation Act, ESI, PF. This employment exchange, though there is a statute, I think nowadays many government earlier employment exchange meant both government and non-government and PSUs used to send the vacancy list to them, and they used to advertise, call for the applications, and then try to conduct some interviews or whatever it is, and then try to give the job. But now I don't feel that this employment exchange mechanism is in existence anymore, right sir? That is my personal experience. If somebody knows something, let me learn from them. Maternity Benefit Act. This we have to keep in mind, sir. Why? Because when we come across the salaries, suppose if an employee is on maternity leave, she need to be paid half salary for a period of 151 days. Post 1 month, subsequently nearly 3 months or 4 months or whatever it is. Right, sir? So, whether we need to recognize that an expenditure or not, we have to keep in mind. And now, let us question ourselves, did we ask any of our clients whether have you sanctioned any maternity leave to any of your female employee? There is a case law, interesting case law. Even male person was given maternity leave to attend his wife 2 months. Salary paid. Since they don't have any other nomenclature, they covered under this only. So this is one of the area where we normally don't throw our interest or throw our vision to look into. Let us learn from this session. Cine workers already I have discussed. Building and other construction workers welfare cess act. Sir, why I am bringing this to your notice? Nowadays PF authorities, just they are observing all gated community constructions, civil structures, whether for government, non-government or whatever it is, canal works. Right, sir? Sir, one submission I want to make here, and one case I also filed before this estate regarding the supply of solar panels along with batteries for a drip irrigation project. My contention it is agricultural related activity supplied under the scheme of central government and should not be charged to tax. Of course, department will take some other issue, that is different issue. Right, sir? Why I am discussing this? It is exempted there. So far as exempted of application of service tax, or if it is for a society, agricultural society, and you take ATP, that is different issue. What about labor law? That is not exempted. Application of labor laws on that activity is not applicable. And we are not given any immunity. For non-application of labor laws in those areas. Is it covered under unorganized sector or not? That is my topic. So these building people are given enquiry after 4 years or 5 years of completion of the project by the PF authorities. We are the auditors. It is a private limited company. Now you tell me, you will share the information or not? If you don't share, you will take from MCA. Right, sir? I told you, just I received a call that Monday I need to attend like that only. First they will call information, you submit information, they will understand what they know. They give you 7A inquiry letter. Once they give you 7A inquiry letter, then it is our funeral. I am using the word funeral because employer has to run pillar to post to satisfy that fellow. He will say, yes, piece worker covered under employee. Weekly worker covered under employee. You tell me where it is not covered. So as a chartered accountant, where he will stand? And these things he won't discuss with us. Because we said after 4 years back I signed balance sheet, completed a income tax assessment, completed GST assessment or whatever is everything gone. Now after all these things he will open the file. And we are for each and but for wife or husband, whatever it is relating to the businessman, we are everything for him. If anybody calls, I don't know sir, my auditor sir, he is having everything data. And we feel proud to have their digital signatures with us. We don't leave any page or any document without putting it. Because that fellow we don't know. We will tell something happened, we are here, why do you fear? That is a statement caption we make to the client. We are here, don't fear. We don't know that. We are in the clutches of that labor laws. And he don't even think a minute to say that, sir, I don't know anything, sir, my auditor has done everything. So, is it leaving any scope on our part to think from the angle of labor laws? To my fortune, I was dealing one case in 2007-8, even 2007-8 only. That regional provident fund commissioner happens to be a chartered accountant. He made 55 crores demand. I was sharing with her. Construction industry. From Bihar, you get the lorry full of laborers, dump them, you provide them for shelter, food, everything, and that poor fellows from morning 6 o'clock they start working till evening 6 o'clock, till light is there, they work. Okay? After that you give them some packet or peg or whatever it is, they will have it, sleep, and tomorrow morning same story. All this story over, after 5 years you receive that love letter from the PF department stating that you are the construction company carried on this venture, kindly provide us whether you have discharged the PF obligation or not. Immediately he will call us, sir, some notice has come. See, our fortune is like this, they find some notice with the word ending with tax. Let it be municipal tax, labor tax or what tax? You don't know. Sir, tax, you are my tax. Tax, you answer for this. That is our fate. If we get municipal tax also, we are only responsible. Rent he will enjoy. We have to run pillar to post. This is my practical example I am telling, sir. And when they do it, they don't see just they take the balance sheet, they take all expenditure. Whether that expenditure is pertaining to purchase, labor, or fixed asset, or expenditure, or interest, they don't know anything. They say other expenses, they don't take pains to go to the schedule also. Now what I am doing is that only. We make schedules as per schedule 3 in private limited company. Employee cost. Okay, sir? They will say salaries, contributions, everything we write. In the other expenses schedule we write office expenses. What is that office expenses? We know consciously. We know what will happen if something goes wrong. Notice has come, where we will stand. So these are the small areas where we feel we are no way concerned. But more than a wife, we serve the clients. Right, sir? Am I right in this statement? He will share what not with you. Whether it is affecting finance, not affecting finance, his personal life, everything. Okay? Because once they start developing intimation, they will share other things also. In this process, they say only one thing, sir, he knows everything of my life, sir. Kindly ask him. So this is the thing. So unknowingly, we are trapped into the clutches of this labor department also, or labor departments also rather, or labor laws also. So my humble submission to all of you, kindly spend some time on these laws, so that it is not in anybody's interest, sir. It is only our own interest. Because nobody will come to our rescue, even institute also will not come. Sorry to make this statement. First they will see whether you are guilty or not. That is the reason why I asked, anybody is doing peer review or not. If you are not getting your firm peer review covering under ABC category or whatever it is, for voluntarily you kindly cover yourself for PF, the peer review, sir, so that we will know what are the documentation lapses. Because the questionnaire is such a beautifully our institute has designed it, it will ask you everything. Whether you are maintaining documentation, not, if you are maintaining, what you are maintaining, what you are supposed to maintain, everything they teach us, then only they question. Kindly do that, sir. This Unorganized Workers Social Security Act 2008, I already discussed. This is enacted only after this IOL, that International Labour Organization, okay, identification of the African countries' problems and other things. Sir, all these things, all these acts are there prior to independence, after independence, during previous governments, but nobody has pointed out or concentrated on the effects of these things. They feel that they got vote, their wealth is doubled or tripled, whatever it is. They feel they are permanent here in this world. What not they do everything. But for all their sins, what they do, we are the people who will be questioned. Why you have not done your duty properly? If you see Article 12 of Constitution of India, we are also one of the authorities. Right, sir? Anybody differ with me? Are we an authority or not, sir? Because we got our certificate under the Act of Parliament. Even Constitution is younger than us. So these are the areas, sir, where we have to these are all 40 crores and others. Now I read you January 2025 data. Yesterday only I have taken this. So it is, I shared you all of you. This one more thing I have forgotten. The topic what was given to me, domestic and household workers. There are around 28.44 million, sir. This data I have missed to you, share with you. In domestic workforce, there is 28.44 millions as on January 25. For them there is no social security. So as a chartered accountants, we have scope, we have opportunity, right, sir? But more than scope and opportunity, it is our responsibility, accountability towards our signature what we put. So ignorance is not a what, sir? Excuse. Right, sir? Can we say only one simple thing, sir? Now what is happening? See, you know, GST data is shared to income tax data is shared to GST, stamp duty shared to income tax, stamp duty shared to GST, right, sir? This data is shared to PF. You don't have scope. Because if you see of late, for last 2-3 years, n number of service tax notices have come, irrespective of SSC, where gross receipts shown more than 10 lakhs. Gross receipts shown more than 10 lakhs. All the people, around 90% of the people, they got the service tax notices. I myself have attended nearly 18 cases in that. Fortunately, are all doctors, that is different issue. And one small contractors, they are not, their work is not covered under the definition of service. Now GST is behind us. GST is not an act as such. It is only notifications. Out of this 7 years, I think more than 1000 notifications have come. One they say rate notification, one they say normal notification, one they say clarificatory notification, explanatory notification, includes exclusively what not. And there is one more, notification number 29/2018. Right, sir? This notification is talking about supply of security services by A. non-corporate SSC, non-corporate registered person, non-corporate person, or sorry, supply of security services to a registered person by a non-corporate entity. Right, sir? There you need to pay GST on reverse charge mechanism. Earlier, that was applicable even to LLP also, but there is a advanced ruling by Haryana bench, so they have, after that opinion, they have eliminated that. Right, sir? Now, you are filing your 3B. Anyhow, one, you don't disclose RCM, right? There you paid, claimed. That is so far as GST is concerned. Now you tell me, what about Social Security? Whether we have liability or not, and whether we have Minimum Wages Act or not, whether there is Maternity Act or not, because nowadays you will find lady security personnel also, whether there is safety working conditions or not. Do you feel we have unknown, attached, knowing liability or not? This is the scenario. Specifically, why I have taken this GST notification, we are happy that under RCM it is coming, okay, well and good, but never we applied our mind towards the labor laws, and never we have educated our client. Arey Baba, they have to give you PF paid challan copy, otherwise you remit yourself into their account. Nowadays PF authorities also, they are having Aadhaar link, PAN link, and they also give one establishment number and followed by the employee number. Right, sir? Those things they are attaching to the bank account where you are getting your salary. And you have to see whether all the 12 months contributions are paid or not. If not paid, are you disallowing under what, sir? In the Income Tax Act, tax audit, where you need to disallow this. If contribution is not paid to the PF authorities, do we have any responsibility for disallowance of that? Under which clause, sir? 43B. Now I will take you to 3615A. Will it be treated as employee's contribution as income or not? One way, expenditure disallowed. Other way, income added. This is only the simple responsibility we as chartered accountants are having on our head. So far as Social Security Code 2020 is concerned. Now, I don't know, in Telangana and Andhra Pradesh, we have profession tax. Right, sir? We have profession tax. We need to pay around 2,500 rupees as a practicing chartered accountant per head. Their limit is up to 15,000 rupees, no. 15 to 20,000 rupees, 100 rupees. And about 20,000 rupees, 200 rupees per month we need to contribute. That is 16 class 3. section income tax are tax on employment. Okay. Now, as a practicing chartered accountant, I am paying my contribution towards profession tax. Right, sir? That I claim as a deduction here in my P&L account or income and expenditure account. And I am paying salaries also. Whether I am discharging my liability towards my employees to whom I am paying 20,000 rupees. I have my GST registration. So GST registration automatically gives me profession tax registration. The profession tax registration automatically cast liability on me to pay profession tax. In my own case I am paying, whereas in my employee's case I am not paying. So is it a unorganized sector or not? So far as applicability of Profession Tax Act is concerned, though it is a state related subject, it is a part of Social Security Act. So as a chartered accountant, do I have any responsibility or not? In my own case itself I have responsibility, then what about our clients?
They have already started getting data from GST. This profession tax, they are now pulling data from GST and sending notices.
Yes, sir.
Services for services.
That is the reason why I raised that issue. So that now I see the scope. Rather than scope, we have to feel our accountability and responsibility. Right, sir? Violation of that. If you are debiting to your P&L account, suppose in next year, will it be allowed as an expenditure? And closing our eyes, we say, allowed. Tomorrow, if somebody catch hold of it, then where we will stand? Again, only one story. Sir, I don't know anything. Our auditor said, we have followed. We are in very peculiar position, sir. We are very peculiar position. But fortunately or unfortunately, our co-professionals are not realizing that if somebody is not doing that activity, why I am doing? As sir was rightly said, 300 rupees registrations they are doing. When they do registration, they give their own mobile number and email address. Likewise, in Pune, one person was held, one tax consultant. Because he has used his mobile number and email address, and they have served n number of notices. This fellow was kept behind the bars. Being a tax consultant. What, madam? Madam, see, that is the reason why, of course, people may not agree with my statement. We are blessed to be a chartered accountant, but at the same time, we are most worst cursed people by everybody if something goes wrong. So, people just like that they are doing, sir. And I don't know whether all of you agree with me or not. CA, earlier they used to say commission agents. Sorry to make this statement. If anybody differs with me, let us have a debate, no problem. And if you see emblem when they have given first time with a red thing, CA, most trusted word or letter or something like that it has come. Yes, we are trusted, sir. But unfortunately, while society is trusting us, we are not doing our duties to the level at which we are supposed to discharge our duties. So I think as a part of that, this labor laws is no exception to us. Do you feel it is an exception? Intention is not to threaten you or anything, because all of you are well experienced and learned people sitting in front of me. I am a very small person. But fortunately or unfortunately, I have travelled to those things. I was sharing that Narayanappa. I found one entry, they levied PF on purchase of generator. I asked him, sir, on generator purchase also I need to pay PF. Immediately shocked, what is that you are talking? Yes sir, your people said, you see the statement which is signed by them. 55 crores, it has come down to 16 crores. I said, my liability is 72 lakhs, sir. That I have calculated. Ultimately, passed for 16 crores. People went to tribunal. There they remitted 75 lakhs along with interest and others. Case got closed. I am sharing this, sir. This happened in 2008, relating to the accounts of 2003 to 2005. Now you tell me, if there is a change in the accountant, whether this owner knows what are the entries they passed, but they expect you to know, being a chartered accountant. If you are maintaining your working papers well and good, there is no problem. Otherwise, and after 4 years, he will find our brother is a very good person than us. Sir, he knows everything, sir. From next time onwards, he will manage. As you said, you will not have tax audit next time. For all these years, whatever you have served him, gone to dogs. So these are the labor laws affecting our profession, practice, opportunities, responsibilities and our accountabilities so far as unorganized sector is concerned. Thank you very much for your patience hearing.
So on behalf of all the members present here, we thank CA Ramamurthy Tejomurtula sir for his all the information he has provided on labor laws. Thank you so much. We shall all be careful. We shall let go of all the bad audits, do good audits. Thank you so much.